Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right. I'm just a wee bit late. I do apologize. I'm trying to set up everything again. I went and tore down my studio so I could go do something last night, film a little local event, and nothing's working properly again. So that happened. Let's see. Give me just a second here. Put that here. All right, I think I'm mostly there. Just 1 second. Here we go. All right, here's a problem. Ready? Here's a little problem. My courthouse disappeared. My courtroom. I'm sitting in the dark. This morning, which is a terrible way to start the day. Not knowing what's going on around me, but hey, that's happening. That's not it. Let's go here. Okay, we got audio there. Reset. That's not it.
Scratch all that. Oh, that was terrible. I apologize.
This is going to be rough, but I think I know what the problem is. You guys ready for this?
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Yeah, it feels like a Monday is the problem. Welcome to Wednesday, but oh my goodness, we're gonna get going here. We're gonna get started. I hope there aren't too many birthdays today. Not that I don't want you to celebrate your birthday. If it's your birthday, we want to celebrate it. But if we have to sing like several verses, I'm in trouble. I'm gonna have to sing fast. Oh, good stuff. Okay, so we've got video there. I have to find my courtroom wherever that went. It'll show up. It can't go very far. This week has been all Mondays, says Lynn. Yes. Bad news for one person. M. Young. I think this is the second time, if I remember right, or this might be your first. Is this the second time you've won the internet? First in chat. That's a major accomplishment. So congratulations and good luck, because today is starting off poorly. It's starting off poorly is all I can say. It's really rough. Let's see. I need my iPad working, which it's currently not doing. All right, there we go. Okay, we'll get there. We're gonna get there. M. Young, congratulations. First in chat comes with its prize, punishment, or otherwise, depending on how you view it. Am I just waking up? Yes, I am. No, I'm not just waking up. I got up at like 5:30. But actually getting up, that's another matter. Let's see. Chat is not showing up on the screen. That's because I can't get my computer working. It's going to get there shortly. Just 1 second. Connecting. It says it's connecting. Then it doesn't. Which means it's on the wrong Wi-Fi. Nope, it's on the right Wi-Fi. Man, why is it being so... There it is. Here we go. Now chat can show up on screen. And that means I have to recognize once again M. Young. Congratulations, M. Young, for being first in chat. That awards you with internet ownership, and you have to fix all the stuff that's not working currently. So if you could find my courthouse and put it behind me, that would be great. I would appreciate that, M. Young. I'd look forward to your wise oversight of everything IP related. Ariel gifted a membership first thing this morning. Thank you very much, Ariel, for that. That's super kind. And one person in particular, Carol Cottle, especially appreciative of your gift because she received it. Thank you very much, Ariel, for that. All right. Paula says, I'm on vacation. Woke up just in time to catch the live stream. Perfect. Where are you on vacation, Paula? And why didn't we get invited? That's what I want to know. M. Young says, I think it's user error. Oh, no, that puts it back on me. I'll wiggle all the cables and see if I can get this resolved. But you're probably right. It is user error. Let's see. Last Poet. It's your birthday. Do we have any other birthdays other than Last Poet today? Maybe if we could get a buffer, because I've missed a lot. It's the Hump Day Hustle. Here we go. So Last Poet. Any other birthdays? Not seeing any others. Oh, the Creative Bee. There we go. I found it first. You heard it. I said it first. Creative Bee and Les Poet. So Debbie and Les Poet both have birthdays today. Okay, I think, can we sing right now? Because it's almost time. Any more? I'm not hearing anything. If I don't hear anything, then we just start. Okay, here we go. La 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 la. Everybody. Happy birthday to you. Happy birthday to you. Happy birthday, Last Poet and Debbie. Creative Bee. Happy birthday to you. Creative Bee and Last Poet, OGs on the channel. You may not know this, but Creative Bee, she made me this. My current one is hanging on the courtroom wall, which is missing. So I'm looking for that one right now. Happy birthday to both of you. It wouldn't be the same without you here. So good to have both of you. I know there are a million places you could celebrate, including Denny's, which will give you free pancakes, I think, on your birthday, which I'm not saying you shouldn't do, but I'm glad you're here today. And it's our privilege and honor to be able to celebrate this day with you. Hope it is a fantastic one. It should be great. And we're getting ready to go into the courtroom right now. As a matter of fact, the court is ready for us, which is good. I just need my courtroom so I don't look out of place. All right. Hope Jules calls in today. I think she's going to call in at lunch. Jules has been in the courtroom every day of this trial, and she says she's been keeping copious notes, which is wonderful. So she has notes on all the jurors and everything that's been going on. So she's going to try to connect with us right as they break for lunch. That's our plan. So we can get. So if you have questions specifically involving maybe the counsel, maybe something we can't see, and the jurors specifically, the judge, anything that would have happened off camera or something like that, that would be appropriate to bring those at that time. I will say that she mentioned that she has made a connection with the family, but out of respect for the family, we're not going to push for information in that area. Obviously, it's very sensitive, and we appreciate her doing that and getting the information that is available. So we'll try to focus on the jurors in that today. Patches says, woohoo, good times. RA, you rock. Thank you very much, Patches. 5 months for you there. That is wonderful. Thank you. Let's see. I know. Here's what I need to do. I need a cord. I need to dive over my desk is what I need to do. Hang on. Okay, I'm pretty sure that my courtroom is right here. So what I'm going to do is I'm going to unplug this. Still there? Everything working? Okay, so that cord wasn't needed. That's good. Now we're going to plug in that. Now I'm going to do a couple little things here. I will tell you, YouTube keeps reminding me that the day is coming when they are going to choose exactly how much advertising everybody gets. And I'm not excited for that because our particular format of videos is probably going to be hit the hardest. And I don't know what to do, but it will go to the point where they say, we've decided that it's in your best interest as a content creator if we choose how many ads go on your channel and what type they are and when. It probably is in my best financial interest that they do that because they want to show a lot of ads, but it's not in the viewer's interest. And apparently there's no way I can get around this right now. So I'm frustrated. I've expressed my frustration to them, and they seem to be doing nothing about it other than saying, trust me, you'll like it. It'll be good for your bottom line. Like, no, it won't be good for everybody. We want it to be good for everybody. Okay, so let's see. Courtroom, switcher, media. Oh, the courtroom is gone. The courtroom was supposed to be on that plug and it was not there. Let's look. RA background. I need to name my file something that doesn't have a B in it because I can't type B. Okay. I'm looking. Desktop. Yep. There's my intro. I can't put my intro in my background, so that would not work very well. Must be in downloads. Okay, we're going to get there, guys. Don't mind me. Just talk amongst yourselves for just a minute while I try to find my courthouse. Now I know how you guys feel when you say I'm in gray now. I'm missing my courthouse. I am missing my courthouse as well. It's quite
Please
distressing.
be seated, everyone.
Oh, now the judge is here. This is embarrassing. He sees me like this. Your Honor, just don't look over this way for just a minute. I'm going to find it.
Computer going?
No, don't. PASSWORD. 1, 2, 3. Enter. There we go. I found it. Don't let the judge look up yet. Here we go. Boom. Okay. Your Honor, I'm here. I'm here now. We can start.
Case number 2018 CA 5321 Kowalski versus Johns Hopkins Children's Hospital. Let's go ahead and take appearances, starting with the plaintiffs, please.
I use an actual green screen. It's a green sheet.
With me on behalf of the plaintiffs.
Ethan Shapiro, Howard Hunter, Pat Crowles, David Hughes. Our corporate representative is Dr. Michelle Smith on behalf of All Children's Hospital.
But not that Dr. Smith.
Thank you very much. I have been handed another exhibit list. Is it okay to admit those that have the yes by them?
I would like that very much, Judge. And I will go through it.
Any objection from the defense?
No, Your Honor.
Okay, Madam Clerk, the court will receive without objection Exhibit 2123, page 10 only. Exhibit 2123, pages 833 through 837 inclusive. The entirety of Exhibit 2512. And I think that are all of the stipulated agreements.
That's all they agreed to? On 4 pages? That's all they agreed to?
All right, Judge. We have for the first witness under 2149, it's on the first page, about 5 down, Johns Hopkins organizational chart be used with one of our witnesses, Joe Cochran, our management expert.
Okay, this is the 2012 version?
Yes, and this is the last one that they gave us as available. So we have asked in deposition if there are any more after this.
2012 or 2021? Because this says 2012.
2012.
Judge, I'm sorry, I missed
Was this back when it was All Children's, or is it now Johns Hopkins All Children's?
It's now Johns Hopkins All Children's, and it still reflects, I believe, the same organization. Now,
why do we need 2012? Why don't we just start with 2015?
I would like that. I think that would be better. Thank you for pointing that out. I understood that there's a organization, there's a committee roster.
I'm sorry, I apologize. Those look like committee rosters. I was looking at it. So 2012, that's the most recent, is that what
that
you
was
have?
what was represented in deposition by multiple Johns Hopkins people.
I'm sorry, what was the date on that?
2012.
It's the organizational chart.
The organizational chart has been updated since then, and the committee rosters we provided, I believe, were 2016, 17, 18, and 19, but Judge, I failed to see the relevance of any of those.
I have no problem with the committee roster, so Court will receive 2142, 2141, 2142,
Mr. Hunter's
2143, 2144. Now, is there a organizational chart that is closer to 2015 than the 2012?
I would love to see one from the defense. It was a point of contention through the depositions of the higher-ups in the company, Perno, Napolitano, Crane, and there's one other.
Look at the judge.
Judge, I believe there
Glaring.
is. We just got this at midnight last night, so I have to say I have not had a chance to look for it. But
Apparently you had
I do believe there is a
a chance on all those depositions.
That's the 2012. Is there any problem, though, with the 2012?
Only to the extent, Judge, that I don't believe it's been authenticated as being the one that was in effect at the time. Of course, on the other hand, I don't believe that the witness was provided this organizational chart as part of his repertoire.
What, 5-6 years into this litigation, and we don't have the organizational chart from 2015? I mean, I don't see how that's a state secret by any imagining.
No one's taking
Judge is not buying this.
If 2012 is the most recent one that we have, then that's the one we're going to go with. Is if someone can tell me if there's a near to 2015, let's go with that one.
And I'm not opposed, for the record, to substituting out, if we do go, or admitting it again,
time. We need
the
objections.
2015. If counsel will produce it, like I said, it's been part of Dukas Tecum requests for a long, long time.
Judge, there have been something like 50,000 pages of documents exchanged in this case. I do not have them committed to memory.
And that's fine.
But I do not believe this is the most recent that was produced. I know that there was a series of them produced at some point, and I can't tell, Your Honor, exactly when that was. I can tell you that there were others produced, and I just don't.
I don't see any harm in admitting 2012, and if we find a more recent one, that's fine. I just don't see how that harms anything.
Very well, Your Honor. If I could, we understood that Dr. Hanna was going to be the first witness this morning. Am I now hearing that Dr. Cochran is?
No, we're not. No, we're not putting on Dr. Cochran first. We got, and I should have emailed you, but the decision wasn't made till 11:30 last night. We're not going to call Dr. Hanna. You have to worry about that. But it's not going to change things because we're still calling Dr. Cochran, but we're not calling him until the remainder of the people that we talked about are taken care of.
So after they spent all evening preparing for a live witness that you told them that was going to be first up, at 11:30 you make the decision and then you don't even bother to tell them?
Judge,
I mean, how is that?
Midnight, it would have been midnight by the time I told them. I did not believe it would be any good. And
Judge, they sent us other things at midnight. They sent us, frankly, this exhibit list at midnight. So, and we get up early and work in the morning for the day's preparation. So that excuse is unacceptable.
The exhibit list was sent yesterday. It was pared down.
Right, I know, agreed. I'm just saying we were working at midnight, as were you.
And we had prepared for him as well. But we made a decision based on speaking with Dr. Hanna and in preparation as part of trial tactics that we think that the jury has heard quite enough about ketamine and about CRPS, and calling yet another doctor.
What time did you make the decision not to call him?
11:30, 10:30, 11:30, because we could not get in touch with him. I actually made the decision earlier, but I could not get in touch with him. And in fact, his office administrator was in touch with me, telling me that he was set to go, and I was sure, and we committed it and decided that we don't have the time to put on another 2-hour witness on ketamine and CRPS. And we're down to the nitty gritty here, Judge. We just have to make some tough decisions. And I'm sorry if counsel had prepped on it. They are getting paid to do this stuff, and I've got
that has nothing to do with it.
Whoa.
The whole point of telling the other side at lunchtime who's going to be the next day is so they can prepare.
Ooh.
Do you know how wrong that what you just said is? You said you'd even determined it earlier but hadn't talked to Hannah about it. You didn't even bother to tell them. What's wrong with that?
Judge, it was so late, it wouldn't have made any difference in our view.
Sound
Why
bites.
call them and
I'm going to take a break.
11:30.
I'm going to take a break. I want the two of you to talk about what people are coming. There's got to be a different way of than deciding at 11:30 at night, 10:30 at night, 9:30 at night, not telling the other side. That is just wrong. Cannot happen again. I am so tired of how you're not telling the other side information. It's just wrong. We're going to take a break.
All rise for the recess.
Well, that happened. Got a few sound bites out of that. That was basically a "what is wrong with you" from the judge. He said they get paid to do that. The judge is mad. This may come back to bite him. I don't know if this can be something that could result in a sanction against the plaintiff or not. But you've got to think that the defense here is winning points with the judge, and when there are decisions coming up that he might be on the fence with, he might start leaning more towards the defense, saying, "Hey, because of what you had to put up with this one, it's a gray area. I'm going to lean your direction." So I'm going to count that as an objection from the judge. Is that okay? Oh, the judge is fuming. If he comes back and his robe is like ripped because he's had a Hulk moment, I would not be surprised. Whoa. I've never seen. I've seen the judge admonish counsel because they're playing these games, but this far into the trial, this same thing keeps happening over and over and over, and the judge needs a cool off moment. Yeah, Dr. Hannah, they just decided last night. Okay, if he had said 11:30, it was 11:30 at night. We just barely made the decision, and then he's like, "Oh, it was like a little earlier than that. It might have been 11." Well, it was 10:30. We actually decided earlier than that. I'd made the call, but I couldn't get a hold of the doctor. So the earlier it got, the worse the situation was. He's like, "Actually, I decided yesterday afternoon not to call the doctor, and I still didn't call the defense." It feels like he smacked my legs. Attorney in the doghouse. Yes. He's in big trouble. The judge screaming into the pillow. It's a good thing the audio's off. I cannot wait to hear from Jules on this one because Jules is in the courtroom and observing the body language between these two sides as they're supposed to be sorting things out. But really, the defense has every right to just be completely just floored and say, "Your Honor, anytime any evidence they want to bring in, anything, we are not prepared to argue this, and we should not allow it in because we did not get enough notice." Baby Bear, unfortunately, yes, the ultimate family who pays the price on this one are the Kalowskis, because this could affect the outcome of the trial in some way. Now the jury doesn't know about this, thankfully. But still, the judge may put some restrictions in here, some sanctions. What is wrong with you? The judge is right, though. Anderson has sent plenty at or after midnight. Right. If he had decided at 3 o'clock in the morning, he should have sent them right then. And they would have complained. They said, "We just got this at 3 o'clock in the morning." And he's like, "Yeah, but that's as soon as I made the decision." And like, yeah, it sucks. It's cheap. It's dirty ball. That's what it is. It's not a. I'm not sure if that's a saying, but don't quote me on that one. Anyway, it's frustrating. Wasn't Dr. Hannah one of the most important doctors? They seem to hold her out, or is it her? I think it's her or him. Dr. Hannah out as one of the more important witnesses, and it would require a lot of preparation on the defense side. Okay, so he literally had them spin their wheels doing something that he knew they were not going to use, which would mean they would be less prepared for other areas that they are going to use. Yes, lots of cursey words from the judge's chambers through the door. this is. I'm not sure. I don't know if this would be mistrial territory. I wouldn't be surprised if they call for one. But I think we're going to see the defense trying to get as much mileage from this situation as they possibly can. Okay, they're gonna go and get as much as they can in this situation. Let's see, are we having weird camera flashes? I think we are. They're flashing all over the place. Okay, we're back. We're back to normal. Okay, so let's just in chat here. What soundbite from the judge's tirade do we need to add to our repertoire? I wish I could see that cool mountain range. I think that looked like Arizona or southern Utah, maybe Colorado. Can we see that again, Mr. Cameron? If you could put that there we go. That's the one. Thank you. Yeah, that's I don't know. Could be Nevada as well. Do you guys know that location? Let's see. Run it back. No. Judge is coming back. Here we go.
2159.
And what's the objection to the corporate bylaws?
Relevance, Your Honor.
Overruled. Court will receive 2159.
If I can backtrack, we did find the 2016.
And what exhibit number is that?
7 years they've been fighting to release this. And in 5 minutes, they found the paperwork that they were looking for.
JHACH 19,511.
Is it a identified exhibit, trial exhibit number?
I don't see one on this copy I've been handed, Your Honor.
I cannot wait to hear Rob's take on this.
Okay, in my Zoom feed, I have a person, I assume is a witness, Regina Chmiel.
This is Beata's sister, Your Honor, first witness for us.
Okay, Miss, is she the one that needs an interpreter?
Yes.
Yes, she is.
Do I have the interpreter here?
Yes, Your Honor. He's
Because I need to tell the witness, I'm going to put the witness into the waiting room. So can someone come down and tell this witness what I'm doing so the witness understands?
Yes, Your Honor.
Okay. Can we go? Can you just translate this? Good morning, Ms. Chmiel. This is Judge Carroll.
Dzień dobry, pani Chmiel. Tu jest sędzia Karol.
Dzień dobry, witam wszystkich zgromadzonych.
Good morning to everyone.
Ma'am, I understand you're going to be a witness this morning.
Rozumiem, że będzie pani świadkiem dzisiaj rano.
Tak, będę świadkiem.
Yes, I will be a witness.
And there's going to be some things I need to do outside of your presence, so I'm going to put you in the waiting room for a little bit, okay?
Są rzeczy, procedury, które muszę wykonać poza pani obecnością, więc umieszczę panią w poczekalni elektronicznej, dopóki pani nie przywołamy.
Dobrze.
Yes, I understand.
Okay, don't go anywhere. I'll call you back in a few minutes, but you're not going to be able to see what's going on.
Proszę nigdzie nie odchodzić od miejsca, w którym pani jest. Za kilka minut sędzia panią wezwie.
Dobrze.
Yes.
Okay, I've removed that witness and put that witness into the waiting room. Thank you, Mr. Interpreter. Okay, what's so the 2016
Polish, so we were
bylaws, or sorry, 2006 org chart isn't identified as a trial exhibit?
And now this is the only one we had. We can substitute it.
This was produced to plaintiffs 12/23/20 and 4/28/01.
Well, it's on our list, but it's on this.
That's it.
We just want to make sure it has the same people.
Well, the other organization chart doesn't have the people, it's just got the organization and titles.
Just make sure it's the same.
Defense has to be careful here, because if they show that they're playing any games here as well, the judge's anger could flip on them. He's having a bad day, and you just don't want to take him off in any regard.
We're fine substituting this, Your Honor.
Okay, well, why don't we just put it as the next number in the series? Hand it to the clerk, and I tell us what number in the series it is, Madam Clerk.
It's 2802.
So the court receives 28/2.
This one has a little bit highlighted on it. think it matters. Does it matter to you that there's two things highlighted on there?
Cleo, if you can
What's next?
let us know if the translation is off.
Then we have
that would be
the
great.
Johns Hopkins medical record access log for October 8th, 2016. This has to do with the Kathy Beatty and the access to Maya's medical records without authorization from the parents.
Is this only access to Maya Kowalski's file, so I don't have to worry about any other patients' HIPAA issues?
Correct.
Okay, let's go ahead and put it up, please, so I can look at it.
The access log in question, Judge, this has come up before, and we had the issue before was authentication and explanation. The purpose that I understand is being offered for is to demonstrate that Sally Smith accessed the medical record on or about October 8th, 2016, to which we are prepared to stipulate. This thing, if you, as you'll see when it's up in front of you, has got 9 or 10 different columns with 9 or 10 different explanations. It's not susceptible of ready interpretation without someone who knows what it says. And so we object to their just putting it in without authentication or without explanation or context of what the various columns and information tranches mean. But once again, we're prepared to stipulate that Sally Smith did in fact, pursuant to her status as a staff physician and CPI investigator, access the chart. They don't need to put this in. That's agreed to.
The paperwork they found was the
We would
2016
prefer to
organizational
have
chart.
a written document in evidence in case there is a dispute either on appeal or otherwise as to the scope of any stipulation and any issues that could come up during the defendant's case or rebuttal countering this. So with all due respect to counsel, we prefer to have this actually in, and we do have the codes, and they're not particularly difficult to ascertain. And on behalf of Maya Kowalski, we waive any confidentiality for these purposes.
Well, there's no authentication issue. I mean, I think the parties have agreed that this is the access log.
It is the access log, Judge. The question is what the various columns mean, and what I'm concerned about is some element of surprise and quote interpretation of these things without context and without reality and challenging.
You can call a witness to explain the meaning of this, but the reality is they are contending that Dr. Smith is the apparent agent of the hospital, and this directly is evidence of their contention. So, or potentially, arguably. Well, you can make all the faces you want,
Well,
Mr. Hunter.
I understand, Your Honor, but there's no authentication.
Faces, okay?
I'm sorry.
Not today.
Not today.
There is no
Not today, Mr.
indication
Hunter. Not today.
that there was any connection between her accessing this chart and her status as an apparent agent.
You can argue that to the
Okay.
jury. They don't have to take your stipulation. I mean, they don't have to take the stipulation. They didn't take it, so the court will receive 2165A as an alpha
So that was an interesting move. I've never
071
seen that
page
before.
one.
Defense
What's next?
stipulated
2249
to a fact,
VAX policy, HIPAA policies for
and
providers,
instead
authorizations.
the plaintiff didn't accept.
They had raised an objection. I'll let them do it, but it's relevant and material for the same reason as the item before, the exhibit before, in order to interpret 2165A-071, 2249 with the codes and the HIPAA policies would be necessary.
Well, there is no cause of action for HIPAA violation in this complaint.
That was my concern, Judge. I'm not sure why they're putting in and why that's relevant to the other. I mean, it's all about HIPAA. So,
And Your Honor, to the extent there's going to be an argument that there was a HIPAA violation by accessing the chart on 10/8/16, we have a pending motion in limine about that. Plaintiffs never filed a supplemental brief this court requested, and I think we're at some point today before Dr. Cochran prepared to argue how this is absolutely not a HIPAA violation under Florida statutes or the Code of Federal Regulations, and even if it was, there's a Florida statute that says we're not even supposed to be talking about that in malpractice court.
Well, again, there's no cause of action for a HIPAA violation, so.
Mine's only for the codes, Judge. If we compare it down to just having the codes, I want to make sure.
What do you mean by the codes?
Well,
I'm looking at the policy. What are you talking about?
it was my understanding that within this document, it set forth the rules and regulations and how to code it. But if it doesn't, then for now, we can withdraw it. We need to move on anyway, Judge. So we'll withdraw for now. And then we'll come back to it.
What's the next one?
2056 is at the top of the list. I think that was skipped. Can you put that up for us? This reflects one of Sally Smith's various roles within the hospital this time. As part of the residency program at Johns Hopkins, goes to our current agency discussion.
Judge, no objection except for the highlighting.
Well, okay. This is not our highlighting. This is how it was discovered.
I said objection. You said no. Okay, I'm sorry. Excuse me, Your Honor. We do object to the relevance.
We object to the highlighting. That's our highlighting. We object to the relevance.
Is this like a published list?
Yes.
Yeah, no.
Okay.
The court's going to
It's
overrule
coming
the
in.
relevance. I will receive 2056. And you don't have a version that doesn't have the highlighting on it?
No, Your Honor, that's how it was. We can try to remove it if it's necessary.
Well, Judge, highlighting can be removed pretty easily anymore on PDFs.
Well, again, it's what the clerk has. The clerk probably has it highlighted.
Substituted in, then perhaps.
I'm so excited about today.
Everyone.
We prefer not to do extra. Well, we'll do what the court requires, or if they require that highlight be removed, we'll work on that.
That one, I mean, out of all the things to worry about in this case, I don't think this is
I appreciate that, Judge. All right.
Your Honor,
this is the art of the possible.
Yes.
In the interest of time, we'd like to, and I think we're going to have a lunch discussion, we'd like to move down to the second to last page of the list, Exhibit 2277, which begins with the risk management file. And within that, I'd like to move, I guess I'm on the last page now, page 628 and 629.
I'm sorry, what? Because this list isn't in chronological order, so let me just find it.
Well, it's so 2277, and within 2277 there are several hundred pages. So if you go to the last entry, 628, 629.
Neither side is getting charged for this time. This is court time.
Email at Johns Hopkins regarding Maya's care and treatment.
Judge, it's an internal email that refers to Attorney Hunter that talks about the dependency action.
Is this the one that I already ruled on, or is this a different email?
This is a different one.
It's the same issue, Judge. This is all talking about testimony at the dependency hearing. And then refers to, in the second paragraph, Attorney. Okay. Refers in the second paragraph to Attorney Hunter.
Stop talking.
Okay, well, let's go. In my mind, the first thing is, can I see the two in the front again? Are any of these individuals? Jackie Crane's, is she the, remind me, she's the nurse or
she's the general counsel?
General counsel.
I haven't seen Jules in the court yet. I'm not sure if it just hasn't showed the angle where she's at. She's typically sitting behind the plaintiff bench.
So, the first issue is
just behind the family.
Attorney-client privilege, but then there was the issue of inadvertent disclosure. But was this document included in the inadvertent disclosure?
No.
Okay. So effectively, we've got a waiver of attorney-client privilege here at this point. Is that where I'm at?
There's not
oatmeal.
There's not an express attorney-client communication here, other than what I was allegedly advised of. The the real objection here, Judge, is going to be with the DCF matter, because this is replete with that entire matter.
Okay. So in my mind, I've moved on beyond attorney-client privilege. Now I'm going to go to the relevance. Can you make it the text larger, please? Mr. Ayden, thank you.
M. Young, we've got an internet question for you here, if you can hurry and resolve that for Tracy. Actually depends on your router, Tracy. Most routers auto-select the least busy signal. You might have to upgrade your router if your current router doesn't have that option. Good morning, JB. All the way up there in the frozen tundra. Good to have you here. Beach lover. It's been a lot longer.
There's going to have to be a couple of redactions in this email.
Understood.
But the balance of it is going to come in. What date is this again? December 30th. And where were we on the dependency court orders with respect to visitation?
I believe the most recent order before this email was a December 27th order. And
well, there's a reference in here about exercising the right to supervise. Was that permitted under that?
Under that order was the first time, it's my recollection, that the hospital was granted express permission to supervise those calls.
In the order, Judge, as opposed to DCF asking them to do it, but they are expressly allowed to supervise.
Defense contends that they did get asked by DCFS to do it, even though it wasn't ordered.
I think the sentence that starts, Maya was not allowed to listen in, that sentence has to come out.
All right.
The following sentence, the judge didn't let Maya listen in.
Yes.
Needs to come out.
Keep me on my toes when it comes to the objections. If I miss them, let me know what the numbers should be, and I'll keep it updated. M. Young, this is solid tech advice.
Is there any?
This is what I expect from someone who manages the internet.
Is this sentence correct
Good job.
that mom's mother is allowed unsupervised FaceTime at 11 a.m. and 5 p.m.?
Judge, I'd have to look at the order specifically. I think they mean Maya's mother.
It's Beata.
Yeah.
It's a paragraph 2 of the order. Mother shall have and ACH shall permit visit by any electronic device, i.e. iPhone, Skype, FaceTime, or similar method at approximately 11 a.m. and 5 p.m. daily. Such communication may be supervised by a guardian ad litem, the child's case manager, or any member of the hospital staff, but does not have to be. I can read the balance if the court wants. There's a few other points.
Tilted TR, I'm sorry to hear that about employment. Any particular field you're interested in? We might be able to network for you.
Where it says mom's mother through the balance of that paragraph.
So the rest of that paragraph, Your Honor, comes out?
Yes, and then the following paragraph, let's redact, but leave in, I did advise Dr. Majors to get pictures of the scratches.
Okay.
And
sorry, Judge. The second sentence.
The sentence, the third sentence of that paragraph where it says Howard also agreed, that sentence needs to come out.
Understood.
But the talking about getting pictures of the scratches and an inquiry to how Maya got them needs to stay in.
Your Honor, in the paragraph above that begins, I just got off the phone with the case manager. The second sentence reads, everyone is over this case. Or can we keep that?
Yeah, Judge, that's referring to the DCF case. I don't.
It's referring to
and
it,
it's
but
out of perspective if the rest of it's removed.
I agree. That sentence without the context of the sentence before or after could be misleading.
Understood.
So, okay, are we clear on what needs to be redacted?
Yeah, we'll put it best then.
Okay, so we'll need to get to the clerk a printed copy of it. So ultimately, I will be admitting, and we'll call it A on that one.
I will also need the
So 628-629A.
I like the plaintiff's attorney that's talking now a lot more. I wish he would have handled more of this case.
I'm only looking at
sure
one
the
page.
judge
So
wishes
where's
the
the
same
second
thing.
page?
The second page is just a continuation. It's nothing more than I think a logo.
I think he's more of
Can you
a.
see the second page?
He's better able to read the room in his delivery style.
No, we're going to leave in the logo. So
Logo stays
in. Ultimately, it'll be received as 2277-628A and 629A. But it'll be redacted. Okay. Is there anything that we have to do before we bring in the jury?
I think we can win.
Your Honor, I did, as a threshold matter for the witness that's coming, I did want to.
Who's coming?
The next witness that's coming.
Tell me who the next witness is.
Regina.
Oh, that's right.
Regina,
That's right. Okay.
yeah, Regina. There is a tremendous amount of hearsay. I anticipate being on my feet quite a bit. Almost everything that this witness knows during the hospitalization came through hearsay conversations from essentially Beata Kowalski.
I'm getting my objection finger warmed up.
I don't know exactly what she's being proffered for, but her universe of knowledge in terms of personal non-hearsay interaction is essentially nil. I don't know where we're going with this. Just like some clarification from the opposing counsel.
I don't think this is going to intrude on what Beata told her about the hospitalization. I think that's the purpose of the testimony.
The only thing I can think of is how did you learn about Beata's death, which is not exactly, it's just a name, date, and would be an exception to hearsay, I believe, under statements regarding reputation, statements regarding personal or family history. Birth, marriage, divorce, death, relationship.
Sounds like they're not going to ask about statements she was making inside the hospital. So,
well, like they told us what she's not being proffered for. I'd like to hear a little bit about what she's being proffered for. And again, the admonition too is not just what happened in the hospitalization, but there's a lot of deposition testimony here about what Beata told the witness about what was going on.
I don't want to go through her whole testimony outside the presence of the jury and then have to redo it again on a witness that also is going to need the services of an interpreter.
All right.
So let's.
So those that know Polish in here, and I realize it's a small percentage, but those that do are going to hear things that will have to be waiting to be translated before they can object to them.
2159. 2159 is in evidence, and we got the 2016 org chart, which is 2802 in evidence. So we don't need 2149. Is that correct?
I'm sorry.
The clerk wanted to know about. Okay, let's do this. Let me have the clerk swear the interpreter in. I will then swear the witness in outside the presence of the jury, and then I will tell the jury, like I've done with the other witnesses, that I swore the witness outside the presence.
I know we've got quite a few medical personnel. If anyone who's in the medical field knows of positions that are open regarding medical records, specifically work from home, Tilda Tierra is currently between jobs and would like to not be between jobs anymore. We'd love to be able to at least pass some options towards her if you know of some openings.
I do. I'm going to bring in the witness. And are you fine standing there, or do you need
Yes,
to
I'm fine.
sit down? If you get tired and need to sit down, let us know, and we'll
Thank you.
make that work for you.
I guess I'll stand over here.
He's going to sit on the witness stand. This is fun.
Why don't you go to that lectern, and then Mr. Anderson can go to this lectern.
Okay. Your Honor, I'm just have a better view of the monitor here. Does that matter or not?
Well, I tell you what, why don't you come sit on the witness stand?
Okay.
There's a monitor there, and I will.
Regina appears to be.
You see that? Okay.
Older sister, possibly, to Beata.
Good morning again, Miss. Is it Chmiel?
Dzień dobry, pani Chmiel.
Dzień dobry, witam.
We'll get a picture here in just a second.
Did I say that properly?
In Polish, it's pronounced Chmiel.
Chmiel?
Close enough.
No, I try to get everyone's name right.
Chmiel. Chmiel.
Chmiel?
Yeah. That's perfect.
Miss Chmiel?
Judge is trying so hard.
My understanding is you currently are in the Chicago area. Is that correct?
Rozumiem, że pani w tej chwili jest w obszarze blisko Chicago. Czy tak jest?
Tak, mieszkam w Chicago.
Yes, I am in Chicago area.
Under our rules, since I am a judge in the state of Florida,
ponieważ ja jestem sędzią w stanie Floryda,
I need your permission to administer the oath before you testify.
Potrzebuję, żeby pani się zgodziła na dokonanie przysięgi, zanim pani będzie zeznawać.
What that means for you is if there was ever an enforcement action or a perjury action,
dla pani to znaczy to, że jeżeli kiedykolwiek ktoś niósłby jakąś akcję o krzywoprzysięstwo
against you based on your testimony here today,
przeciwko pani na podstawie tego, co pani dzisiaj zeznaje,
you are agreeing to personal jurisdiction in Sarasota County, Florida.
Zgadza się pani na to, żeby taka akcja sądowa, jeżeli by była taka, miała miejsce w Sarasocie, w Florydzie.
Because even though you were sitting in Chicago, you were actually testifying in Sarasota County, Florida.
Dlatego, że mimo to, że pani w tej chwili siedzi w Chicago, to zeznaje pani w Sarasocie na Florydzie.
Okay, rozumiem.
I understand.
With that understanding, do you agree I can administer the oath to you?
Rozumiejąc to, co powiedziałem, czy zgadza się pani na przysięgę?
Tak.
I do.
Please raise your right hand.
Proszę podnieść prawą rękę.
Do you solemnly swear or affirm the testimony you give is the truth?
Czy pani przysięga, że wszystko to, co pani powie w zeznaniach, jest prawdą?
Tak.
Yes.
Thank you, ma'am.
Dziękuję pani.
Let's bring in the jury.
Your Honor, I'm sorry. Did I miss it? I don't remember you swearing in the interpreter.
Yes, you missed it.
The clerk swore the interpreter.
Oh, I'm sorry. My apologies.
Okay, let's bring in the jury.
Wprowadzeni będą ławnicy.
Polish is a little harder to, there aren't as many similarities between our two languages.
All right, jurors entering.
Okay, everyone, please be seated. Okay. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that correct? And have you been approached by anyone about this case since you were with us last?
No.
And have you reviewed any media coverage of this case since we were last here?
Sędzia sprawdza, czy ławnicy z nikim nie rozmawiali.
And y'all doing okay this morning? I asked a different question. Are y'all doing okay this morning? Trying to keep you on your toes. Okay. Members of the jury, our next witness is testifying from the Chicago area.
Nasz następny świadek zeznaje z Chicago.
And needs the services of a Polish interpreter.
Potrzebuje usług tłumacza polskiego.
Outside of your presence, I have sworn in both the interpreter and the witness.
Poza waszą obecnością przysięgi dokonał i tłumacz, i świadek.
So the witness will be testifying under oath just like every other witness has.
So that's the Zoom, what the Zoom feed looks like that I can't show you.
Każdy inny świadek w sprawie.
Mr. Anderson, You may inquire.
Panie Anderson, może pan zadawać pytania.
I hope you do not mind if I just call you Regina.
Mam nadzieję, że nie będzie pani miała nic przeciwko temu, jeżeli będę się do pani zwracał jako Regina.
Dobrze, miło mi.
That's okay.
Thank you, it's a pleasure.
You're Beata Kowalski's sister.
Czy pani jest siostrą Beaty Kowalskiej?
Tak, jestem.
Yes, I am.
Where do you live?
Gdzie pani mieszka?
Mieszkam w Chicago.
I live in Chicago.
How long have you lived there?
Jak długo pani tam mieszka?
21 lat.
21 years.
And where did you live before that?
Gdzie pani mieszka uprzednio?
Mieszkałam w Polsce.
I lived in Poland.
And when you moved, was Poland still under communist rule? Or had it been freed?
Kiedy pani przeprowadziła się do Stanów Zjednoczonych, czy Polska jeszcze dalej była pod władzą komunistyczną, czy już została wyzwolona?
Już została wyzwolona.
It had been freed.
For how long?
Jak długo?
Miałam 28 lat, jak w Polsce został obalony komunizm.
I was 28 years old when communism was toppled in Poland.
And how old would Beata been then?
Ile lat miała wtedy Beata?
Jak został obalony komunizm w Polsce, moja siostra miała 16 lat.
When communism was toppled in Poland, my sister was 16 years old.
So both you and your sister lived into your teens under communist rule?
Więc zarówno pani, jak i pani siostra, będąc nastolatkami, żyły pod władzą komunistyczną.
Tak.
Yes. And did that shape Beata's view of life from what you saw?
Czy to przeżycie w jakiś sposób ukształtowało poglądy Beaty na życie z tego, co pani mogła zobaczyć?
Tak.
Yes.
Nasi rodzice mówili nam, że trzeba walczyć o ważne sprawy. Nasz tata w czasie komunizmu należał do Związku Zawodowego Solidarność 1980.
Our parents told us that we should fight for things that are important to us. Our father belonged to the Solidarity Union movement.
Nasz tata był jednym z liderów tego ruchu, który walczył o prawa ludzi i walczył z komunizmem.
Our father was one of the leaders of the movement that fought for human rights and fought against communist rule.
Ma'am, are you reading off of something? This is Judge Carroll.
Sędzia pyta, czy pani czyta z notatek.
Mam notatki i patrzę, żebym po prostu powiedziała dobrze. Mogę korzystać z notatek moich?
I made some notes. I just want to make sure that I'm saying what I'm saying correctly. Am I allowed to use these notes?
Well, let's turn over your notes and not use them. If you need to use them, let us know beforehand, okay?
Sędzia prosi, żeby pani odwróciła notatki do góry nogami, nie używała ich. Jeżeli pani będzie je potrzebowała, proszę o tym powiadomić sędziego. Yes, Your Honor.
Not to get into too much of a history lesson, but was the solidarity movement under Lech Walesa the beginning of the fall of communism in Eastern Europe?
Tutaj wchodzić w lekcję historii, ale chciałem pani zadać pytanie, czy ruch Solidarności pod kierownictwem Wałęsy był jedną z przyczyn upadku komunizmu.
Hold on a second. Sustain.
So,
tell her not to answer that question.
Ma pani nie odpowiadać, dlatego że adwokat strony drugiej wniósł sprzeciw, sędzia ten sprzeciw uwzględnił, że to nie jest istotne.
From the way that you and your sister were raised, do you believe that there was an inherent distrust of government from being under communist rule?
Czy z tego, tak jak pani siostra były wychowane przez rodziców, czy zgodziłaby się pani z tym, że był jakby zakodowany brak zaufania wobec instytucji rządowych?
Nie wiem, na ile moja siostra pamiętała, ale myślę, że miało to duży wpływ na nią, ponieważ nasz tata został internowany i osądzony w więzieniu jako więzień polityczny i nie było go pół roku.
I don't know exactly how much of this affected my sister, but I assume, I would think it had affected her. Because our father had been imprisoned by the government authorities for a period of 6 months.
Nasz tato został internowany w grudniu, 13 grudnia 1981 roku na oczach swoich małych dzieci.
Our father was interned on December 13th, 1981. He was arrested, taken in while his small children were watching this happen.
Tato został zabrany z domu i nie wiedzieliśmy, gdzie on przebywa.
Our father was taken from his house and we didn't know where he was being taken to.
Go ahead. She can
continue. To na pewno było wielkie przeżycie dla niej, dla 8-letniego dziecka. Jeszcze do tego naszej mamy nie było, bo kilka miesięcy wcześniej pojechała do Stanów Zjednoczonych.
It was a very impactful experience for an 8-year-old. My sister was 8 years old.
Finish out
Additionally, so because our mother had not been at home, she was in the United States at the time.
Okay, ma'am, we need to wait for the next question before we say anything else.
Musimy czekać na następne pytanie, pani musi czekać na następne pytanie, zanim pani będzie kontynuować od pytania do pytania.
Your Honor, I would like to state my objection on the basis of relevance, non-responsive to the question asked.
Adwokat chciał mieć sprzeciw, mówiąc, że na bazie istotności.
I'm going to overrule, but ma'am, you just need to wait for the next question.
Sędzia nie zaakceptował sprzeciwu, ale musi pani czekać na następne pytanie, a odpowiadać tylko na pytanie, które jest zadane.
Were you and your sister taught to assert yourselves in order to get something done with a bureaucracy?
Czy panią i pani siostrę uczono tego, żeby być asertywnym, żeby być pewnym siebie w konfrontacji z biurokracją, żeby po prostu domagać się swego?
Overruled, she can answer.
Może pani odpowiedzieć.
Myślę, że tak. Rodzice nam wpajali to zawsze, że trzeba walczyć o swoje i stawiali nasi rodzice na edukację nas.
I believe so. Our parents always taught us to stick up for ourselves and to educate ourselves as best we could.
So, was the Roman Catholic religion important in your family?
Czy wiara rzymskokatolicka, religia była ważna w rodzinie pani?
Tak, była bardzo ważna i jest.
Yes, it was and still is very important.
How often did you get to see your sister once she moved to the United States?
Jak często widywała pani siostrę od czasu, kiedy ona przeprowadziła się do Stanów Zjednoczonych?
Kiedy ja przyjechałam ze swoją rodziną do Stanów Zjednoczonych, Beata wyszła za mąż i założyła swoją rodzinę i spotykaliśmy się bardzo często.
After I had moved to the United States, Beata had married, she had her own family, and we met very frequently.
Is that how you pronounce Beata's name in Polish?
Czy tak się wymawia imię Beaty po polsku?
Beata, a w domu mówiliśmy na nią Benia.
Beata. The Polish pronunciation is Beata. At home she was called Benia.
So, did you have the opportunity to observe Beata's interaction with her children, with Kyle and Maya?
Czy miała pani okazję obserwować interakcję między Beatą a jej dziećmi?
Tak, Beata, jak mieszkała na przedmieściach Chicago w Elmhurst, tutaj urodziły się jej dzieci Spotykałyśmy się bardzo często na urodzinach swoich dzieci, na świętach, pomagałyśmy sobie nawzajem. Była bardzo dobrą matką.
Przepraszam. When she was married and had children, we would meet very often. We would meet for family holidays and on other occasions. She was a very good mother. We met quite frequently.
And when you spoke, did you speak Polish?
Kiedy spotykałyście się, czy mówiłyście po polsku?
Tak, mówiliśmy po polsku. Jej dzieci chodziły do polskiej szkoły raz w tygodniu, by uczyć się języka polskiego i Beatka mówiła zawsze do nich po polsku.
Yes, we spoke Polish. The children went to Saturday school to learn Polish, and Beata always spoke to them in Polish.
At the time Beata passed, how well were the children doing in communicating with the rest of the family in Polish?
Wtedy, kiedy odeszła Beata, na ile z powodzeniem mogły się komunikować dzieci z resztą rodziny po polsku?
Kiedy po tragicznej śmierci mojej siostry kontakt z jej dziećmi był bardzo znikomy.
After the tragic death of my sister, the contact that we had with her children was very sporadic.
Before that, were they coming along in the Polish language so that you could communicate easily directly with them?
Pytanie jest, czy przed śmiercią Beaty, na ile dobry był ich polski, czy mogła pani się z nimi swobodnie porozumiewać w języku polskim?
Tak, mogłam się porozumiewać, spotykałyśmy się, przytulaliśmy się nawzajem. Dzieci bardzo mnie lubiały, naszą mamę, babcię.
I could freely communicate with them in Polish. We hugged, we had a very good time. They were very close to me and their grandmother.
Hey guys, let's lay off the witness and just listen to the testimony right now.
When was the last time you spoke with either Kyle or Maya?
Kiedy to było ostatnim razem, kiedy pani rozmawiała albo z Kyle, albo z Mają?
Z Mają i z Kajem wysyłamy sobie text message, bo najlepiej nam się w ten sposób porozumiewać. Nie dzwonimy do siebie, tylko SMS-ujemy.
Yes, sure.
Is one of the two texts running this through the system so the jury can see? Okay.
Pytanie jest, czy jurorzy widzą pani obraz.
The jury can
Teraz się pani obraz.
Hey, look at that.
Zniknęłam.
Sorry about that.
Forgot to push the button.
Should I interpret the question?
I can't even remember the question.
The question was whether Ms. Chmiel had when was the last time she had communicated with the children?
That was the question, please.
Kiedy pani, jeszcze raz jak pani odpowiedziała na to pytanie, kiedy pani ostatni raz miała kontakt z dziećmi?
Z dziećmi mojej siostry kontaktujemy się codziennie przez SMS-y. Nie dzwonimy do siebie, dlatego że one nie mówią już po polsku, a ja tylko troszkę mówię po angielsku.
Przepraszam. I contact the children regularly. We communicate through text messages. We contact each other every day. Text messages are a better mode of communication because the children no longer speak English well, and I don't speak. No longer speak Polish well, and I don't speak English well enough to have a fluid conversation.
So, without Beata, has it become more difficult for the children to communicate with your side of the family?
Czy bez Beaty jest w tej chwili trudniej dzieciom komunikować się z pani stroną rodziny?
Tak, teraz jest bardzo trudno, dlatego że Beata, moja siostra, była łącznikiem między nami. Ona mówiła
it has become. May I ask the witness just to,
yes,
no more than 2 sentences? Proszę panią, nie więcej niż 2 zdania, tak jak się umawialiśmy, bo mnie potem jest trudno wszystko przetłumaczyć. Yes, the exchange has become much more difficult right now because Beata was the intermediary who's bringing us together. So it is more difficult now.
Did you have an opportunity to observe your sister's interaction with Maya and Kyle on those occasions you were together?
Czy miała Pani okazję obserwować Beatę w relacjach z jej dziećmi, z Kyle i z Mają w tych momentach, kiedy byłyście razem?
Tak.
Yes, I did.
Describe for the jury, from your position as an aunt, how Maya interacted with her children. What kind of mother was she?
Jeżeli Pani mogłaby opisać ze swojej pozycji jako ciocia, jak Beata, jaka była interakcja między Beatą i jej dziećmi, jakiego rodzaju była mamą?
Jak Kajo, drugie dziecko, Beata urodziła, jak pamiętam,
When Beata gave birth to the second child, Kaya, I remember.
Jej dziecko miało problemy z krwią jako noworodek.
The child had problems with blood as a toddler.
I Kajo został zabrany do innego szpitala po porodzie.
And Kaya was taken to another hospital immediately after birth.
To ona wypisała się ze szpitala położniczego i pojechała za nim.
Beata had signed herself out of the OB hospital she was with, and she went with the child.
Chory Majo miał, co pamiętam, 8 razy przetaczaną krew od swojej mamy i ratowała jego życie.
When Kyle was ill, he had 8 blood transfusions. Transfusions that were the source of the blood was the mother's blood, and that saved his life.
Z tego co pamiętam, Beata, moja siostra, była bardzo dobrą matką. Pamiętam, jak założyła dla niego taką książeczkę.
From what I remember, Beata was a very good mother. I remember where she instituted a booklet for him.
Taki pamiętnik, jak była w ciąży, prowadziła pamiętnik dla małego Kaja.
It was a diary that she had written while she was pregnant for her child to read in the future.
I jak pewnego razu byłam u niej na wizycie i oglądałam tą książeczkę, jak ona dokładnie pisała, co czuła, jak go nosiła pod swoim sercem.
One of the times when I was there, I had a chance to look at the booklet and read it, and she was very precise in recounting how she felt when she carried him under her heart during her pregnancy.
Pisała praktycznie każdego dnia w tym pamiętniku do Kaja. Pisała go swoją ręką i swoim sercem.
She wrote practically every day. She wrote with her heart and with her hand.
Natomiast Maja, jej córeczka, bardzo ją kochała.
She loved her daughter Maya very, very much.
Maja, gdy była tutaj zdrowa w Ermpus, razem z rodzicami jeździła na łyżwach. Byliśmy na takim pokazie na tych łyżwach.
When Maya was healthy, she would go with her parents to go ice skating. We went to see ice skating shows.
Słuchaliśmy jej nagrań, ponieważ Maja pięknie grała na pianinie.
And Maya played the piano very, very well, wonderfully, so we would listen to recordings of her playing the piano.
Kiedy Maja z rodziną przeprowadziła się na Florydę do Venice.
When Maya with her family had moved to Florida, to Venice.
I wkrótce, myślę, że tak 2 lata.
And within, I think, was 2 years.
Maja zachorowała.
Maya became sick.
I Beata informowała nas i opowiadała o wszystkim, o jej zmaganiach z tą chorobą.
Beata informed us about all the details. She told us about all of Maya's struggles in fighting the ailment.
Ma'am, you need to wait for the next question.
Proszę poczekać na następne pytanie.
From what you saw, understanding most parents hopefully have a strong parental instinct. Did Beata have a particularly strong parental protective instinct towards her children?
Z tego, co pani
because of what
widziała,
she'd been through.
I'm going to check the foundation.
Going to overrule that. You can translate.
Mogę przetłumaczyć, sędzia pozwolił. Pytanie było takie, że zakładając, że większość rodziców ma instynkt opiekuńczy wobec swoich dzieci, czy powiedziałaby pani, że Beata miała wyjątkowo silny instynkt opiekuńczy wobec swoich dzieci?
Beata była zwykłą mamą, tak jak wszystkie dobre mamy.
Beata was a normal mother, just like any other good mother. I'm not sure that the witness understood your question.
Can you translate the parental instinct to protect her children? And I'm trying to ask, was Beata's more than normal?
Just ask a normal question.
Just ask a normal question.
I'll try it.
I will object to the extent this is calling for character evidence.
You'll need to translate our discussion. Just ask your next question.
Right. Did Beata have a strong instinct to protect Kyle and Maya from what you saw?
Okay, I'm going to sustain the objection. Let's go to the next question.
W tej chwili podtrzymał obiekcję sędzia, więc przechodzimy do następnego pytania.
So since Beata's death, how much less you've testified you see them less, how much less are you able to see Kyle and Maya and they you?
Od czasu śmierci Beaty, na ile mniej jest pani w stanie widywać się z dziećmi, na ile mniej one są w stanie widywać się z panią?
Po śmierci Beaty widziałam dzieci 2 razy.
After Beata's death, I had seen the children on 2 occasions.
Razem z moją rodziną, z moją mamą, która je wychowywała. Mama moja do tej pory bardzo rozpacza, że nie widzi swoich wnuków, którymi się opiekowała.
When I had seen them, I was in the company of my mother, their grandmother, who raised them, who also raised them, and she is despondent about the fact that she can't see them more.
Brings up a good point. Now, who is in the United States from your side of the family that the children would be able to interact
This is new information.
Kto jest w tej chwili od pani strony rodziny w Stanach Zjednoczonych, tak żeby dzieci mogły mieć jakby interakcję, widzieć się z tymi osobami, które są w Stanach Zjednoczonych?
My tu mieszkamy wszyscy. Jest moja druga siostra Elżbieta, jest mój brat Piotr,
Momencik. We all live here. There's my sister Elżbieta, my brother Piotr. Proszę.
Jest siostrzenica Klaudia.
There's my niece Claudia.
I moje dzieci, a mam ich 5.
And my children, and I have 5 children.
Wszyscy czekamy na wizyty Mai i Kaja.
We all eagerly await Maya's and Kyle's visits.
Any cousins around their age?
Czy
Maya and Kyle's?
Czy są kuzyni mniej więcej w ich wieku? Maja i Kyla.
Moje dzieci są dużo starsi. Mój syn jest ojcem chrzestnym Kaja.
My children are quite a bit older. My son is Kyle's godfather.
And so now has that contact with your side of the family been reduced now that it's been a few years since Beata's passing?
Pytanie jest, czy od śmierci Beaty ten kontakt został zmniejszony?
Bardzo został zmniejszony.
It has been reduced to a great degree.
Po śmierci Beaty rodzina się rozsypała. Wszyscy po prostu nie mogą sobie z tym poradzić.
After Beata's death, the family fell apart. We can't cope with the situation.
Is there any doubt in your mind that Beata would give her life for her children?
Czy ma pani jakiekolwiek wątpliwości, że Beata oddałaby swoje życie za dzieci?
Objection, relevance, foundation.
Establish the foundation.
Also character evidence as well.
Sustained.
Nie mogę tego, znaczy sędzia nie pozwala na odpowiedzi na to pytanie.
And do you hope for more communication with Maya and Kyle in the future?
Czy ma pani nadzieję na to, że będzie pani miała więcej kontaktu z Kyle i z Mają w przyszłości?
Mam nadzieję, że się będziemy spotykać.
I'm hopeful that we will be able to meet. Proszę dalej.
Może już wkrótce przyjadą do nas na wesele.
Hopefully, maybe they will come to visit us soon for the wedding.
Your witness. Thank you, Regina.
I don't think they're
Mr.
going to have
Hughes,
much.
your turn.
Teraz będzie adwokat obrony zadawał pani pytania.
May it please the court. Good morning, ma'am. Thank you for coming in. I'm sorry for your loss.
Dzień dobry pani, dziękuję za to, że się pani pojawiła. Jest mi przykro z powodu straty, jaką pani doznała.
Does Mr. Kowalski, Jack Kowalski, make arrangements for you and the family here in Florida to get together?
Czy pan Kowalski, Jack Kowalski aranżuje takie możliwości, żeby pani rodzina mogła się spotkać z dziećmi?
Trudno mi powiedzieć, dlatego że to Beata była tym łącznikiem, jak żyła.
It is difficult for me to say because Beata was the instigator of family gatherings.
My mieszkamy w Chicago, oni mieszkają w Venice.
We live in Chicago, they live in Venice.
My mówimy w języku polskim, troszkę po angielsku tylko.
We speak Polish, just a little bit of English.
Jacek mówi tylko po angielsku, nie mówi po polsku.
Jacek speaks only English, he does not speak Polish.
When was the last time that Mr. Kowalski made attempts to meet with the side of the family that's in Chicago?
Kiedy ostatnim razem pan Kowalski próbował się spotkać z rodziną, która mieszka w Chicago?
Jacek z dziećmi po śmierci Beaty był tutaj 2 razy z wizytą.
After Beata's death, Jacek and the children were here in Chicago twice.
I don't have any other questions. Thank you, ma'am.
Nie mam więcej pytań, dziękuję.
Mr. Anderson, any more questions?
Nothing further.
Pan Anderson też nie ma więcej pytań.
Hold on a second, ma'am. The jury might have questions.
Jeszcze pani poczeka, bo być może ławnicy będą mieli pytania.
Members of the jury, anyone have questions?
Ławnicy nie mają pytań.
Okay, seeing no questions, may this witness be excused at this time?
Yes, on behalf of plaintiffs.
Ponieważ nie ma więcej pytań, czy możemy podziękować świadkowi?
Thank you for being with us, ma'am. You're free to go.
Dziękuję za to, że pani była z nami. Może pani już skończyć swoje zeznanie. Thank you. Thank you, Your Honor.
I do believe that the Beata's sister there, or Regina, understood a lot more English than we might have been led to believe, because she would start responding after the question. She understood questions.
And your next witness.
She's probably just more comfortable speaking
Vose, by deposition.
in Polish.
Judge, can we approach briefly?
Sure.
Okay, so we're gonna count that as another objection because they make a lot of objections. All right, so interesting reason to call her. Beata's sister. There wasn't a lot new. A lot of what we'd heard before we had heard from other members of the family. I think we got some new information about Beata's dad being imprisoned in a communist country, the dates that happened, a little bit of insight into the distrust of government, which they've tried to get in with other witnesses and I think was unsuccessful. So that might have been the main push. We found a little bit about some of how the family, Beata's family, namely Maya and Kyle, interacted with these relatives up in Chicago, and how that went. There was just confirmation about the family being strong Roman Catholic, but really there wasn't like a bombshell reveal there. So it was an interesting decision to call her. But obviously, Mr. Anderson, he's watching the clock. He knows he just cut Dr. Hannah off the list, so he might feel freed up to bring in some of these other witnesses that might put more of the human side of the situation on the case. So all goes to his strategy. He thought it was. I mean, we'll have to look at if his side prevails, we'll have to look at
and
the
this
numbers.
one's on video as well? This deposition's on video?
Yes, Your Honor.
Oh, Your Honor, I do ask, I'm sorry, can we tell the jury the dates the depositions are taken? Because it's not, can we approach?
It's on the bottom of the screen, but
okay.
It's literally stamped on the screen.
Sure.
That's what deposition videos look like. Ooh, mood lighting. Yay. No necking, guys. No necking. That's what my science teacher used to tell us every single time we'd watch a science video. Bill Nye the Science Guy's on. No necking.
Is that too much light over there?
I'm blinded.
Tell me. I'll keep adjusting it.
Alexa, 20%.
That was a juror who just shouted out Alexa. This jury does feel comfortable.
That's the right one.
And we get a light show.
Like I said, there's like 9 switches here. Or not switches, buttons. Okay, let's play the next deposition, please. That lady, you know how to do the lights? No.
Judge, should we do an instruction? This may be our first. Is this our first depo?
No.
Oh, sorry.
I'll just tell you the instruction anyway. As a reminder, depositions were done under oath prior to you coming here. You're to treat them just like all the other evidence in this case.
Okay, here we go.
There you go.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Laura Ann Vose,
And is that an MD?
D.O.
And what the DO stands for again?
Doctor of Osteopathy.
And at your present hospital, are you on any committees?
Yes.
What committees?
I am on the ethics committee. I am on a pediatric surgical performance improvement committee.
Okay. Dr. Vose, we are, as I said, in follow-up to your last deposition, I think your only deposition in this case, which was taken Thursday, November 14th at 2019. Do you remember giving that deposition?
Yes.
And have you had the opportunity to read that deposition in the interim?
Yes.
Right. Did you mark out any changes or corrections on an errata sheet?
I would like to defer to Howard whether or not I had filled out one form regarding my cell phone.
All right.
Regarding my cell phone.
All right. So that's a maybe?
Yes.
And during the course of that deposition, I advised you that if at any time you did not understand my question or you're having difficulty answering it, I asked that you tell me out loud on the record so I can change it to make it easier to answer. Do you recall that?
Yes.
And we agreed that in the event that you did not say anything, we all, judge, jury, all of us could understand you understood the question and are answering it to the best of your abilities. Right?
Yes.
Okay.
Is this a gotcha moment? It's a weird sort of preface.
From 2017 to 2020, basically the time after Maya finally left Johns Hopkins, to the time you left Johns Hopkins, did your position change at all?
No.
Did you continue to work on certain committees?
Yes.
And what were those committees?
Not having the list in front of me.
Best you can do.
Their ethics committee. There was a PICU committee. There, I would have to actually pull up my CV to be able to tell you all of the committees that I was on at that time.
Okay. Well, the reason I was asking you is that you said in the first text, I think we're going to talk about, you've been busy with an ethics consult. So I take it that as of the time that Beata Kowalski committed suicide, you were on that ethics committee?
Yes.
The cell phone that we're talking about here, I wanted to read just the last 4 digits. I didn't want to put the whole thing in the record. That's the one that is 9979.
That's not my personal cell phone.
Okay. You think that was the hospital's?
Possibly.
Okay. That's the one that appears next to your, I take to be your statements here in the text. All right. And what number did you send the texts from? And just for clarification, it is the text that began to be discussed today, learned today that ketamine girl's mom committed suicide yesterday. And all I'm trying to establish is whose phone was that, yours or the hospital's?
That one was mine.
So one of the statements in this is I've been busy with an ethics consult, so I haven't done anything about order sets yet. I wanted to find out more about the ethics committee. Was this something where you had calls to, I guess, intervene or to analyze ethical issues?
Yes.
And so what did you do? Not particularly for this one, but in general, when you got a call?
We would take in the information from whoever requested a consult, review the record, talk to all of the parties involved. Then we would convene a subgroup of the committee to have people come and present and to review the records, and involved parties were then excused, and the committee then would discuss recommendations. And then
who else? If there was an outcome, if there was a decision, a recommendation, who did you make a recommendation to?
We would write a formal consult and put it in the chart.
What human being within the hospital, if you had to report to management, who would you report to?
We would fall under the medical executive committee. We also had administrative management that we reported to as well. So, for example, Joe Perno would have been aware of the ethics committee activities.
what was the test to determine whether the ethics committee should consider a case?
We would get the request. We would determine whether or not there was an ethical issue at question. Sometimes it would be more of a legal issue than a ethical issue, or a communication issue. So we would try to address.
Sorry, go ahead.
We would try to address what the specific ethical question was.
To make the cut, so to speak, for committee review, was there any guidelines? Were there any guidelines for you? In other words, I'm assuming you didn't take up matters involving just a disagreement among nurses or social workers or anything like that. Would it be something that would involve a doctor as a requirement?
It would not necessarily have to involve a doctor. It could be anyone was allowed to place a consult or request something to be reviewed. So it could be inter-service related or patient-physician related.
All right. After the time that you learned that Beata Kowalski had committed suicide, was there an ethics committee convened to review what happened?
No.
Why not?
There was no request for one, and we also usually did consults during current hospitalizations if a case involved a patient.
All right, so the committee itself never took it upon itself to bring up a matter. It had to have a complainant.
We did not bring up this case.
Let me try this. How could you decide if something was ethical or unethical if the ethics committee never took it up?
Again, there was no request. If there had been a request to look at it, then it would have been looked at. If a concern had been raised internally or an external person had asked for something to be reviewed.
So the answer is, in that situation, no one would be reviewing the issue. True?
It would be reviewed if someone had requested a review.
Okay. What about in the 3 months of Maya's hospitalization preceding the suicide? Did anyone bring up any ethical issues about her care?
There were no requests for the ethics committee to evaluate the case.
Was there ever any investigation at all of what happened to Maya Kowalski by the ethics committee?
No.
And after Maya's mother committed suicide, was there any investigation into the ethics of how she was treated?
No.
Would you agree with me that using the term ketamine girl is a bit dehumanizing?
It basically sort of is a euphemism to not use her name in a text.
Okay, well, you're not answering my question. In retrospect, wouldn't you say that the term ketamine girl is a bit dehumanizing?
I probably could have used a better choice, but I was trying not to use her name. I'm not aware of that. No.
Can you say, as you sit here today, that you didn't refer to her as Maya in different conversations to other doctors? On the phone, that is.
I'm not aware one way or the other with 100% certainty.
How many ketamine girls were there at All Children's at this time?
Well, I had used that as a euphemism because it was unique, kind of given her history, and
did you ever refer to her as ketamine girl to her name, to her face?
No.
To her mother?
No.
To her father?
No.
So how is ketamine girl not an identifier if MK is the only girl being kept there because of ketamine?
I see it more as an identifier for people that would be familiar with her case, but not something from somebody outside to be able to connect specifically to a person.
You're sure that none of the nurses or social workers or other doctors also referred to her as ketamine girl from time to time?
I have no idea.
All right. You said, sorry to say my prediction was correct. You were predicting you were predicting Beata's suicide, were you not?
Prediction probably was not a good word, but more related on my previous experience of a case during residency. So it may have been more of a speculation than a prediction.
You have a doctorate level education, do you not?
Yes.
All right. So when you say words, you choose what words are appropriate, do you not?
I like to think that I do, but in a text, sometimes you don't think and edit and re-edit, and as a human, you sometimes use words that probably would not be the best words to use.
Okay. So tell us when you say my prediction, please define my prediction, what it was.
I had a previous experience during residency where there was a child who the court had determined was Munchausen's by proxy, and that mother had committed suicide. So it was based on a previous experience.
And where did that happen?
That happened at All Children's.
And when?
I believe it was in my internship year, which would have been 1994 to 1995.
And tell me what the facts were, without mentioning names, obviously, that you believe caused that mother to commit suicide.
I don't have the details. I know as a resident, I believe I might have seen that child one time in the emergency room, and then there was an investigation and she had committed suicide, and that's basically all of the details that I know of that case.
Who were you predicting this to? Who was the recipient of this prediction?
Some of it was my own thoughts, and I believe they had maybe a passing conversation after caring for Maya with a coworker just saying that I had a previous experience, and that's what had happened.
So by the time Beata committed suicide, you had already gone through one with a mother committing suicide, right?
I knew of one, yes.
Mm-hmm. And you knew the signs of someone who was about to commit suicide from that experience, did you not?
I didn't have any involvement with that patient or family during that period of the investigation and afterwards. I had seen her.
And yet it came immediately to mind when you heard that Beata had taken her own life, did it not?
It came to mind.
All right. And then there is a response, or is this you? I know we did the right thing, but this is really effed up. I feel bad. Is that you, or is that Dr. Tepa Sanchez?
It's Dr. Tepa.
And did you share her concerns that this was effed up?
I shared my concern that I felt bad about the situation.
All right. So you felt bad. And then you expressed this by saying, don't know all the details, but I think the courts and the psychiatrists finally called it what it was. I had another mother do the same thing. We definitely did the right thing for the child. All right, taking this last sentence, we definitely did the right thing for the child. The right thing being what?
That I believe that as a group and an organization that we advocated for Maya, raised concerns, and allowed the process to continue for the appropriate people to look into what was going on in the hopes of having a good medical outcome for Maya.
You do know that Maya did not have a good medical outcome for more than 3 years and still suffers from pain. Do you not?
I'm not involved with her care, so I don't know directly what's been going on with Maya.
Did you ever check on Maya to determine whether this statement was correct? We definitely did the right thing for the child.
What do you mean by check on?
Call her. Follow up in any way.
No, I didn't.
Talk to Dr. Wassenauer, her pediatrician.
No, I had no follow-up contact with Maya.
Did you ever call Dr. Wassenauer to ask him what his feelings were?
No.
And then it says, OMG, that means, oh my God?
Yes.
And then, well, I really hope she has a chance of a better life now. Is that you, or is that Dr. Tepa Sanchez?
That's Dr. Tepa.
And did you believe that Maya was better off without her mother?
I think it's sad when any child loses a parent. However, if the investigation was proceeding and found that that was leading to harm for Maya, and that Maya, perhaps Maya now would have a better opportunity to have some other therapies and not be under the high doses of drugs, to be able to succeed at school, to be able to do well.
So you actually believed that Beata Kowalski was doing something harmful to her daughter?
I think that the process of evaluation was underway, and that is that we allowed the system to work, and the people that were appropriate to make those investigations and determinations were involved.
All right. And then it says, well, I really hope she has a better life now. That's, again, Dr. Tepa Sanchez.
Yes.
Do you have any remorse to this day, evidenced by anything in these text messages?
I feel sad about the whole situation, and I feel sad that she chose to take her life. But I'm hopeful that Maya now has been able to be more active and participate in her life and do more things.
Okay. And you saw her feet turned inward towards each other? The dystonia?
I don't recall if I ever examined her feet on night call.
You never saw her feet. Okay? When you saw Maya, though, she was perfectly civil and nice to you, was she not?
She was, she didn't really talk much to me that I recall. She was on her phone the first time I saw her. She was playing on her phone. She did not personally swear at me.
You saw her 10 times, and each time that you saw her, she acted like a 10-year-old, 11-year-old girl, did she not?
Some of the times she was sleeping.
Well, I think 10 and 11-year-old girls sleep occasionally.
Correct.
So, but the point being, your medical records do not reveal any denial of her being in pain. So when you say, let's me see what she does with pain tonight before doing CT, you realized that there was, I don't want to call it a threat, but a possibility that that performing a CT could cause her some discomfort, aggravate the pain, in other words. True?
Yes, there was a potential for that.
So you were the chairman of the ethics committee at this time in 2017, were you not?
Yes.
Still to this day, there has been no retrospective on what happened.
Okay.
Up to the point that I was at All Children's, there's not been an investigation. I cannot testify to what has happened since I left.
Does that complete the plan of the
There we
deposition?
go.
Yes, sir.
Okay, members of the jury, I think this is a good time for a morning break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. All right.
I counted one objection, only because it was like, but there were several in there. One was to form as well. I should probably count that as well. Chairman of the Ethics Committee and refers to a patient as the ketamine girl. I'm still waiting for the feed to come back here to normal, and it's not yet. We have the tech guys need to push the button. We can hear, but we cannot see. Judge, if you could turn on the lights, that would be appreciated.
Any issues we need?
Just
the
the
jury's
lights.
out of our presence. Any issues we need to address before we take a break? Do we have the time breakdown on that deposition?
That was all the
Turn the lights down. The camera guy fell asleep.
So can you tell me how long it specifically was?
Yes, Your Honor.
It's 23 minutes and 21 seconds.
Okay. Thank you all. We'll be in recess for 10 minutes.
We got a 10-minute break. Just 1 second. There we go. And we're back in the courtroom. All right. So this last witness, I need to keep some notes here. I'm trying to do a little better tracking notes for you so I can do a better synopsis at the end of the day. Last witness was Laura Vose. She's the ketamine girl texter. And an ethics committee chair. Now, let me just say, I've been an ethics committee chairman before. I know it might be a stretch of the imagination for you guys to consider me in that position. But yes, it's a difficult position, and one that let me just say, you have to act above reproach. Nothing you do everything you do is scrutinized to a higher degree as an ethics committee chair than just a regular participant in any sort of group. Okay? The ethics committee chair has to be completely unbiased and follow all the rules. And for this to happen under her watch and them to do nothing about it, it makes it seem pretty bad. Pretty bad. I will tell you, I did my best as an ethics committee chair. If we did any good at all, it was because we had a fantastic committee that worked with me and worked for me. Basically, they did the work for me, is what I'm saying. But it was incredibly difficult. It was not something I'd want to do again. Very not fun. Let's put it that way. So if you're asking me to apply for your ethics committee chairmanship, no, I'm not available. Okay, the last witness juxtaposed to Beata's sister was striking. It was. I think this was a good witness for the plaintiff to call for sure. This was. Oh, we've got a call coming in. Hang on 1 second. Oh, I missed it. It was Amber. Lots of people were very, very frustrated with what they saw in this last witness. With how, even to the date of the deposition, which was 2023, if I read the note right, was still very much condescending towards Maya, the family. They're like, I'm sorry about the whole situation, but still thinking that we did the right thing. Interesting how the hospital, no one brought up any investigation at all, even though there was literally an investigation in the situation. Why the hospital didn't do it internally just to make sure they were right, I'm not sure. Creed says, I don't know how I feel about the nickname. It's common in hospitals because there are way too many names. Reads horrible in court. It does, but it sort of pulls back the curtain a little bit, Creed, and it shows us how the hospital was viewing her and the family internally. And that gives us a little peek as to why they were so hostile to them and how they treated them. So it is bad. It's not like a mortal sin, but at the same time, it's a symptom of the underlying feeling that was prevalent or appears to be prevalent in the hospital. I wonder how hard the defense fought to try to keep it out. There were lots of objections. If you look at the timestamp, every time it jumps, that's pretty much an objection or Mr. Anderson losing his train of thought. It could have been either. But my phone was ringing like crazy. I'm not connected here, so you'll have to hold on 1 second. Hey, Amber, how are you doing? Are you there? Can you hear me? Hello, Amber? Why is it not working? Hang on. Apparently, I have to plug it in. Amber, can you hear me now?
Oh, it's me, Raggy.
Hey. Hello, I can hear you now.
Hey. You can hear me now. Can everybody else hear me too?
They can. So mind your P's and Q's.
Right, mind my P's and Q's. Okay, disclaimer, I want everybody to understand this is not how every healthcare worker operates, behaves, treats patients. This is not the standard. Do we all have a different viewpoint or different sense of humor? Yes, because in our line of work, we have to, because we see so many things that aren't pretty. However, that doesn't necessarily mean that we should be heartless. So please be mindful in chat when you're talking about healthcare workers in general. This is not the standard, because I see a lot of comments in here that are very judgmental and offensive with regards to healthcare workers as a whole. They do not set the tone for healthcare workers, period. They don't.
We're just talking about Johns Hopkins right now. That's the only one. And it's just this time period and these particular ones that we're interested in. This is right. And even in the plaintiff's complaint, they're saying that Johns Hopkins in this situation did not meet the standard of care that we all expect. They're saying that they're not what we expect from a hospital, and that's why it's so appalling. That's why we're looking at this and like, holy cow, you really treated the patient that way? That's really what you guys did? That's your go-to? Because it is not standard. Right. It is not normal.
Right. And I will say, if anybody has experienced anything like this, you need to actually report it. Please do. We can't do anything to fix it if it's not reported. And if you're not satisfied with who you reported it to and there's no follow-up, then continue on. That's what you're supposed to do if there is a problem with the care and treatment that you've received. This is something I do for a living. This is something that I'm working on in my own area within my huge medical corporation to fix and ensure doesn't happen. So you have to report it and follow up on it.
Let me ask you this. There's a couple takes on the ketamine girl comment, and one of them is that due to HIPAA, you can't use the patient's name. But isn't the argument that she shouldn't have been texting about patients on her personal phone anyway?
Correct, but from what it sounded like, and I'm kind of working at the same time, so I'm going to have to go back and listen specifically. But it sounded like it was a hospital-provided device that they were using, because a lot of times beepers aren't necessarily in anymore everywhere. Some do, some don't still have beepers. But a lot of the nurses on staff
Nope. And we lost her just that quick. Sorry. We lost her. So sorry, the phone crashed, Amber. Hang on. I don't think I can take a call back because it's messing up with my Zoom feed. But appreciate the words, Amber. We'll definitely be mindful of our comments as many people in here in the medical field. We're not trying to paint everyone with the same brush. I do think this particular individual does come across a little bit heartless. And I'm looking at it as someone who's been on an ethics committee and the chair of an ethics committee, which she was, and understands that position is under a microscope, and everything you do there should be done to the highest standard. So I think that's where, personally in my mind, that's where she fell short. As we all do. I fell short as well. But yeah, if we fall short, you've got to own it, right? All right, we've got a few minutes break here before I believe we start the next witness. I'm not sure who the next one is going to be. Let's see. I'm getting a ton of calls. Hang on. Hey, this is Scott. Hey, Lisa.
See that? Are there any issues we need to?
Definitely so, Your Honor.
How long is this next deposition?
Just a moment, Your Honor.
Just as a reminder, at 11:25.
It's
we turn into pumpkins.
It's 22 minutes and 49 seconds.
And who is this all for the plaintiffs? Or is there a split on this one?
I don't recall any defense questions in this one. I think it's all plaintiffs.
It was 22 and something?
22 minutes and 49 seconds.
Okay. And who is this?
Dr. Joseph Parno.
Are we ready to bring the jury in?
I didn't hear the last name. Dr. Joseph. Who?
Let's bring in the jury, and you're the new lighting director.
Bailiff just got promoted. He's now bailiff and lighting director.
Good luck.
So Jack didn't complain, so there was no complaint, so there's no investigation. But they basically made him feel like if he did complain, he would lose what he had.
Bring the jury.
Jules is going to call right as soon as they break for lunch, so that's going to be good. I think they might be doing a little business, but it might be the actual lunch break that she calls on, so we'll see. Actually, I see this. I haven't worked as much in the medical field or been as familiar with that. I'm around a lot of people that work in the field now because the area I live in is a medical community. It really is. The schools, medical, lots of big hospital stuff here. But I have worked a lot in around law enforcement, and law enforcement has a similar sense of humor in some ways to what nurses and doctors have, but because of what they deal with, they sort of have to be able to joke about it and find levity in moments where they can, in situations where the average person might be appalled. So I give them a little leeway that way. It probably happens a lot, and it usually never comes to light, and nobody knows no one's the wiser.
Okay, please be seated, everyone. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
And has anyone approached you about this case since you were last with us?
Correct.
And have you seen any media coverage in the last 20 minutes? Okay. Plaintiff, let's call your next witness.
Dr. Joseph Perno by deposition.
Somebody help me with the last name here. Dr. Joseph
do the lights again.
Perno. Bug Duggar, thanks for another 5 gifted memberships. Hey, Joe, let's go. Gene Rano.
Doctor, if you'll please raise your right hand.
Best poet. Congratulations.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Morning, doctor. Please state your name for the record.
Joseph Perno, P-E-R-N-O.
Thank you for spelling that for us.
And you are a medical doctor?
Correct.
And where do you work?
Johns Hopkins Children's Hospital.
And when did you start there?
2003.
Prior to the acquisition of All Children's Hospital by Johns Hopkins?
Correct.
And that occurred in?
2010 or 11.
All right. Is it true that you never actually sat on the risk management committee?
I don't recall attending in 2016 or 2017.
So you weren't there, at least as far as you can remember.
As far as I could remember, I was named a member of the committee as chief of staff, but as chief of staff is a volunteer position. I was still working a full clinical load and couldn't attend every meeting I was invited to.
Apparently couldn't attend any meeting.
So as chief of staff, how did you keep up with what was going on there?
Well, as chief of staff, you get invited to every single meeting in the hospital. You pick and choose the ones that are important for the role of the medical staff to attend, and I don't recall ever attending the risk management committee.
But since you were chief of staff, you had, I am assuming, because you're here, some control or management of the risk management committee?
No, I had no role other than to attend and listen to what's going on.
Well, how was that information then communicated to you of what happened or what was going to happen?
Is there anything the medical staff need to know about? I'm the liaison to the medical staff. They would communicate with me if there's something that was significant for the medical staff to know.
Well, I understand that, but how about agendas and decisions and topics and referrals up and that type of information? How were you kept abreast of that?
Again, I would only be notified if there was something pertinent that came out of a meeting that they needed addressed with the medical staff. If not, it would.
And how would they do that?
Probably in a one-on-one meeting. I don't recall anything coming up, but that would be the typical way. Either the VPMA or the president of the hospital would update me.
So let me get this straight. Did you ever see any agendas for the risk management meetings? Any of them?
Not that I recall. If I was on the committee, they were probably sent to me, but I don't recall ever seeing them.
Do you recall ever seeing any one of them, an agenda for a risk management meeting?
Not during that time.
Do you recall receiving any, did you receive any notes, memoranda, or any other documentation, electronic or in writing, of what went on in a particular meeting?
Okay, I honestly do not recall.
during the time that this stay of Maya Kowalski was going on, October 7th through approximately the 14th of January, 2017, were you aware of what was going on with her?
I was, and I think we discussed at a previous deposition, I became aware when there was a question about bringing in an outside physician to the organization.
And was that the only decision that you were involved in insofar as Maya's care?
Correct.
So insofar as being able to answer questions of what went on, what was reviewed, what decisions were made, what recommendations were made at a risk management meeting, you wouldn't know. Correct? All right. So tell me what you knew or understood about Maya Kowalski's care and the situation.
At the time, from what I recall, is they wanted to bring in her personal physician who did not have privileges. And the question was should and how we would give temporary emergency privileges on a case-by-case basis. And as chief of staff, I have a role in that decision-making in conjunction with typically the VPMA of the hospital.
All right. So there is a method to bring in doctors who don't have privileges on an emergency basis. Is that right?
Correct.
What are the criteria?
So they need to be able to, they need to be filling a gap that we do not have on the medical staff. So there needs to be a need for them. They need to meet the qualifications of our medical staff to treat the patient. They need to be, for emergency privileges, really they're self-limited to a particular case or time period. I don't have it all in front of me, but it's pretty spelled out by Joint Commission, but those are the main crux of it.
All right. I see two then. They need to fill a gap in an area of medicine that the hospital does not have an expertise in.
Correct.
And then the second one is they have to have qualifications of medical staff. Translate that for me.
Right. They need to be able to be credentialed on our medical staff, meaning they have to meet certain basic things that our medical staff bylaws state you must have.
Well, all right. And so is that in writing anywhere?
Yes.
And what is the name of that document?
That would be the medical staff bylaws.
All right. And so then we had Dr. Hannah. Do you recall Dr. Hannah as being the subject of your review?
Yes.
Let's just assume for the purposes of this question, through other testimony and circumstances, that the hospital was informed that Dr. Hannah could and would be examining Maya Kowalski. What effect would that have on the credentialing process?
I believe it would have no effect. We would still follow our process as a medical staff. It's our job to make sure that people are qualified to treat children, so we would follow the same process. Again, I think it's speculative. I don't recall that we did that, but
he could, and if I'm understanding you, visit the patient as a visitor and converse with her, so long as he doesn't physically examine her or treat her, right?
Yeah, he could visit her as a friend or a colleague, sure.
So if he was turned down at the front desk after applying, even though he didn't apply, but just coming in to see Maya, that would be wrong, would it not?
I don't have any control over security and their policies. We would follow our normal visitor policies at the time, so I can't speak to that.
Well, the patient's rights include to talk with another doctor or specialist at your own request and expense. it would appear then that the patient has a right to speak with another doctor at least. Is that true?
He would be visiting in a role of a friend, not as a physician, because he's not credentialed.
Okay. Well, so you're saying that to talk with another doctor or specialist at your own request and expense, it has to be on the phone?
In the hospital, you must be credentialed to act as a physician. So he could talk to his patient over the phone. He could get emergency privileges and treat her as a physician. But in the building, he needs to be a credentialed part of the medical staff to care for any patient.
Were you aware that there was litigation going on involving Maya Kowalski?
Not at that time.
That is a shelter hearing, shelter proceeding.
I probably knew that she was a shelter hearing, but I probably knew.
All right. Under those circumstances, then, did you nonetheless look at the doctor's background, training, and experience to determine whether he would have been approved?
He never applied or sent it in, so no.
You never did any independent research to determine whether or not?
I would have no need to do that. I've got a lot of duties, as I described earlier. I don't need to be doing extra work.
And as we've established, you can't say whether you were advised or not about that. True? Is that true?
Yeah.
But you have a rough idea of what risk management committee did?
Yes.
What did they do?
They look at trends and different things that pose a risk to the hospital. It's a quarterly meeting, so it's not a real time. It's usually retrospective, looking back what's happened, infection rates, different risks that may be there. Again, and some of this I know just from reading up on it.
Okay. And when you say retrospectively, that means in the preceding quarter?
Yes.
And when you say quarter, are you talking about, for instance, the typical quarters of January, March, June, October?
Yeah, that's what I assume that's the frequency.
Is it true that the board, based on the recommendation of the MEC, can allow someone onto the hospital to make an examination on an emergency basis without submitting their application for privileges?
That is exactly what I was referring to when I talk about emergency privileges. There's a shortened process where we do the basic checks for quality and safety. And yes, it is a recommendation. All medical staff decisions are finalized by the board. But yes, that's the emergency privileging process you're describing.
Sorry, I gotta make a note. Who was there to review what was happening to Maya Kowalski in real time?
So there's no need for a review in real time if the care is going well.
So the answer is no one.
Everyone. We're constantly monitoring our quality of care through multiple indicators, whether it's frontline staff, physician staff, resident staff. We're constantly looking at it. So if there's no red flags, there's no need to do a review of every single case.
What's a red flag?
If there's a concern with the care that we're doing.
Give me some examples.
If there's a concern for inappropriate medication use, prolonged stay in the hospital, discharging too soon, inappropriate floor, meaning need a higher level of care, something along those lines. There's some generalities of things we're always keeping an eye on.
All right, let me ask you about some different things and ask you whether they would meet the threshold for the first the Risk Management Committee, and we'll work through the other ones. A patient such as Maya Kowalski being kept by the hospital against her and her parents' will for 7 days. Would that reach the threshold of something that would be reviewed by risk management?
And no, I mean, Risk Management Committee meets quarterly, so that would not be appropriate.
So would it be reviewed retrospectively?
I do not know.
Would it be reviewed by the Patient Safety Committee?
Probably not.
Would it be reviewed by the Standards and Credentialing Committee?
Definitely not.
Can you think of any other committees that might review a patient being kept against their will at the hospital?
I don't believe we keep patients against their will, but it would probably be more of a team meeting with the care team and the family to discuss best process.
All right. The patient being prohibited from seeing her priest, would that meet the threshold for the Risk Management Committee?
Again, the Risk Management Committee doesn't function in real-time decisions. It's a quarterly meeting.
Well, then who at the hospital checks to make sure that the floor staff, the doctors actually involved, are doing the right thing?
So we have risk managers who are involved on a day-to-day basis that will interact with the staff as necessary. We have social workers for scenarios that you're kind of leading towards that would work together with the care team to make sure we're giving the highest quality care.
What if it's the social worker who's actually doing the things that are highly questionable, if not illegal?
We have physicians, we have risk managers would be involved, and I would like to say our social workers don't perform illegal activities.
Who makes the decisions or oversees decisions about compliance with court orders?
I would say that's probably our risk management department.
So in terms of, let's just say there are facts in the record that Maya Kowalski's priest was prohibited from seeing her in the hospital. You would agree that that violates Maya Kowalski's rights?
I wouldn't necessarily agree to that, and I don't know why the priest was denied, but I wouldn't agree to that.
Okay, so who was there then to review the actions of a nurse or a doctor or a social worker who came up with something like that out of their own head? Who was the next level to check to see whether that was appropriate standard of care?
It would be probably a team decision between the caregivers, the social work, the nursing staff, and again, likely risk management in this scenario.
And who's the superior to risk management?
I don't know. I would guess our legal counsel, but I don't know. I'm not in that.
And who does your legal counsel report to?
At that time, it was the president.
Bring down the president.
And other than the board of directors, was the president the highest authority at the hospital?
Yes, the president at the hospital, yes.
Let's ask about the child being stripped down to her underwear, short shorts, against her will, and photographs being taken of her without any court authorization, any authorization or notice to the parents, and against both the parents and the child's will. Would that be the type of thing that would meet the risk management threshold?
No, because I would consider that part of our standard care and treatment plan. We often will take pictures of patients to document for the medical record.
Make sure I get this right. Standard of care. So, Johns Hopkins, All Children's Hospital, standard of care, could include stripping a child down to her underwear and photographing her in a private room against the child's will, against the parents' will, and without notice to the parents, and without any court order or legal authority to do so. Am I correct in that?
I think the legal authority is the consent to treat. It's part of a treatment protocol. Many children object to things we do for them, right? If I'm suturing a child in the ER, they object. If they were put an IV in their arm, they object. So a child's objection, I think, is difficult. We work with them. But yeah, it's taking non-patient identifiable pictures to help with the medical record, whether it's bruising, whether it's rashes, whether it's injury. It helps enhance the medical record. So it's part of a standard treatment plan.
But in every one of those circumstances, the parents are notified and give their consent. True.
We have consent to treat. So once they give us consent to treat and examine, that's all part of a physical exam and treatment plan. So yeah, that consent had been already given.
Well, can the doctors put a child into a surveillance room for 48 hours under false pretenses of testing without parent consent?
Yeah, I think we choose rooms for our families all the time without consenting families. And if we feel it's part of the treatment plan, I don't see that as a separate call out either.
What possible benefit to the child is it to put them in a room where they cannot reach the commode for 48 hours, knowing the child cannot walk, and keeping her in that darkened room for that length of time?
Are you asking about this specific patient? I can't speak about this specific patient. And I'm not sure exactly what you're trying to get at.
When is Baltimore consulted in terms of standard of care?
Very rarely. In 2016, probably never.
But the point is, Johns Hopkins in Baltimore was not monitoring the level of care that you were providing down here. True?
Correct.
And they were not influencing it anyway, correct?
But they're going to write a check.
Are you aware from any source other than your attorney that Beata Kowalski committed suicide?
No.
So, to this day, sitting here, you're not aware that Beata Kowalski killed herself and left suicide notes which blamed Johns Hopkins' level of care. Are you aware or not? Are you aware?
I have no knowledge from outside sources.
Okay. Did you ever speak with any of the physicians that were involved in Maya Kowalski's care while she was there or soon after?
Just in regards to what we discussed with the potentially bringing in an outside physician.
Okay. So in that limited conversation, then I take it that you never learned that there were texts back and forth predicting Beata's suicide, right?
I have no knowledge of that.
And you would agree with me, though, that if a Johns Hopkins physician is aware that a patient or visiting parent is a suicide risk, that is something that risk management should consider.
Yes.
And that's where we end that one.
It's kind of an abrupt end, but that's the end.
Okay. Are we have another deposition or
Aziz.
Sorry?
Yes, we do.
So
Aziz.
I'll leave the lights as is.
Lights.
And your next
The next deposition is Dr. Anthony Napolitano.
Did you see how somebody joined the Zoom meeting that deposition was done over mid-meeting?
Hold on one second.
I'm positive there was like a frantic text from a lawyer to somebody
If there's
else.
a question, go ahead and write it out.
It's like, Get in here now. Get in here. Ba-ling. President has joined the meeting.
And Mr. Whitney, while the jurors writing out, from a timing perspective, are we okay with the next deposition?
I think you said the breaking point is 11:30. Is that right?
11:25.
It will be fine.
Okay, another quick depo. No defense questions on that deposition. They said no questions. We're done. Just end this.
Doctor, would you raise your hand for me, please?
Hold on a second.
So they have some questions. Apologize. All right.
Oh, we have questions from the jury.
Are there other questions? I'm sorry.
Okay, lots of questions from the jury. Let's see if the jury gets sent out. They might have to turn the lights on so they don't trip on the way out the door. Audio's down. Let me listen in on Zoom, see if we're hearing anything. Zoom's down as well, so there's no audio on this one. They're discussing questions from the jury. Now, this is interesting because jury questions for a video deposition are, I don't know. How are they going to handle this? The questions, obviously with the deposition, we don't have a witness that can answer that, but as you've seen, the attorneys are very aware of the questions that were raised, and I suspect they will address it in due course. That's the judge speaking.
Hey, members of the jury, one of your number had a couple of questions. Obviously, with a deposition, I don't have a live witness here that can answer that, but as you've seen, the attorneys are very aware of the questions that were raised, and I suspect they will address it in due course.
Lights are turned down because we're watching movies in court today.
And
it's just
proceed
easier.
with the playing. Hey, is the lights okay? Do we need to dim it down some more? Okay, thank you.
Here we go. Roll the tape.
Doctor, would you raise your hand for me, please? Do you swear affirm testimony you're about to give the truth, whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
Anthony Napolitano.
Dr. Napolitano, do you understand that you are appearing pursuant to a directive by the court that the defendants produce someone with knowledge regarding the Risk Management Committee operations and issues regarding the chain of command and control?
Yes.
And have you ever served on the Risk Management Committee?
Yes.
What years?
I would say 2014 through 2019.
And what was your position, if any?
I served as chair of the Department of Pediatrics.
Who else in 2016 was on the committee with you?
It would be the chair of the Department of Surgery and members of the risk management team.
You're real soft. Can you speak up a little bit on this?
Sure. It would be Dr. Columbani, the chair of pediatric surgery, and members of the risk management team.
And who is that at that time?
I don't remember all the names. It would be Jackie Crane would be the name I remember.
And she was the general counsel?
I believe she was.
Can you tell this jury, from the best of your memory, whether the Risk Management Committee of Johns Hopkins All Children's Hospital ever took corrective action in any way about Maya Kowalski's considerations and situation?
Not that I'm aware. Not that I am aware.
How does risk management manage risk in real time?
We go back to our divisions and our care areas and look to see how we can help.
So you do or do not discuss things happening in real time?
No,
No, you do not.
we do not discuss real time.
So if a physician or a group of younger physicians makes a mistake, to the best of your knowledge, there's no one at the hospital that is there to correct them in real time.
It's not in real time.
There's no one there that was reviewing what the hospital was doing in real time, correct?
In real time, no.
So, for instance, if you had a social worker who was acting inappropriately towards a child patient, there was no mechanism by which risk management would intervene and try to stop that behavior. True?
No.
Did you know anything about, Doctor, did you know anything about what happened with Maya Kowalski?
I read about it. I read the article about 2 weeks ago.
But before that, as a member of the Risk Management Committee, you'd heard nothing?
I had heard nothing about the case.
And what other positions did you hold?
He's looking at me.
During 2016, 2017? What other committees and things were you on?
The Department of Medicine.
What was your position?
I was chair of the Department of Medicine, pediatric medicine.
And in that capacity, you didn't hear anything about Maya Kowalski?
No.
Megan, welcome.
All
Good
right,
to have
what
you here.
else?
Thank you so much
Were
for your
you on?
support.
What other committees and organizations were you on?
I would sit on medical executive committee.
And as a member of the medical executive committee, you didn't hear anything about Maya Kowalski?
No.
To the best of your knowledge, did anyone from the quality department, such as a vice president of quality, report to the medical executive committee about Maya Kowalski?
No.
The hospital is hanging Beata out to dry.
Do you have any idea why you, as the chief the Department of Medicine chair, would not know about a child being kept at the hospital for this long, or 3 months, involving court orders and an eventual suicide of the mother?
The care is managed at the division level.
Managed at the what?
The care is managed at the division or the treating doctor level with their care. Doesn't come up to me.
This witness has
I would
his own
not hear
counsel.
day-to-day operations or care like this.
What remedies
As a lawyer
were
with it.
available to the patient, most likely the patient's parents, if the doctors at the treating doctor level were misdiagnosing or otherwise negligent in their care of the patient?
Object to form.
They would ask to speak with the division chief and ask to sit down and speak with him or her to discuss the concerns they have.
All right. And with Maya Kowalski, they're under allegations of child abuse. Who would that fall under as a division chief?
That would, for the care or for the care patient?
Yes.
That would be the division chief of hospitalist medicine.
So I know you didn't learn of it till recently, but you do know Maya was there under a court order, correct?
My knowledge is really from what I know from reading the USA Today article that I read.
Okay. And who was responsible then for assuring Maya's care was aligned or complied with a court order?
That would be the physicians caring for Maya.
And if the physicians were not monitoring the nurses and errors were made in her care, how would that be corrected so the child was no longer injured, hurt, or troubled?
It would be the nursing manager of the floor that Maya was on.
As chair of pediatric medicine, do the hospitalists belong to your department, pediatric medicine?
They're one of several divisions, yes.
The ones that what?
Yes, they would. The hospitalists fall under the Department of Medicine.
All right. And so during 2016, who were some of the hospitalists that were under your authority, if you will?
At that point in time, and this is reading from the article, would be, I think, Dr. Deese was one that I read, and
who was it? Sorry?
Dr. Deese.
Okay. Anyone else? Dr. Major?
She would be a hospitalist, yes.
Let's see, how about Dr. Young?
Dr. Young, yes.
Dr. Carroll?
Yes.
Dr. Davidson? Danielson, excuse me. I'm sorry, Danielson.
The first name on Danielson is who?
Kristen?
Would be a hospitalist, yes.
Celia, welcome to the
So
gallery.
she'd be under your care.
Thank you so much.
Under the hospital.
Okay. And throughout this period of time in the fall of 2016, did any of your hospitalists that we've mentioned here ever come to you with any concerns about the actions of any fellow doctors, nurses, or social workers?
No.
If they had come to you and said, the patient's complaining that she's being tortured every time she has to do this type of physical therapy, what would be the procedure? And that's an example. What would be the procedure then once you received that report?
I would speak to the division chief to understand what was happening, ask for a report on what's happening.
Well, who is the division chief for that? What division are we talking about?
The hospitalist.
Well, who was the division chief in 2016 while all this was going down?
I don't remember. I have to go back. We'd have to go back and look.
To the best of your knowledge, has Johns Hopkins All Children's Hospital done anything to change the way it operates since Beata Kowalski's death, Maya's stay there?
No.
They have not changed anything since Maya stayed. This is their current operating standards.
Most of the doctors, nurses, and staff like you don't even know what went down, do you?
From the article that I read is how I know about it.
but internally, coming from within the hospital. Nobody ever brought to your attention what happened there. Is that right?
No.
Okay. And who was there to make sure that the patient's rights, as stated in this particular document, the Guide for Patients and Families, who was there to make sure that the patient's rights under that were being upheld, honored, if you will?
The local leadership, the managers of the unit, the nursing managers of the unit, and the physician, the division chief.
Well, you just testified now that you don't treat adults. Who there is qualified to diagnose a parent as having a mental illness?
We don't have adult providers at the hospital, so we really do not manage adult care.
I take it the answer to your question is there isn't anyone there that is qualified to diagnose adult psychiatric issues.
Yes.
And that was true in 2016, correct?
Yes.
Be the end.
That's the end.
And that's the end of that one.
The date. It's a bit hard to read on that deposition.
Looks like the 11th, May 11th.
Still going.
Oh, it is.
All right. So I'm going to ask you now about some allegations you haven't heard from your testimony other than popular media, and ask you whether these comply with hospital policy. Maya's priest was prevented from seeing her. Does that comply with hospital policy?
I'm not aware.
Okay. She was prevented from having a computer or any electronic devices. Is that part of the hospital's policy generally with children? Not being allowed to have any food, any baked goods from parents or even her little friends. Is that hospital policy?
If a patient was on a specific diet, potentially.
To strip her to her underwear, short shorts, and physically hold her down to photograph her. Is that part of hospital policy?
I'm unaware.
All right. What about listening in on calls with her lawyer? Is that hospital policy?
I'm unaware.
Lots of unawares.
Do you report to anyone in Baltimore?
No.
Have you ever?
No.
Is it true that the hospital, All Children's, continue to operate with essentially the same staff and same procedures and same level of care after Johns Hopkins bought it as before Johns Hopkins bought it?
Yes.
If there is a truly egregious event at the hospital, and I assume there has to have been some over your tenure, what is the most direct line to the president?
I'd go to the president of Johns Hopkins Old Children's.
Okay. Do all department heads have access directly to the president?
At that point in time?
Yes.
2016?
Yes.
Yes.
Okay. So what divisions are part of your department?
At that time?
Sure.
So it would be the cardiology, hematology, oncology, critical care, hospitalist medicine, genetics, infectious disease, neurology, rheumatology.
Well, if you had, then you would have had control over all of the doctors we mentioned from one department or the other, would you not?
I'd have a good deal on the medical side.
All right. And then how often would you have a meeting in 2016 with the heads of the departments?
We would try to meet monthly. Not everybody would attend, but we try to meet monthly.
And in terms of the discussions, do you recall any discussions, even in the general terms, about a child that was being held by court order in the hospital for a long period of time?
No, that would not come up in the division meeting.
How many times have you ever heard of a child being kept at your hospital for over 3 months against their will?
I'm not aware of that.
And so still, if that in fact is true, that was the circumstance, Maya was being held for over 3 months against her will and her parents' will at the hospital, that was not a significant enough event for any of the department heads to bring up?
No.
I see. So it doesn't really matter if the child feels that they're a prisoner, the patients feel the child is a prisoner. You're going to stick to your, what did you call it, methods of care?
Yes.
I don't think I'm premature this time.
And this was from May 11th, 2023?
Yes, Your Honor.
Okay.
Wow. This is cringeworthy. If I were on the defense. Yeah, my battery's dying. Hang on. Okay. I think we're going to lunch here. Let's see what happens here. I think they're talking about scheduling. Judge is looking at the clock. It's definitely a scheduling issue. Okay, some things that really stood out to me in Dr. Napolitano's testimony had to do with, and I'm not sure if he's all the way done. Well, I guess he is because he's on deposition. Some things that stood out to me were every time he said "I'm unaware," it's the right answer from a legal perspective because it's the best possible answer for Johns Hopkins, but it still looks so bad that we have basically all the managers and all the people who should have been aware saying they aren't aware. The questions about the oversight from Baltimore, from headquarters basically, there was none. The fact that they still operate the exact same way they did before the buyout. Please do not listen to any kind of call to action. Never would. I don't do calls to action. I am completely anti the cancel culture. That's not something I would ever support. Let's see. Run to A and run this other one. Hang on one second. I need to go back to my happy place. Give me just 1 second. There we go. Ooh, I fit down here better. All right. It seems like that Beata was really hung out to dry on her own. The hospital is still, from a management perspective, still saying we still believe what we did was right, was the best interest of the child. That's been consistent across Dr. Vose. Was it Vose? I think it was Vose. Laura Vose. She was the one that had the ketamine girl text. Dr. Perno, Joseph Perno, who was the chair of risk management committees. He's like, hey, I'm really busy. I didn't have time to go to these meetings. If there was a problem, it would have come to me. They didn't come to me. There wasn't a problem. Everything's fine. Dr. Anthony Napolitano also, they brought the hospital defense basically presented him as here's somebody you can talk to about risk management and how it works, because he actually went to the meetings. Okay, the chair didn't go, but this guy did. And so they brought him up there, and he had a lot of I don't knows. Everything was fine. We have our systems. We still run our same systems the same way. There's no problems. I don't know of anything you're talking about. Not a good look overall for the hospital. They need to save some face.
We're going to go ahead
somehow.
and take lunch now. And this is one of a meeting that was pre-planned that I had, so the fault's on me. I'm going to ask Deputy Coley if you could have them back ready to go at 1 p.m. We've got a full afternoon, so please be ready for a full afternoon. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll see you back at 1 p.m.
Okay, we're going to switch right up here.
All rise, jurors exiting.
All rise, jurors exiting. Let's see if there's any meeting. I think they have a little bit to discuss because Judge I think he's got half an hour before he actually has to leave. Brandy, good to have you here. Welcome. Yep, they've got some business to conduct. Oh no. Let me talk to your boss.
Thank you.
We can work
Everyone,
this
please be
out.
seated.
Kieran, we can work this out.
So everyone knows we will be back at 12:15 now.
That's 1 hour from now.
I do have another 12 or 13 minutes if you want to just start, or do you want to just take lunch now?
Judge. I'm happy to do that.
Yeah, because I've got about 12 or 13 minutes.
And the time on that last deposition, Your Honor, was 19 minutes and 34 seconds.
Dr. G probably will not be
That was
reviewing
just the one
any of the
about Dr.
depositions
Perno.
on this
I don't
case.
I'm sorry?
Did they give the time on Dr. Perno? I didn't think
I
so.
can tell
It was
you why.
22 and like 40-something seconds.
Okay.
And the one before that was 23 and 21 seconds.
Sorry.
Somebody cranked the volume in the court.
So I've got my list. We'll just start and then we'll pick it back up at 12:15.
Going back to our
For the afternoon witness, Your Honor.
You want to go ahead and do that one right now?
Motion what for the afternoon witness?
Me, Judge. Maybe longer than 10 minutes.
If it's going to be longer than 10 minutes, we probably...
Okay.
Skip it.
What's the motion?
It's a motion to limit or exclude Dr. Cochran's testimony.
Motion to limit or exclude Dr. Porkman's testimony?
2 days ago.
Well, perhaps they can look at it over lunch and then be ready to talk about it.
Bug Duggar.
I guess it's back to you, Mr. Whitney, about exhibits.
Thank you. I'm going to start on the back page of the exhibit list we provided. And again, this is under the risk management file, which is exhibit 2277.
Thank you so much, Bug Duggar. Appreciate your generosity
I'd like to
today.
focus on pages 630 to 631. You can pull up 2277 to 631. Your Honor, the email on the bottom half of the page was previously admitted with redactions.
Oh, yeah.
But we would, so we could redact the entirety of that from this email if necessary. But we would like to admit the top email from New Year's Eve with redactions, of course.
Okay, big email here.
So when you say the top one, are you talking about the one at 219, talking about a transfer? Or the one
Yes, I'm sorry. Those two. That starting with that one, which is 2 lines, and then up to the top, that exchange.
Not sure if you guys can read this or not, but I'll let you get a screenshot.
Judge, sorry, I'll wait for court to stop reading.
Yes. Please don't interrupt the judge when he's reading. This is the judge's reading face.
Okay, and what was the status of the court order? It said, if I remember correctly, at this time it allowed Johns Hopkins to supervise the call specifically.
That's correct.
Within its.
Judges, this included all starting with DCL.
Well,
it includes counsel referring to counsel. It's going to get further entrenched into the DCF hearings.
Your Honor, the relevance of this email is that Johns Hopkins has repeatedly taken the position that they were doing everything they could to transfer this child out of there. And that's the nature of the 2 lines at 2:19 p.m. It has nothing to do with, it's a medical transfer, it has nothing to do with a court order. And the top email, the first line of that email reveals the type of attitude that was being expressed to other facilities about the potential transfer. So it's relevant and necessary for us to push back on the idea that they were doing what they could to accept transfer.
Anything else, Ms. Cross?
I just disagree with their aspersions and characterization of the email. They're trying to interpret, and presuming they're going to try to interpret for the court, what it means is not yet once they get wind of issues with the family. I mean, that's having to do with the dependency court.
Hey, this is what we're going to do now. The bottom email, the one at 6:12 p.m., either you need to redact it in its entirety or redact it consistent with how we previously redacted the predecessor email.
Understood.
The one at 2:19 that starts with thanks for the update, that entirety, those 2 sentences, or those 3 sentences will be unredacted. Those will come in.
I'm sorry, I'm not following. Oh, there. Okay.
And up at the top, the first line, which is 3 sentences, that will remain in.
And the remainder redacted.
Well, the answer is almost yes, but this concept about Maya's recent scratches self-inflicted, that isn't dependency related.
Right.
I think the sentence, plus we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted, can stay in, because we're going to have an instruction that tells them as of this date that there was authority for Johns Hopkins to supervise the calls.
May I read that sentence to you, Judge? Mother shall have an. I'm sorry, I didn't. May I?
It's just a sentence.
Number 2 of the order.
No, it's the sentence. Plus, we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted. That sentence would remain in.
Okay.
Who's taking notes as to?
I've got the notes. I have the email here, and I have the notes on the redactions, and I will make it happen over lunch.
So our court observer, Jules, is going to be calling in as soon as they break here.
I'm not. Did you redact the rest? I wasn't.
Okay. The only thing that's coming in on that very top email, the 739 email.
Can we have it large again, please?
Make it big for those in the back.
Thank you. Is the very first line, which comprises 3 sentences, the one that starts not yet once. That whole line stays in. And then the only other sentence that will remain in is the sentence that says, plus we are exercising our right to listen in on the calls the best we can due to Maya's recent scratches self-inflicted. Everything else will be redacted.
Your Honor, this is a bit nitpicky, but the two signatures there that just say sent from my iPhone, and we keep those.
Can you scroll it down so I can see what it says?
Just says at the bottom of the screen here, sent from my iPhone.
We want that and the Johns Hopkins logo at the end.
Not dependency court related.
Okay, thank you.
And then, of course, the next email in that chain, the 219 email, will stay in. And then the email below that,
we will redact consistent with the previous ruling.
Exactly. And so when you tender the redacted version, this will be called 2277-630A and 631A. And so the court will receive the A version as redacted.
Judge, I just like to reiterate our objection. We're going deeper and deeper down the DCF and dependency rabbit hole.
I don't think so, Mr.
Particularly
Hunter.
in light of the last two depositions and the court's rulings on our objections. So I feel constrained to put that on the record, Judge. We're parsing a course that can't be parsed. And I just have to object here.
And I appreciate it. And let me just give you my rationale, and then I've got to run. There are obviously causes of action that I have not allowed in because of Chapter 39 immunity. I don't have that order in front of me. I don't have the buzzwords in front of me. But it was, anything that was as a consequence of the call, and the actual dependency hearing is, obviously a consequence of the call. And I think I've been very clear about that. But there are other counts, including the medical malpractice, because Maya was a patient at Johns Hopkins Hospital concurrent to the time of the dependency court action. And there's also other counts, including the outrage count, negligent infliction of emotional distress, plus others. And so there is evidence that could be down the dependency court, but also is relevant to the other causes of action. And what I have been attempting to do is, wherever I can, to excise out anything that is purely dependency court. But if it's something that goes to a medical malpractice or one of the other counts in this case, even if it specifically or somehow references the dependency action, I'm leaving it in because the jury already knows about the existence of the dependency action. They're going to be instructed, and we've already somewhat instructed them, that the hospital is not responsible for Maya Kowalski being there and could not discharge her against a court order. So I don't believe that the evidence that has been coming in is improper, given the causes of action that are actually pled that are outside of the Chapter 39 immunity. And with that, Mr. Altenburn, you get 15 seconds. And then
that's all I need. I just got to say, I need to review. We've been doing the objections in your rulings on the depositions in this kind of wholesale fashion, so I don't get to see all of this. But there was a massive amount of information in Dr. Napolitano's deposition about being held prisoner and this and that and the other thing. And keeping in mind that count 14 is only a negligent training count, there was things way beyond that. And then we're talking about things that appear to be going to punitive damages that are after the fact conduct. None of that is admissible for punitive damages. So there's just a pile of things that got in that deposition that, Your Honor, I respectfully think are error.
Well, I appreciate that. Assuming that those questions were designated as objectionable.
Yeah.
The judge has a lot of respect.
Some of them were, but then there were some of them in there that didn't, that sounded to me like I don't remember reading any of that. So I think some of what you're talking about wasn't actually designated. But I mean, I've been trying to rule the way I just articulated it just a moment ago. I mean, that's what I did last night with Dr. Is it Newberger? I mean, I sustained a whole bunch, but I let in some stuff. I cut pieces and,
Judge, like, I'm doing the best I can here, guys.
Look, I'm doing everything I can to be fair to both sides with the causes of action that are allowed, those that are not allowed, and that's the way I'm going to continue to roll on it.
Certainly before Dr. Cochran's testimony, I filed a motion, I think on Sunday, trying to limit some things as to relevance because of these things.
It's a long 15 seconds.
Well, I think that's what Mr. Hunter said, and I said that we were going to need to do it, and I really need to go. Judge Moreland is on time all the time. Bye now.
Okay, so now we're officially in break. We're expecting Jules to be able to call us right now. Jules has been a court observer since the get-go on this case and has been keeping copious notes. So if you have questions for Jules, we're probably going to steer clear of questions that may venture into the invasive towards the family. Particularly here, Jules has made a connection with the family, and they've shared things with her in confidence, and so we're not going to broach that subject and be respectful of that relationship and their trust in her. But Jules is a true crime addict. She is, and she's going to be calling here in just a second. Just waiting before we go to lunch, and we'll do that. All right. Any updates with the Facebook post? No, we haven't. I'm really excited to hear this motion to limit or exclude Dr. Cochran's Cochran's. I cannot say that name for the life of me. His testimony. I would love to hear what they don't want to have brought in. That's gonna be spicy as well. Lunch is gonna be short today. I can tell you that. Can we ask the jury's reaction to the last hospital stuff? We'll ask all about that if she's able to call here. She might be on the phone with somebody else. Obsessed with Truth says, I love that you put my comments up. Sometimes it makes my day. I feel valued. Lame, I know. But I just want to say I appreciate you. Love this community and our captain. Thank you, Obsessed with Truth. I try to put up comments that are relevant to the discussion at hand that we're listening to as much as I can. Just with a lot of people in chat, it's hard to put all of them up. And I also get sucked into the happenings of the court and forget to put anything up sometimes, so I apologize for that. All right. I think we've got Jules on the phone here now. Let's see.
Call from Jules.
Hey, Jules, this is R.A. Thank you so much for calling back. How are you doing?
You're very welcome. Sorry it took me a minute. I ran to McDonald's.
Oh, good.
Sorry.
Get yourself some sustenance. It's going to be a long day, apparently. The judge says we've got a lot to do this afternoon.
Yes, very much so. Yeah.
Today started off a little bit spicy with the back and forth. What was your take on all that?
Well, it didn't surprise me on it at all. I mean, this has been going on since day one with the spiciness. It just depends on who it is. Hunter and Hughes definitely were on a roll this morning. But, Greg holds his own, Anderson, that is. And what they tried to accomplish, they did not. The judge ruled against them. There's been a lot of speculation. I try to stay off the chats as much as possible because there's a lot of criticism out there on the way the plaintiff's team is handling things. And I want to make something really clear. I'm not sure if you're aware of this or not, but this legal team does not come from this area, okay? And there were a lot of law firms that wouldn't touch this case with a 10-foot pole.
That's a great point. Nobody wants it to go up against Johns Hopkins.
Right. And no one in my area, and within the surrounding area wanted to take on this case. And so Greg took it on, and he's paying his legal team and everything, and you know, he's not getting paid.
Yeah, it's all contingency,
Now,
right? He
It's
doesn't.
all contingency. It's all so, you know, if they lose big time.
Yeah.
But if they win, that's when, you know, Greg will make money. He is not from around here. And like I said, he took this on when no one else would. Also, the gist around town, around the county was, this is never going to get in front of a judge. And then it got in front of a judge. And then it's like, well, the judge is never going to let this trial go forward. Well, here we are. Yeah. We're in front of a jury. Yeah. So, you know, I just wish the criticism of Mr. Anderson and Mr. Whitney and their entire team would stop.
Yeah.
That's all.
I appreciate that. That insight is helpful, and I admit that I'm partially to blame there, because I've been critical of some of the things he's done. I think he's had some great days, and I think that the testimony we just heard in the depositions today that he elicited, the questioning, that was very, very effective and very helpful for the plaintiff's case. So we're excited. We're excited to hear more.
Yes, it is, and you know, he does falter at times, but when it comes to legal arguments, you can't beat Greg Anderson. You can't. But I admit, when it comes to cross-examination or direct examination, it's tough.
Yeah, and you can't be an expert in everything, but he clearly is very good at his job. I mean, he didn't get there, you know, being average, and he got this far because he's good at what he does. So we're looking forward to more great stuff from him, and that's great. Tell me a little bit about the jury, specifically today. Was there anything notable in the jury's reactions to the testimony they heard from these depositions?
Yes, let me get my notes out to the right spot. Okay. Well, I'm sure you saw in the morning how Hunter pissed the judge off.
The judge needed a break.
We'll go right behind
Splash some cold water on the face, take some deep breaths, and then he came back in.
Okay, so with Beata's sister, Regina, jurors number 4, you do know what the makeup of the jury is, right?
Yes.
I don't have to go over that. So, okay.
7 and 5.
So, okay. Jurors 4 and 5, they're female. They sat there. This is the first time I can honestly say during the entire trial. They sat there with their arms crossed and kind of had a stern look on their face. You know, no one was they weren't writing anything down. Kind of indifferent. And juror number 8, listen, these are my personal opinions. I want to make this real clear.
No, that's good.
I'm not a lawyer. I'm not a jury consultant. I'm not a body language expert. I'm just going by me. And but juror number 8, a lot of the time seems disinterested throughout the entire trial. That's my opinion.
Yeah.
And again, it was the same way. Juror 12, I love this guy, and I sure hope that he's not going to be an alternate.
Do we know if the alternates are pre-selected or if it's random? How does this judge do it?
Random.
Not random.
It's it's yeah. So we don't know, but juror 12, he's I'm very bad at guessing ages, but I'm going to say somewhere to mid to late 30s. He, throughout the entire trial, this man takes copious notes and asks the most questions. Well, when Beata's sister was on there, he was smiling, he was nodding his head, and then every time Hughes got up to object, he would, do that ever so slightly shake of his head back and forth. And so juror 12 definitely liked Regina. I couldn't get a good read on the rest of them. They were paying really close attention to the screen, but no one was writing anything down. The only time that they looked up was every time Hughes got up to object, and it was Hunter who would turn around and tell Hughes to object. So there you have that.
The dynamics in this courtroom are a blast to watch. They're so much fun to watch lawyers doing what they do best. It's been a spicy trial. A lot of these civil trials do bring out the spiciness. Let me ask a little bit about the judge. The judge's frustration that we saw this morning. This is the most we've seen him frustrated, but this is the same theme that we've heard pretty much since the get-go. His frustration with this court case. I know there was a time this morning when the defense was saying, in all these depositions, when we've asked these depositions, we've been seeking the 2015-2016 organizational chart, and we still only have 2012. We've been trying to get it for years, and they found it within 5 minutes after the judge had his "I'm not putting up with this anymore" moment. What's the take you get from the judge? Is he going to just be like, look, I've had enough? Is there going to be sanctions? There's going to be, are we going to have more blow-ups?
The other day, I can't remember which incident it was. Was it yesterday, maybe? I can't remember now. He did threaten sanctions.
Yeah.
Is he going to? I've sat in enough of trials to say I think the threat of a sanction is enough. I think it's highly unlikely unless someone really crosses the line big time.
Yeah.
But he's threatened sanctions on 2 occasions already.
Do you have a count how many times a threat of mistrial has been brought up? I know one day both the plaintiff and the defense argued for a mistrial and argued against it the same day, which was sort of interesting. But 4 times?
4.
Wow.
4 times, and currently the defense has a motion for mistrial that Judge Carroll hasn't even looked at yet.
Okay, so we'll get to that next time we have a break of time without the jury present, I'm sure. I forget the gentleman's name, but the older attorney who sits in the back, who deals more with the jury instructions. I
can't stand that man.
I think the judge has a lot of respect for him. I think he was a prior judge and actually was over the current judge. So there's a relationship there of some sort. But
correct.
He can't.
That's absolutely correct.
He can't seem to get any time in front of the judge. It's like he sits in the back, and everyone else takes up all this time. He's got stuff that's been pending since day one that the judge just hasn't had time to get to yet. So one of these days, it's just going to have to be business all day.
And he's going to be the one, and that he's the one that's going to be doing the jury instructions and also setting up the appeal issue.
Yeah. Well, I've got a lot of people in chat.
He's a former.
Yeah.
Go ahead. I'm sorry. Go ahead.
Sorry, I cut you off. I apologize. I've got a lot of people in chat asking about the jury's reaction specifically to the depositions today. We're talking about Dr. Napolitano, Dr. Joseph Perno, maybe Dr. Vose as well. But did you see anything during that time that piqued your interest?
Yes. During Dr. Perno, it was 1, 2, 4, 5, 6, 7, 11, and 12 doing the note taking. They were very attentive during Perno's. A couple of them were frowning, especially number 12. and again, 12 takes copious notes for everything. So yeah, those are all the ones that were taking the notes, paying very, very close attention. And when it came to the jury question, it was juror number 7 who had multiple questions, none of which obviously could be even spoken about. Yeah, so that was Dr. Perno. Let's see. And then Dr. I can't pronounce that name. Napolitano, whatever. You know who I'm talking
Anthony
about.
Napolitano. Yep.
Yeah, him. 2, 3, 4, 5, 6, 7, 9, 10, 11, and 12. They were all taking notes. 12 was ferociously taking notes. They were not, listen, they were not happy. They weren't happy with him or Perno, but I'm going to tell you, it was Vose that they were really disgusted with.
Wow. That was the text, the ketamine girl text.
Messages.
Yeah.
Yeah. They were not, I saw as they were writing, and shaking their heads. Their number 3, he's a cute old guy. He's very animated, in the court, and he was like holding his chin and just like shaking his head back and forth, looking down. And it's because Ketamine Girl came up quite a bit. And these text messages, so everyone knows, the defense tried very, very hard on several occasions to not get these text messages in, and they kept saying, well, we don't even know what's the relevance here. How is he going to bring this in?
Yeah, we found how they brought him in. Yeah, if they had been successful at keeping the messages out, that would have precluded this testimony as well.
Correct.
And so that, you know, they knew that this was very damaging testimony, and that was the gateway that would get them here. But yeah, amazing. Jules, I will just say we have tons of people in chat just saying thank you so much. We love you. Thanks for being there. Make sure you thank Jules. Fascinating. Thank you. I appreciate you doing what you're doing. I think we have a good description. We're watching for you. Because the family's not in the courtroom, they're not showing the side of the courtroom you're sitting on very often. Defense table doesn't get shown much at all. But appreciate you being there. Appreciate you taking the notes. Hopefully we can catch up with you again as more is going to happen in this case. We've got a few more weeks to go, right?
We have at least 4 weeks to go. Yeah. So, but this is a quick story, if you don't mind, that I would like to share, because it's not overly personal, and it's obviously not confidential anymore. But on Monday, I obviously knew that Jack and Maya were going to testify. So actually on Friday, I went to Jack and I had told him about how I had a bracelet that was baptized by Pope Benedict back in 2017, and can I have his permission to give it to Maya so she can wear it on Monday? And he said, absolutely. And then, you know, Maya and I texted over the weekend. So Monday, before I left to come to court, I got the bracelet. But whatever possessed me to grab my rosary, I cannot tell you. But I grabbed my rosary, and I got here really early. And I said, Jack, here, put the rosary in your pocket. And he's like, oh, Julie, thank you. And I gave Maya the bracelet. When Jack was done, there was a break, and I said to him outside of court, I said, you did great. And he says, that's because I had God in my pocket. And he reached in and he took out my rosaries and he handed them back to me and he said, "Thank you." And I looked at Maya and I said, "Maya, do you want to hold on to these?" And she said, "Can I?" And I was like, "Yeah." And so she put them in her pocket. And you all know
we know what happened
the jury
next.
question was.
Wow.
You know what the jury question was. And here's a little tidbit. Guess who was objecting to the question from the jury about the rosary? They weren't going to ask that question to Maya. The question, it was they didn't want the question asked. And I tapped, I don't know if she's not in court today, but the court clerk with the short red hair and Clark Kent, I usually sit behind them, or sometimes I'm on the defense side, but most of the time I'm on the plaintiff side. I tapped her on the shoulder and I said, "Tell them not to object to that question." And she's like, I said, "She's got rosaries in her pocket." And they got, yeah. And then you saw when the question was asked, she goes, "They're in my pocket."
Wow.
So there you go. There
Jules,
you go.
thank you for sharing that.
I thought you would like that. Yeah, it's common knowledge. It's not, it's not that I am revealing anything of a confidential nature. That's just my little thing between me and Maya. Anyway, I hope that was helpful.
Jules, have a fantastic day. Thank you so much. We'll watch for you in court, and good luck. I hope you don't get like writer's cramp as you're writing all your notes here. We appreciate all the tidbits you offer us. Thank you so much, Jules. Get yourself some lunch and a little
You're
break.
You're very welcome.
We'll see you. Thank you.
You have a great day.
Bye.
All right, bye-bye.
Thanks so much to Jules for calling and updating us. That is cool. We have to take a lunch break, so you guys get a little bit of lunch, but we're coming back in like 15 minutes. Is that right? Somebody can tell me if we can come back when we come back. I think it's 1:15 we have to come back. So I basically get time to run, fill up a glass of water, drink it, come back, sit down, and go live again. That will be it. But thank you, all of you. Appreciate all of you for being here. Let's see. We have someone tell me the time. I'm watching the chat here. Court's coming back at 12:15. Oh my goodness. I'm not sure if we can break. Maybe we can sit on a splash screen for a minute. Do we not break and just continue? If court's coming back in 15 minutes, I'd rather not end it and start over. I need to get a drink of water or something because I've had no water this morning. I'm thirsty as I'll get out. So we'll let's do this. Let's stay through the break. Is that okay? If you give me a couple minutes, we'll scratch the record here and stop that, and come back. Judge said 1 o'clock. Man, all right. This is what we're gonna do. I'm gonna step up, go to the kitchen, grab a bite to eat for 2 seconds, but I'm gonna be live. We'll play a little music for you if that's okay. Do you have any requests? No? Okay, then I'll select. Let's do a little. Let's do our country twang one. How about that one? All right. Right back. We're going to do a synopsis. We're going to rehash what happened this morning. Get a Sammy. Yes, I will. Thank you very much, Sheila. I'll get some food. We're going to rehash what happened this morning. Then we're going to pick up with the court, which is going to be back here very soon. Let's see. Yep, that's where we are right now. So I'll be right back. See you guys in a few.
I was kicked back, taking it easy.
He's the guy!
Let no dead horse go unbeaten.
You're talking about stuff that is not relevant.
And now what Murdoch stole it.
There's a lawsuit.
Is that correct?
Don't miss the forest for the trees.
Are we going to address subject matter jurisdiction?
I'm not a camel.
Is that what Murdoch stole
That
it?
was terrible. I apologize.
Let no dead horse go unbeaten.
Are we going to address subject matter jurisdiction?
Don't miss the forest for the trees.
And now what Murdoch stole it.
Is that correct?
Let no dead horse go unbeaten.
Don't miss the forest for the trees.
I apologize.
Bring the camel.
All right. I'm back. Had a delicious salad, just for the record. It had lettuce, baby tomatoes, bacon, mozzarella cheese, shredded, avocado. I think that's about it. It was sort of sparse, but it was really good, really tasty. All the components were very fresh. All right. Let's see. Dilly Pickles, welcome to the gallery. Yellow Courthouse. Good to have you back with that. Appreciate that. And Bug Dugger, I'm not sure how many times you've gifted 5 memberships today, but it's been several. So thank you. Thank you very much. Appreciate that as well. All right, we're back. You want to talk as we've got a few minutes before court begins. So we're going to rehash for those that missed this morning. Hang on just one second. Let me actually do a quick. I want to turn this off. Is that working? Okay, hang on. Got to make one little change. And I'm not seeing it. All right. I was trying to make a change to some of the commands, but I'm not seeing the one I was looking for. So we'll bring that back. All right, let's talk a little bit for those that missed this morning. First of all, you did miss a lot. There was a lot of action. It started off beautifully. Mindy, thanks for the kind words. The only radio DJing I've done was in college when I took a class for it, but I did major in communications, electronic media, so I've taken a lot of television/radio type classes. It was very quick for eating a salad. I'm not quite done. So if I smile and I have lettuce in my teeth, I apologize. And it was thanks to Mrs. R.A. who had the salad ready to go for me. As soon as I stood up and got in there, it was like ready to go. She was just putting the finishing touches on. All right, so this morning, very, very spicy. Very, very, more of the same, really, as far as what the content was. We had the plaintiff or the defense who's objecting because they just barely found out what the plaintiffs are doing. They're still asking, what are you going to do? The defense says, oh, we're not going to call Dr. Hannah. They're like, what? And you see all the defense attorneys, they're like, throw their chairs back, hands up in exasperation, just like, oh my goodness. I can't believe it, right? I can't believe it. What is the world coming to? Here we've stayed up all night preparing for Dr. Hannah, and now defense tells us the morning of, we're not calling him. That was a dirty trick not defense. That was plaintiff that tells them that. Judge blows a lid. He's like, look, what time did you find out? And they said, they go back and forth. There's a whole bunch of back and forth. And the judge is like, what are you doing? What are you doing? In what world is this acceptable? You have to tell them what you're going to do. You've got to give them some notice. You can't just change everything at the last moment. The judge was so mad that he had to take a break. He had to stand up and leave and come back. I've got some lettuce in my mouth that's not going away. Anyway, sorry, a little too much information for you, but lunch was short. What can I say? Anyway, so Dr. Hannah, I don't know, Karen, I'm not sure which Dr. Hannah, what Dr. Hannah specifically had to testify to. Let's see, actually. I think Dr. Hannah was mentioned in one of the other testimonies. Anyway, so we started, instead of Dr. Hannah, we started with Regina Chmiel. Beata's older sister, I believe. She was on Zoom. She's speaking Polish. She does speak some English, but it's more comfortable for her to speak in Polish. So they had a translator there. It was difficult to. It's always a slow process when there's a translator. It lengthens the time by exponentially. And she didn't really give us a lot new. She did read from notes initially. The judge saw that and said, "Hey, you can't do that. You've got to flip those over. Let us know if you have to consult your notes." She talked about family living under communist rule in Poland. She talked about her dad being imprisoned for 6 months. She talked about the family being strong Roman Catholic. She mentioned that the kids, the family up there and the family down in Venice, really the connection was Beata, and that she was the one that would make that connection work and also be sort of like a translator and go between. And since she died, there really hasn't been a lot of family connection. Not a lot other than that was offered in that testimony. Next, we have Dr. Laura Vose, who testified by video depo. She was the one who texted about the ketamine girl and that the hospital did the right thing and the girl's better off now. Jury did not take that well, according to our court observer, who just said they were shaking their heads. They were just. Jules was saying they were in unbelief a little bit during that. What was the buffer sound? Hang on. Hannah is who Dr. Kirkpatrick sent Maya to because family couldn't continue to afford Kirkpatrick. He wouldn't have brought anything more than jury has already heard regarding ketamine treatment and buffer. Yeah, that's why they chose not to go with Dr. Hannah, because it would be more testimony about ketamine and about that same process. And so they chose not to do it that way. Thank you for the clarification, Amber. So Dr. Vose, she testifies. She's the ethics committee chair, okay? And we get testimony I've heard that basically the ethics committee didn't look into any of this. There's no, at any point that she worked there, did they look into this? There's no issue there. Jury was not happy with that. Next, we have Dr. Joseph Perno. He's the chair of the risk management committee. This guy has never attended a meeting with the risk management committee. He's like, yeah, I'm the chair, but I'm sure if something important happens, they'll tell me. And nobody told me anything, so I'm sure nothing important happened. A lot of very dismissive about things. And so it was a little bit of an arrogant response to almost everything. Little to no oversight is what he testified to, especially from the headquarters. Do we have the timestamp of this morning? Let me see if I can pull that up as while we're talking here. That would be really fun to rewatch if we've got time to view this. Let's go back. Okay. Here we go. Oh, no, come on. Come on, don't act like that. The problem is the live just ended that I'm trying to play from, and it just does not play well. So play. Give me a second. If I can replay the judge, that would be fantastic. Okay, right here. Okay, here we go. I'm just going to pull this up. Just had to jump to the right spot.
No, we're not. No, we're not putting on Dr. Cochran first. And I should have emailed you, but the decision wasn't made till 11:30 last.
Okay, so watch this. We're going to back up just a bit.
Very well. If I could, we understood that Dr. Hannah was going to be the first witness this morning. Am I now hearing that Dr. Cochran is?
No, we're not. No, we're not putting on Dr. Cochran first.
Watch the defense table.
And I should have emailed you, but the decision wasn't made till 11:30 last night. We're not going to call Dr. Hannah.
Watch this.
Don't worry about that.
Boom.
But it's not going to change things because we're still calling Dr. Cochran.
What?
But we're not calling him until the remainder of the people that we talked about are taken care of.
So after they spent all evening preparing for a live witness,
Judge blows
that you
his
told
top.
them that was going to be first up, at 11:30 you make the decision and then you don't even bother to tell them?
Judge,
I mean, how is that?
Midnight, it would have been midnight by the time I told him. I did not believe it would be any good. And
they're like, we're working
Judge,
on
they
this
sent
all
us other
morning.
things at midnight. They sent us, frankly, this exhibit list at midnight. So, and we get up early and work in the morning for the day's preparation. So that excuse is unacceptable.
The exhibit list was sent yesterday. It was pared down.
Right, I know, agreed. I'm just saying we were working at midnight, as were you.
Just saying.
and we had prepared for him as well. But we made a decision.
Listen to this
based on
excuse.
speaking with Dr. Hannah and in preparation, as part of trial tactics, that we think that the jury has heard quite enough about ketamine and about CRPS, and calling yet another doctor.
What time did you make the decision not to call?
This gets worse.
11:30, 10:30, 11:30, because we could not get in touch with him. I actually made the decision earlier, but I could not get in touch with him. And in fact, his office administrator was in touch with me, telling me that he was set to go, and I was sure. And we committed it and decided that we don't have the time to put on another 2-hour witness on ketamine and CRPS.
That's the judge
And
sign
we're
there.
down to the nitty gritty here, Judge. We just have to make some tough decisions, and I'm
Not
sorry
sure what alarm
counsel
went
is
off
prepped on it. They are getting paid to do this stuff, and I'm got
That has nothing to do with it.
Look at that. They're getting paid to do this stuff.
The whole point of telling the other side at lunchtime who's going to be the next day is so they can prepare. Do you know how wrong that what you just said is? You said you'd even determined it earlier, but hadn't talked to Hannah about it. You didn't even bother to tell them. What's wrong with that?
Judge, it was so late, it wouldn't have made any difference in our view. Why call them? And
I'm going to take a break.
11:30.
I'm going to take a break. I want the two of you to talk about what people are coming. There's got to be a different way of than deciding at 11:30 at night, 10:30 at night, 9:30 at night, not telling the other side. That is just wrong. Cannot happen again. I am so tired of how you're not telling the other side information. It's just wrong. We're going to take a break.
All right.
So judge walks out. They sort things out a little bit. They talk amongst themselves while the judge is gone. And when they come back, everyone is on their best behavior. And what's funny is the next thing that happens, the defense make a couple objections. The plaintiff comes out and says, next, we want to have a copy, or we'd like to admit this copy of the 2012 organizational chart from the hospital. And he's like, 2012? Why are we dealing with the 2012 version? And they're like, well, Your Honor, we asked for newer ones. In all these depositions, we've asked the defense for a newer one, and they have not been able to get us a newer one. So we're going to admit this 2012 one. And the judge is like, seriously? 2012 is the best you've got? Takes them all of 5 minutes. It took years. And they said, no, over years. But in 5 minutes, we found a newer one. They found a new one. That gets admitted because no one at this point wants to tick off the judge. They do not want to. The judge is in a bad mood. Yes, we need a clip of the judge saying, that is so wrong. Let's see. Just ask a normal question. Yeah, they struggled with the interpreter. That's difficult. Having to break up your bifurcating your questions, to a first half, second half. There's a big word for the day. I think I used it appropriately. Anyway, so that's where we are. Let's go back to live now. Let me make sure we get that. Return back to where we should be. I think we are waiting on video feed. Okay, still are waiting video feed there. So our live feed is available. There we go. Hold tight, hold tight. We're going to get there. 3, 2, 1. There we go. So this is live now. Waiting for the judge to return from lunch. Where did I leave off? The witness, we talked about Regina Chmiel, Beata's sister, how she testified. Dr. Laura Vose, she was the ketamine girl text doctor, and how the jury didn't like him. Dr. Joseph Perno came after Dr. Vose. He was the chair of risk management committee, very arrogant, never attended his meetings, little to no oversight. Dr. Anthony Napolitano is provided by the defense as somebody who knows about the risk management meetings and can answer questions regarding those because he attended. He's the chair of pediatric medicine. He's on the committee. We find out from him that, and from Dr. Perno as well, that the risk management committee doesn't really do anything in real time. It's all retroactively. They look back and they meet quarterly and handle issues, but no day-to-day issues are made by them. No discussion of issues in real time. There's no real-time oversight of patient care to detect improper care. They testified that Johns Hopkins has not changed their standard operating procedures since Maya's stay. And that Dr. Napolitano was over division meetings. Maya did not come up in any of the meetings with the department heads. Just very, very spicy. And really, the testimony just seems very detrimental to defense's case. And knowing what we heard from Jules about the jurors writing down things about this case, that's amazing. All right, I'm already tired. It's only 9:20 in the morning, says Rosie. Where I'm at, it's 12:20. We're about to get started, I think, in just a couple minutes. Let's see. I thought I saw the judge walk back in. I wasn't paying attention. Let me see. I've got somebody on the phone. I'm not sure who it is here. Just one second. Hey. Oh, the caller hung up. First of all, when you call, you've got to hang up your video because all I hear is my own audio back to myself when you call. Zimmy, I summarized them well because my wife told me, take some notes today so you can remember what you heard, and I've been doing that. So all credit goes to Mrs. R.A. Appreciate that. So anyway, spicy testimony. What we have pending right now is a motion to limit or exclude Dr. Cochran's testimony. I'm not sure if I'm saying that correctly. Dr. Cochran's testimony that the defense does not want in. So there's a motion. They filed it on Sunday. We heard they filed this. The judge is going to have to take that up because I think they want to bring him in next or later today at some point. Let's see. Somebody sent something to the burner. Let me see. I missed a lot of calls. I apologize. Let's see. Those asking about live chat when they rewatch YouTube. All my videos, live chat is available on them after the fact, but it takes sometimes 24 to 48 hours for the live chat to show up. So if you watch a video within that time frame, like if you watch, today's video like 10 hours after it ended, there's probably not any live chat there because YouTube hasn't matched it up to everything. Okay, here's that call again. One more second. Hello. Hey, this is R.A. Who am I speaking with? Hey, this is This is who? Sorry, your sound's really loud. I can't hear. Hang on one second. Yeah, that's better. Who am I speaking with? Granny 213. How are you doing? You're off air right now. Yeah. Oh,
we're going to address, folks.
Judge, it'd be the motion to limit Dr. Cochran's testimony that we made reference to before the punch break.
And at some point again, Judge, if you've had the chance to review it, though, Williams' motion, you have to find out about those.
Okay, here we go.
Well,
Williams' motion.
Mr. Hunter has the floor right now.
Thank you, Your Honor. May it please the court.
Just the motion to
We've
exclude.
made a motion to limit or exclude the testimony of Dr. Joseph Cochran. The basis of the motion, the main thrust of the motion is exclusion, and it is based on section 766.102, paren 7 of the Florida statutes. As Your Honor has heard before in this matter, section 766.102 provides for the qualifications under which testimony may be offered by an expert witness in a medical malpractice case. A threshold requirement is that the expert witness have reviewed under subsection 5 of the statute all pertinent medical records, which this witness has testified he has not done. Above and beyond that, however, and more importantly, the thrust of this motion, under section 766.102, paren 7, anyone who is testifying in a medical negligence action against a hospital or healthcare facility may give expert testimony on the appropriate standard of care or other non-clinical issues administratively if he has substantial knowledge by virtue of his or her training or experience concerning the standard of care among hospitals of the same type as the healthcare facility or hospital whose acts or omissions are the subject of the testimony and which are located in the same or similar medical communities. Now, I paraphrased the statute there, Judge, but the thrust of the statute is that the threshold substantively for the competence of an expert to testify on administrative and non-clinical matters against a hospital is the question of whether they have substantial knowledge and experience in the same type of hospital. This witness has never practiced in a children's hospital outside of medical school over 30 years ago. He has never been a CMO of a children's hospital. His experience as a CMO or senior executive official in a hospital setting comes as a result of having served as a CMO, chief medical officer, in a general hospital, not a children's hospital, a general hospital of a different type in a different medical community than All Children's Hospital in St. Petersburg. He's in the room there, Your Honor.
And he's sitting in the room.
The doctor to be excused.
Dr. Cochran, if you could wait outside, please.
Look at that. Mr. Shapiro's rolling his eyes, shaking his head. He's in the room. I think experts are allowed to be in the room,
In any event, Judge,
but in this
that's
discussion,
the
he can
thrust
leave.
of the argument. The record has established through his deposition testimony that he's not familiar with the different levels of licensure under Florida statutes for different types of hospitals. He is not familiar with the differences in specialty as opposed to non-specialty institutions. He has no familiarity with the disease processes here at issue among pediatric patients. In fact, he's testified he's not a pediatrician. He's never been a pediatrician. He has no knowledge of the diagnosis or treatment of CRPS, the use of ketamine, or any of the other clinical issues that are at issue here. He is, by training,
They must really be scared of what he has to say.
board-certified OBGYN with no pediatric credentials whatsoever, who has never practiced significantly in a pediatric hospital.
Do pediatric hospitals use a different coding system than other hospitals?
Coding system in what respect?
For billing purposes.
I'm not aware that they are, but on the other hand, he's never been provided their billing records.
Yes, he has. Yep, he sure has.
Okay. Anything else,
Yes,
Mr. Hunter?
According to his deposition. That's what we have, Judge, and the alternative part of the motion is that his testimony be limited to those matters with respect to which he can furnish familiarity. If Your Honor is suggesting that perhaps if he's properly informed regarding billing, that would be a potential exception. But as a matter of standard
When was
here-
this deposition taken of Dr. Cochran?
Deposition was taken, Dr. Cochran, sometime recently. Judge.
August
He
1st,
was-
2023.
He was the one that, Your Honor, let them add late at the last minute. It was taken you said August? That's probably it. That sounds right.
August what?
August 1st.
And so this motion is coming in
We
on.
didn't get the transcript before the deadline.
Transcripts can be had in a day or two. I'm just wondering why, because we had so many of these hearings before trial. Why, when we are with lots of people here and people ready to go to testify, that we're having this conversation now as opposed to, the day or the week before trial even started? Why wasn't it filed by then?
Judge, we thought we would file it at a point where we had a complete picture of what he had reviewed, and we had the opportunity to put it together. And
But if the deposition was on August 1st.
I'm sorry?
I said if the deposition was on August 1st, why wait 2 months to file the motion?
Thank you, Evangeline Light. Appreciate that. 5 memberships.
The reality is you want me to make a decision, which these motions take a lot longer than the snap amount of time that I'm being given on this.
Judge, in years past, we would make this motion after voir diring the witness at the time on the witness stand.
I don't know. How many motions in limine to exclude various doctors and opinions have we had
We
in
had,
this case?
Judge, we had a number of them. We had a number of those in June, July, and others in August. This doctor got deposed late. He never got a report to us till very late. And
His report was timely on June 10th, 2023.
I'm going to hear from your side in a moment.
Judge is reading the motion, I think, right now.
I don't know what to do, Mr. Hunter, because I feel like I'm being jammed on this. I mean, he's here, everyone's waiting, and you're asking me to make really substantive, substantial rulings on things that I would have liked to have actually had some time to think about and to, read it in more detail.
Judge, I regret making you feel that way. That's not my intention. There's a number of us getting jammed about a number of things in this matter.
Mr. Whitney, what's on your side?
The relevant section of the statute is 766.
Well, first off, tell me what this doctor is going to be testifying to. Let's start fundamentally.
Well, that's probably better Mr. Anderson's question.
He is a hospital administration expert, Your Honor. He has analyzed the rules, procedures, routines, forms, releases, and the internal documents of Johns Hopkins All Children's Hospital. He is offering opinions about the failure of the systems within the hospital to prevent many of the situations that happened here, including Kathy Beatty and treatment of Maya Kowalski and the overall treatment of her through her stay. He is opining as to whether the hospital had sufficient control to advertise itself as Johns Hopkins All Children's Hospital, given the fact, as just testified to by, I believe, either Dr. Perno or Napolitano, that there's absolutely no control whatsoever over them by the Baltimore company. He's also testifying about the lack of training in the first part. In the second part, she probably shouldn't have even been anywhere near Maya Kowalski in light of the aggressive the memo regarding aggressive behavior and the extent to which the aggressive behavior was known and how unusual it is for the type of report that was filed against Ms. Beatty to be in a hospital, and the fact of threats of physical violence by one employee upon another are a very grave allegation in a hospital, particularly a pediatric hospital. He will testify, and thus that Ms. Beatty should have been sent back if they wanted to keep her for significant training, which they failed to do, or she should have been released, or at the very least she should not have been put in to be whatever you want to call her towards Maya Kowalski with very little control. He's going to testify to what you heard from Dr. Perno and Dr. Napolitano, the fact that there was absolutely no real-time review or risk management
Jules is in the
of
black and
events
white.
as they happened or within close proximity of them happening, sufficient to put a halt to things that were ongoing. He will testify to this was a fox guarding the hen house situation because of the way that Johns Hopkins has set up its monitoring system such that you had people who worked together all the time, if not totally, were counted on to report about each other in the event there was any violation of Johns Hopkins internal rules. He'll testify concerning the internal policies and procedures of Johns Hopkins Children's Hospital. Instances include their elopement routine, their their minor leaving AMA routine, their failure to express the patient and family rights and comply with them in the handling of the Kowalskis. That is a summary of his testimony, and it is set forth not only in his deposition, but in his report. I'll find the date of the report. It was filed timely, as co-counsel has stated, but he filed that, and he also filed, the court may recall, an affidavit, I believe, in support of punitive damages, in which he went over many of these points, I think almost all of these points, and that affidavit is April 12th, 2023, prior to one of the final motions on that. So the defense has had an opportunity to receive a report, an affidavit, and depose him extensively, at which point he covered these issues. All of the things he's testifying to are in evidence.
If you need further on the statutory argument, please let me know.
I'm still trying to read, and that's why I say I got jammed on this one. I don't know how you want me to do a quality job at making well thought out decisions without giving me the time to do it. I mean, I can make rulings, but I like trying to think through what's being requested of me, get a chance to actually read the depositions, and I'm still trying to read his report right this second.
Judge, I appreciate that. Some of the stuff that you're hearing is clearly outside of the pleadings that have been put forward. The count 11, for example, has been walked away, walked back. He's being put forward as an all-purpose expert regarding a very limited specialty hospital, and that, I suppose, is the point. And I apologize, but I didn't perceive that as being a matter that required that much forethought. And if that's my bad, that's my bad.
Well, if you're making the argument that he has never been the chief administrative officer of a specific children's hospital, And you're contending that that is the requirement under sub 7 of the statute for him to be qualified. Is that the argument you're making?
Yes, sir. I'm making the argument that someone who's going to criticize the standard of care of a specialty hospital under the statute needs to have substantial knowledge and experience demonstrated of their ability to know and be familiar with the standard of care for the same hospital. That's the clear black letter law of the statute.
What do the cases say interpreting the statute? Since
there's very few cases that interpret this statute as opposed to the statute under 766.102(5). No. But under 102(5), the cases are very clear that it's got to be that the expert witness against or for whom a witness is testifying has to be in the same specialty. This requirement is essentially the same thing as applied to hospitals.
Your Honor, subsection 7 begins, notwithstanding subsection 5.
Considering that I wasn't given the opportunity really to think about this or review, can someone give me a case interpreting the statute so I can actually see what courts have said about this statute?
The primary case they cited, the only case they cited, is Santa Lucia versus Levine at 198 Southern 3rd 803. And that case does not discuss the relevant statute. It doesn't even discuss 766.102. It discusses a separate part of the statute under 766.103. So we don't yet have a case.
Judges hate to be on the forefront.
Cases we cited, Judge. Neither one of them construes this particular subsection of the statute. That's why I said what I said a moment ago. The point, however, is that under this statute, which was amended in 2013 to require it tightened the similar healthcare provider requirement for giving expert testimony and required expressly that you have to have an orthopedic surgeon, for example, to testify against an orthopedic surgeon.
What was the law number?
I'm sorry?
What was the law number that was the change? I mean, these are things that I would normally have done so I can actually understand what the legislature has done.
The laws of Florida citations were 2013-108 and 2011-233.
So Judge is going to look up this law. It sounds like these laws were created using, let me just say it.
I believe the latter one in 2013 is the one that tightened the similar healthcare provider provisions, subsection 5.
These are medical malpractice laws. And it sounds like they're made favorably for the medical companies. Judge is frustrated. He does not want to tread in an area where nobody has gone before. Very few judges like to do that. That's dangerous ground for a case. So he's looking for precedent here. Having found no precedent, we're going back to reread the law to see if it spells it out. And if it's not specific, he may side with the plaintiff here on this one just because of the lack of time to be able to do this and say it wasn't a timely objection. So unless the law here may, and I don't have the Florida laws pulled up in front of me, but the law may be very specific in this area and defense might be right on. And he might be precluded from testifying in part or in whole because of that. But the judge is
213-108 laws of Florida.
He's going to read it here, maybe.
Doesn't say what you said it says. So what's the next one?
No.
2011.
He's over it. Judge is making his decision.
I don't know what to do, Mr. Hunter. I don't feel like I am ready to make a decision on this issue. I feel this is way too late. I mean, if just looking at the statute, what you're saying is because he has never been a pediatric hospital administrator, he is not eligible to qualify under the statute. I think you're probably reading the statute a little too narrowly, but again, I haven't had a chance to do it. So if I have to make an on-the-fly decision, I'm going to overrule that because you haven't shown me any case law that would construe it that way, and if I got to make a decision without any chance of reflection, then I'm going to say no.
Judge, I would simply point out to you that the plain language of the statute requires substantial knowledge and experience with respect to the same type of hospital. That's the purpose of the statute, as obvious on its face. That's the objection we were making.
Well, I don't believe the word same is in the statute.
I'm sorry?
Oh.
Your Honor, it does say of the same type as the hospital in subsection 7. I wanted to clarify the factual point, which is that
Same or similar communities, and he was the head of what, Brandon?
he was the head of Brandon, correct?
It's all part of Tampa Bay.
He was the chief medical officer of Brandon Hospital, which has a pediatric hospital within it. And in fact, he affiliated and collaborated with Johns Hopkins All-Children's Hospital in establishing the standard of care at Brandon.
I think he's coming in.
Is that true?
Not to my knowledge. He certainly didn't say that in his deposition. He did testify in his deposition that at Brandon, his hospital, not him, he didn't service the contract, his hospital hired pediatric ER doctors and pediatric neonatal intensivists to come in and run portions of their hospital. But he also said that he had nothing to do with either making or servicing those contracts. So I don't construe that as assisting them in making the standard of care. If Your Honor will look at the statute, it's a matter of his having knowledge and experience in the same type of hospital and in a similar community. It's a two-pronged test. Now, the similar community is wishy-washy here, but the same type of hospital is clear. I'm sorry?
It says or, right? Not and, it says or.
It says the substance testimony and which are located in the same or similar communities at the time of the alleged act giving rise to the cause of action.
And if you're suggesting that Hillsborough County and Pinellas County are not the same or substantially the same.
No, sir, I'm not suggesting that. I'm saying that what I'm suggesting is that the same type of hospital is the primary standard here. And he has not demonstrated that level of knowledge.
So you agree it's the same community?
Yes, sir.
Okay, so you're only talking about
same type of hospital. And Judge, with all due respect, this objection would be perfectly appropriate at the time he offered the opinion.
Except that the court set a prior deadline.
Except the court set a prior deadline.
For a moment on the or that the court points out, same or similar communities, in addition to being the chief medical officer of Brandon and Pediatric Hospital there, and affiliated with Johns Hopkins in those efforts. He was also the division chief medical officer for HCA Far West Division, and he oversaw Sunrise Children's Hospital in Las Vegas. So Las Vegas and Tampa are substantially similar.
Now, there's a leak.
Well, they both have football teams. Both had John Gruden as a coach.
I would suggest to you that they're the similarity then, Your Honor.
No,
It's coming in. I think the judge is allowing it. Judge is reading into his hand.
Where else has this doctor been? Remind me.
Hospital Corporation of America.
Yeah, he's been an executive with HCA Hospital Corporation of America. In that role that I just mentioned, he was the division chief medical officer. I think he'll say he oversaw 10 hospitals in that role, and the one I mentioned was Sunrise Children's Hospital.
It's Hospital Corporation of America, the largest hospital.
I know what HCA is.
I know. It's coming in.
Mr. Hunter, what I'm hearing is, from a factual standpoint, he may qualify even under your definition. That's about the best I can give you right now, given that I wasn't given time to prepare for this.
Sorry, what did he say?
Mr. Altenberg?
Yeah, if I may, beyond his qualifications, I'm going to be instructing my trial guys to object a lot because of the scope of the pleadings. There is no risk management claim under 766.166 expressly in count 8. Nothing in there alleged a management thing. It was diagnosis and having a treatment plan is what's in count 8. In count 14, the smorgasbord is now down to a negligent training claim only. And it only references 766.166 in paragraph, I believe it's 170, to say it's sort of like this. And so I was listening to opinions that might have been appropriate when count 11 was in, but count 11 was voluntarily dismissed. So anything about the training or the not the training, but the background on Miss Beatty and whether she was disciplined in the past is not relevant to this.
Your Honor, as you're aware,
Excuse me.
Yeah, let Mr. Altenberg finish.
It's done.
At any rate, we need to keep this within the scope of the pleadings. And it sounded from what I heard, numerous things were going beyond anything that is left at count 14, and there's no risk management claim pled in count 8 except by incorporating that which is in count 14.
Are you done?
Yes.
All right. Hold on a second.
Are you done? Oh my goodness. That was a little snippy. Plaintiff should not have stepped in there, but defense also should not have stepped on his toes as soon as he did.
So, Mr. Whitney, you're telling me that Dr. Cochran, when he was administrator with HCA, had under his constellation of hospitals a pediatric hospital?
Yes, Your Honor. And as CMO of Granite Regional Pediatric Hospital within it.
Now, how about Mr. Altenberg's point about the scope of the pleadings?
Sure. The scope of the pleadings also includes punitive damages claims. And under 76872.
On battery and false imprisonment.
Correct. And we have to show and demonstrate the ratification or active participation or condoning of these actions by management. And he can speak to all of this because of the violations of internal policies, the failure to train Catherine Beatty, which is pled, in her anger management issues, allowing her to continue over this child, leading inevitably to the battery and false imprisonments and all the other misdeeds that she committed against Mike Kowalski, as she's testified to here.
This is a big witness.
Management and risk management are materially relevant to our case here. The issue of risk management not only is subject to our pleadings, but has been up to the second DCA, as the court's well aware. So the nexus between risk management and mismanagement of this hospital has all been part of this case for now 2 years.
Hold on a second, please.
Reference is being made to Ms. Beatty's prior arrest.
No.
No, it was not.
That's out. In the hospital. And I think I struck that last night as well. All the questions.
You did, Your Honor. I thought I saw it referenced in some of his testimony or affidavit.
That could be. That could be.
I missed. What are you arguing?
Your Honor, additionally, on the pleadings, outside of the punitive damages argument, count 8, which is the medical malpractice count, incorporated count 14, which is the negligent training, supervision, and ratification of the physicians.
No, training, not negligent training.
And in the lead up to trial, there was an agreement between Mr. Altenburn and Mr. Elegant, I believe, he'll confirm, to collapse count 14 into count 8 to avoid another jury instruction on this issue.
There was an offer, and there was never an acceptance because they never gave me jury instructions that could fit there. There's no agreement on that.
Then in that case, count 14 is still an active count. So
for negligent training only under a common law theory backed up by 766.166 and a reference to a Bill of Rights, which is a piece of material only admissible to establish a common law standard of care. There is a statutory Bill of Rights provision in the Florida statutes. It has no private right of action. It has a different penalty.
Well, we've consumed all this time. The bottom line is, I guess he's testifying, and there's going to be lots of objections, and I'll just have to do the best I can with the rulings on the fly.
It's going to get spicy.
Are there any other motions that are going to be very substantive like this that I need to know about so I can be ready for them?
So I can duck at appropriate times.
Thank you.
From the plaintiffs, there will be.
Well, let's get them quickly because...
We will.
From the plaintiffs, there will be more. Get ready, Judge. Okay.
I guess we didn't get anywhere. Exhibits, so...
Do you want to handle one or two, or you just want to... I'll leave it up to your honor.
Are they needed for this witness?
A couple of them.
If they're needed for this witness, then let's do them.
Here we go.
What do you need? Oh, I say that.
Remember that what do you take for a headache commercial? I think the judge is about to star in that. Was that an Excedrin?
Mr. Whitney?
An old
Which one or ones are we talking about?
Just a moment, if we could.
I'm sorry?
If we just have a moment to decide which one Mr. Anderson would like for this witness.
We don't argue with things that are either already in evidence or we don't need from this.
All right, we'd like to address Exhibit 2277, pages 245 and 246.
The doctor's testimony is coming in over the objection of the defense.
Put it up.
We're now talking about exhibits that may be presented during this testimony. We're going to see that here now.
Your Honor, we recognize that there would need to be redactions. I would focus the court on paragraph number 3 in Ms. Salisbury's email regarding billing.
Judge, this is the DCF attorney writing an attorney for the hospital regarding DCF matters and things that she's concerned about.
I think it's the Kowalski's attorney.
Yes, I'm sorry. The Kowalski's attorney writing the hospital in the DCF hearing.
How are you intending on using this?
Notice, Judge.
Notice on what?
We brought to their attention, if I could, yeah, I got it. I have reviewed records indicating the child is being treated for, quote, complex regional pain syndrome, I guess this is the code, and it gives the code, medical confirmed, would like verifications. Further, I would like an explanation of what medical confirmed means. The purpose of this is to demonstrate that it was brought to the attention of the hospital during the course of this on November 11th, and it starts out a printout of the child's diagnosis.
My recollection is the hospital agrees it was billing under the CRPS. I don't think that's an issue in the case.
No, it's not an issue in the case anymore, but the timing of it is when they were notified of it and whether they continued to do it.
Okay.
What does that have to do with anything?
Well, I think it would go to our fraud count regarding the billing as to whether there would be the required clear and convincing standard on it, that it was brought to their attention. They knew what the problem was. They chose midway through her stay to continue to bill for serious.
It's to one of the lawyers here.
The way we were hoping to fix that was simply to delete names and just make it to
The
defendant.
unfair prejudice of this exhibit outweighs any probative value, even if I were to figure out a way to splice it to only get to that small paragraph.
I understand the court.
That's out.
This judge needs a hug. Judge Carroll needs a hug, you guys.
What's the big highlighting?
2277. No, I'm sorry. 2123, pages 833 to 837.
Family's not there today, apparently. They weren't there yesterday.
That's already in.
That's submitted.
That's already in. My apologies. So if we have time for one more, we would like to address 2277-453. Yes.
Put it up. What is this?
That's exactly the point, Judge. It's undated notes that somebody's going to have to interpret. Nobody's going to testify as to who wrote the notes, what they mean. If somebody picked up my notes from today, they would have to interpret them and try to figure out what the heck they meant.
We can withdraw on that.
Scratch all that. Oh, that was terrible.
It's from the risk management
Scratch
file
all
at the
that.
hospital.
Did
It's-
Mr. Anderson just say he will withdraw?
Well,
Yeah, he did.
Okay, then let's go to the next one.
there was one of these that had Ms. Crane's note on it, and that's what I would have thought this one was. Nursing notes pull out. Nursing notes pull out. Do we need it for this witness?
Okay.
Yeah, I don't think we need it for this witness.
Does anyone need to take a break before we start?
Other than
We've been
the
here
judge.
for 40 minutes, or anyone want to take a break, or you want to get going?
I think we have time for a break if the court would like one, simply because we've got. this
I'm
witness-
fine. I'm just asking the lawyers if you want one.
The defense would like a 5-minute break, right?
Let's take a 5-minute break then.
Okay. Welcome back from lunch. So this is ding, ding, ding. Afternoon session. The fight is about to begin. Spicy after lunch. Most of the discussion we've had this since lunch was on the motion from the defense to exclude in part or entirely Dr. Cochran's testimony. Now, he is the doctor who, according to the plaintiff, is going to testify as to the violation of protocol procedures, all the hospital norms and rules and policies, because he is a hospital administrator. So he's going to look at the Johns Hopkins All Children's Hospital policies, look at how they behaved, look at the records from the hospital, and say, here is where the hospital didn't follow their own standards. This is where the hospital made mistakes, and had they followed their own standards, this would not have happened. This is obviously very damning testimony for the defense. They fought very hard to keep this out on many different fronts. They brought up arguments, predominantly first, Mr. Hunter brought up the argument that the witness is not qualified to be an expert witness, okay, under Florida law, Florida has some very friendly laws for hospitals regarding medical malpractice suits. And they say the law states that he has to be, if you're going to testify against a hospital, you need to have had prior experience and expertise in a similar hospital in a similar type area, basically limiting the number of people who might be able to testify against a hospital. Very friendly legislation. Imagine whatever field you're in, if there are laws that protect you, these are very protectionist type laws that seem to probably have been made with the help of a lobbyist from the hospital. I don't know. We won't go there. But the hospital defense is saying that he's not an expert. He needs to be excluded for that reason. He didn't review all the pertinent medical records. He goes on and says there's a challenge to his experience. He's not worked in a children's hospital before like this. He's not familiar with the different levels of licensure, specialty versus non-specialty physicians. He's got no CPRS experience. He's an OBGYN. This has nothing to do with a children's hospital. Defense comes back and says, hold the phone. He's managed some of the 10 hospitals, including Children's Hospital, include the one he was I forget what it was, the head of was had a children's hospital within it, and basically just the guy's like overly qualified, not underqualified. The judge was most frustrated with a couple things. The motion that was sent to him was given to him in the last minute. He's addressed most of these previously. The motion cited some case law, but didn't have anything to do with like the actual motion they were making, the substance of the motion. And so he's sitting there looking at a law on the books, and that was thrown at him in the last minute, and he's got nothing to base his, no prior ruling from another judge. And judges hate to break ice. Okay, a judge will never win first in chat. Okay, they don't go where other people haven't gone before very easily or very willingly. And so this judge is like, show me something I can base my ruling off of. I don't want to be the guy who leads the charge on this one, finds out I was headed the wrong direction. So he, what can he tell you about the Kathy Beatty arrest? Only that the judge said it's not coming in, and there was one, but it's not coming in. That's prior ruling. So the jury's not going to hear about that. Anyway, so a lot of argument over this. Clearly, the hospital, through their defense attorneys, do not want this testimony to come in. And we're going to see objections throughout this testimony, probably to almost every question, if not every question. So the counter is going to be clicking. It's going to be clicking like crazy as we're going through this. Let me make sure the sound's a little... Was this too loud? No, that's not too loud. Let's see, where's camera 6? Why do I have no sound on this one? Oh, I know why. It's because I turned the sound off, that's why. All right, well, the counter's going to work even if the sound doesn't. So, Lauren Farmer, we have not read up on that because the jury's not going to get to hear about that. So for the determinations that the jury's going to make, it's not relevant to this case, even though arguably it's very relevant to the larger issue at hand. Apparently there was an arrest at some point in Beatty's history, and I don't know much more beyond that. I'm sure we could look it up, but it's not going to be coming into court, so we're gonna avoid focusing on that. So apparently through Samantha Terry, we're hearing that the Beatty arrest was for treatment of a child, but the case was dropped. So no conviction there, just an arrest. Okay. All right. So any questions? I think that covers pretty much everything we've... so let me turn this off. I can't get my dang sound to work here. Let's see, 6. Oh, I turned it down. That's why. Nope. Why does camera 6 not want to give me any sound? I used to have a clicky sound. It was a lot of fun to hear the click every time there was an objection. All right. we get a little bit of a break. Judge is going to take some deep breaths, maybe do a little yoga, a little Zen relaxation. Arrests never come into evidence, only convictions, and generally for felonies, right? So this is not coming in for sure. Okay. We did hear Beatty testify. That was on Thursday last week, Jenny. If you missed that, you have to go back and watch. That testimony was riveting and frustrating at the same time. Stephen, at this point, all we've heard from is from the plaintiff. So it's very easy to look at this and see it from the plaintiff's perspective. There's a lot of evidence, weeks worth of evidence that the defense is going to introduce, which will present a different picture. So we really have to wait for that to really weigh in on this. But I will say that it seems to me so far that the plaintiff has proved some elements of this, their allegations. And they might have at least a partial win in the works already, if not a full win. All right. Is the hospital defense, we technically did nothing wrong, or is it all Beatty's fault and she went rogue on us? They are trying to, I think the biggest part of the hospital defense here is that we are shielded in our actions from the Title 39 actions, from the dependency court ruling. We are protected under Florida law from anything we did then. And they've tried to fit as much as they could under that umbrella and say you can't go there. You'll hear this. You have to separate this. You can't blur that line because we're immune. We're immune under that law, and they are. They're immune under that law for actions they take under the order of the dependency court. So they've got a lot fit under that umbrella, and I think some things even got sort of thrown out because of that protection. But not everything fits under that umbrella, and so the judge has to draw the line and say this you are still on the hook for, potentially if the jury finds that way, and other stuff you're not. The judge has a punching bag in his office.
Please be seated, everybody.
Ooh, sorry.
Okay, before we bring the jury in, what witnesses are we going to have tomorrow? Plaintiffs.
Depending on the length of this testimony, we may have to push our next witness in tomorrow, which would be Jessica Blackrick. We also have Deborah Salisbury and Brian Gillis may testify tomorrow. We have a rather long deposition, relatively, of Dr. Eli Newberger and deposition excerpts of Dr. Sally Smith. And if we can get to it, the Kowalskis will begin their damages testimony.
Wow.
If I may inquire, I can't foresee what Ms. Salisbury or the other attorney, and I've forgotten his name, could possibly testify
Brian Gillis.
to in this action that's not going to invade what went on at DCF. So if we could get a proffer from the plaintiff so I know what to prepare for.
Especially with Ms. Salisbury. So what's Ms. Salisbury going to testify to?
I wish I had my notes in front of me. I know she's been instructed not to get into anything involving the DCF matter, but she was involved in sending warnings to the hospital about certain behaviors. And so, again, it goes to the notice to the hospital that Kathy Beatty was acting out as against Mike Kowalski. I wish I had my notes here.
And she can also speak to the factual scenario of the Morris transfer that we've heard a lot about.
Yes, that's right. I'm sorry.
Well, the first area of inquiry I would think would be entirely both duplicative and potentially privileged if she's going to come in and say, as the attorney for one of the Kowalskis, I was sending warnings.
Well, it's not your privilege to be concerned about.
Sorry, go ahead, Mr. Williams.
It's not only that, Judge. These matters were squarely in front of Judge Hayworth in the dependency action. She was dealing with Judge Hayworth in the dependency action, and the matters that are being alluded to were brought to Judge Hayworth's attention in that dependency action and dealt with at that time. So this is a matter, once again, of us going into matters that were before the dependency court that are not only duplicative of what we've heard already, but also were before Judge Hayworth and subject to his jurisdiction at the time.
Well, obviously, if it's talking about the dependency court, I'll shut it down, just like I've been
Yes.
on everything else.
We have big red lettered things, don't ask this, don't get into this on our desk.
But
We got Post-its all over the
there's
place.
a notice that's separate and apart from what was transpiring within the dependency court, perhaps that is relevant. Maybe it's cumulative, maybe not. I don't, until I hear it, I won't know.
And who was the other gentleman that they're having coming in for?
Brian Gillis, he would be
Was
similar.
he the attorney for DCF?
He was an attorney for DCF at the time.
And what is he going to be testifying to?
Again, Judge, off the top of my head, you remember Mr. Gillis?
One issue would be the issue that arose with Catherine Beatty's email that we tried to have admitted and the factual assertion that there was a delegation.
The email you sustained?
Yes, sustained it with, yes, with the additional instruction that the defense could try to prove up a delegation.
I think it's also important to note that I do not believe Mr. Gillis was actually working on the Kowalski dependency case, and he is currently Deborah Salisbury's practice partner.
Was he the DCF attorney at the time?
I would defer to Mr. Whitney on that. My understanding was he may have worked for DCF, but he was not staffing the Kowalski case.
This is the point, Judge. Yeah, we have no information that suggests that he has any involvement in this case, except to the extent that he used to work for DCF back then, but had no knowledge or involvement in this case. So when he's been injected in the case before, it's been offering opinions about what DCF should have done or what should have been done in this situation, like a de facto expert of some sort, but yet he's never been listed as such, and he has no personal knowledge of events here that we're aware of.
Are we calling him for the dependency action? Because you know that's not happening.
I know that is not happening.
So what is he being called to say?
Without my notes, I can't tell you specifically, but I will reevaluate whether we can call him and take any risk with it. Honestly, Judge, I've been concentrating trying to get ready for this witness and get things going and dealing with their motion.
Have we turned over the exhibits that we're going to use tomorrow?
Yes, Kelly Perry takes care of that. Can we check and ensure Kelly Perry is?
Yes, they were sent at 12:01.
Okay.
Yes, they were sent at 12:01.
Mr. Hunter.
Way to go with Kelly. I guess Kelly's doing that from home.
One is, I really would like to hear some explication of what we're doing with Mr. Gillis, because otherwise we're floundering around all night trying to figure out what this guy's going to say with no indication of what he in fact is going to be proffered for, and just wasting a lot of time. And then the second thing is, did I hear Jessica Stevens on the list for tomorrow?
Jessica Blackrick.
Jessica Blackrick. She is with the guardian ad litem program, but we don't know what she's being proffered for, and if it's a Williams rule situation, we're going to have.
It's not Williams. It's not Williams rule.
Okay. So for those two witnesses, why don't we have a discussion after the jury leaves, before the lawyers leave, so we know this way somebody, if your law partner can scan your notes and send them to you, that
Yes.
way we can have a more intelligent discussion before everyone leaves here today, so we can be more targeted and focused tomorrow.
I understand. Oh, one other thing for the record, Judge. When I said withdraw to a 453, that was the last exhibit that we were discussing there. I think it was 277 453. That was just as
words all over the place.
Say again?
It's the one with words all over the place.
Yes, we weren't withdrawing that completely forever. We were simply withdrawing it for the purposes of this witness.
Okay.
Judge, I apologize for this request, but I've looked at their redacted exhibit, and I didn't take the best of notes. And can I ask the court to look at it to make sure that it's in conformance with the court's ruling?
Ooh, I think they put two sentences in here that the judge didn't specifically specify could go in. the current feed we have has a lot more saturation on the color levels. Look at the flag. Look how red the flag looks. It's all just a little bit redder than normal.
The top two are fine. The bottom one, and just so the transcript's clear, I'm looking at 2277-630A and 631A. The bottom one looks like what I said this morning, but without being able to compare it to the one I actually ruled on. But it looks... 628, what?
Would you like me to publish the other one?
Judge Holtz.
I mean, if you could pull up the other one, but I think, so I can see the underlying, but I think this is what I said.
Would you like to see 628, 629, or the other ones?
If I can see the original without the A, the 628 without the A.
Got it. Just a moment.
But Ms. Crows, this does look...
I wasn't suggesting it wasn't, Judge. I
It's very
just
dark.
wasn't clear and didn't want it going in.
Just a moment.
Yeah, this conforms with what I wrote earlier today.
Okay, it was a waste of time.
Thank you. Anything else, or can we bring the jury in?
I'd like to proceed.
Let's bring in the jury.
Bring the jury. Okay, let's see where we're at here. Get ready for the objections. They're going to fly. If I miss any, let me know what the number should be. Just put it in chat. That's a couple times today that the female defense attorney has made comments saying, "Did I miss this, or was this right?"
Welcome, members of the jury. Please be seated. Did you have a good lunch?
Yes.
Okay, glad to hear that. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? And I want to confirm while you're away, you reviewed a whole bunch of media about this case. No, great. Has anyone approached you about this case since you were last with us?
No.
Mr. Anderson, your next witness, please.
May it please the court, I'd like to call Dr. Joseph Cochran.
I'm going to try to watch chat. See, I like the more colored version here, so we're going to make the more colorful version go up here. Here's the doctor. He's got his 40 ounce with him.
I do.
Brings his own keg. He's not going to trust that nasty court water. Oh yeah, we're going to be over 800 for sure. Unless they cut this testimony short, we'll definitely get there.
Hi. Can you please state your name for the record?
Yes, sir. I'm Joseph Cochran.
MD?
DO.
DO. And where do you live?
I live in Tampa, Florida.
And have I asked you here as an expert in hospital administration to advise the jury on your review of the policies and procedures at Johns Hopkins All Children's Hospital during the relevant period?
Yes, you have.
I'd like you to give the jury the background, a little bit of your background training and experience for offering opinions here today, particularly your well, why don't I let you start?
Good afternoon. So I'm Joe Cochran. I am an OBGYN by background. After finishing my residency in Philadelphia, I practiced in Sarasota for about 12 plus years, from 1991 to 2003. I'm board certified by the American College of OBGYN. I spent my first 3+ years working for a large practice. In March of 1995, I started my own practice with the idea of keeping it small and boutique-y. That didn't last very long, and the practice actually grew fairly quickly. By the end of my term with the practice, I believe that we had 3 physicians, 3 nurse midwives, and 4 nurse practitioners serving a variety of offices, one of which was here in Venice. The main one was in Sarasota near Doctors Hospital. In 2003, shortly after I became a dad, I had what should have been routine back surgery. There were complications after the back surgery that ended my clinical career. I was unable to continue to stand, bend, lift, twist. Obstetrics is a fairly physically demanding specialty, even though the babies are fairly small. So it took about 2 years for me to get better, and I did that recuperation at home in Sarasota. In 2006 or 7, I started a business education master's program at University of Florida in the Warrington College of Business. I graduated with a Master's of Science in Entrepreneurship and Innovation. Shortly after graduation, I was recruited to a healthcare think tank in Washington, D.C., known as the Advisory Board. It's been around since the early 70s and is now part of Optum Healthcare. I joined in November of 2008. My first day on the job was the day before we elected Barack Obama as president. So it was really kind of neat to have a front row seat to the development of the Affordable Care Act. I had nothing to do with the legislation. We actually helped hospitals and large medical groups know how to change in this new paradigm. I was with the advisory board through the beginning of 2013. At the end of 2012, just prior to the election between Barack Obama and Mitt Romney,
politics, man?
I was asked to deliver an address at the Longboat Key Club in Sarasota, talking about what would a second term of Obama versus a first term of Romney look like for healthcare. There were some executives from HCA in the audience. A conversation started that evening that ultimately led to them offering me the opportunity to work with HCA Healthcare. HCA Healthcare is a for-profit hospital company. It currently has about 180 hospitals, I believe in 20 or 22 states. So I was offered the opportunity to become the chief medical officer of Brandon Regional Hospital in suburban Tampa. It's about a 350 to 400 bed hospital at the time. I was in that role from 2013 until 2018.
Did Brandon, I'm sorry to interrupt, did Brandon have pediatrics as well?
Brandon always had a pediatric capability. But during my tenure, we actually developed what we referred to as a hospital within the hospital, so that we had a dedicated pediatric emergency department that had a separate entrance from the adult emergency department. And we had a dedicated floor for pediatric patients, including a pediatric ICU. And of course, being a heavy OB hospital, we always had a neonatal unit as well for newborns.
Please continue from there.
Thank you. So in the fourth quarter of 2018, based on some progress that I had a hand in at Brandon Regional, I was given the opportunity to assume a larger role within the company. And for better or for worse, that included a move out west. I became the division chief medical officer for the Far West Division, which has responsibility for about 35 cares of site total, but 5 acute care hospitals in the state of California, 3 acute care hospitals in Las Vegas, Nevada, including Sunrise Hospital, which is about 800 beds today. If I'm not mistaken, the Sunrise Children's Hospital, which again has a separate entrance and a separate emergency department, accounts for 206 of those beds. I was in that role for about 3 years, including when the nation learned about COVID. One of our hospitals in the Silicon Valley actually had patient number 2 in the whole country. So we were kind of winging it. We were figuring it out. And a lot of what we did in managing the early cases in California and some in Nevada actually set the foundation for how the rest of the company managed COVID across as it spread from the West Coast.
He's gone politics.
I was in that
He's
role
talking
for
about
about
C-19.
3 years.
All we need to do is weigh in on a foreign war. And
Quite
we'll
simply,
have
it came down to
all 3.
a job that I loved and a family that I adored. My wife and my 2 kids were never able to move out west, so I was commuting about 2,000 miles, 5 hours by air. My kids are my world, so that became unsustainable. So at the end of 2021, I moved back east. And in the early part of 2022, I accepted an opportunity to step away from full-time service to HCA Healthcare and take on the opportunity to serve interim roles. So they would drop me in basically as a consultant, and I would work, 3 months at a time, engaged at a specific hospital trying to address more specific problems.
So did Sunrise Hospital, can you elaborate a little more on what your job duties were there at HCA in the Western Division? And particularly, Jerry would like to know about Sunrise Hospital and the other pediatric units that you were involved in.
Yeah, so Sunrise Hospital is a very large safety net hospital. As I said, it's over 800 beds today. The night of the 1 October shooting, you may remember where there was a sniper at the Mandalay Bay Hotel. The night of that shooting, 100 patients were taken to the county hospital, the old Clark County General, which ultimately became University Medical Center. They accepted 100 trauma patients and then shut off and went on divert. Our hospital emergency room took over 350 patients in that night. We always felt that we had to be there for the community. So it was very much a safety net hospital. It was, really kind of, it was off the strip. It was not the glamorous part of Las Vegas. The Children's Hospital, and Mr. Anderson, I want to make it clear, as the division chief medical officer, I had a facility chief medical officer at Sunrise who really was
We're going to object
more
to the narrative
responsible
here.
for the day-to-day operations.
Did he report to you or she?
He did. Yes, sir.
Reported to you?
Yes, sir.
All right. So you were over the administrator there in terms of problem solving and operational decisions?
So my focus was always on clinical quality and patient safety. That really is job one for a chief medical officer. So I want to make clear, I was not over the entire leadership. There was a CEO who really ran responsibility for the hospital. My job was to support, lead, direct the chief medical officer at the facility, who also had the responsibility for clinical care and quality. Safety, I'm sorry.
And you said you're married. How long have you lived in Sarasota, setting aside your trip out west?
So I moved to Sarasota in the summer of 1991 after finishing my residency. I was a little bit of a slow learner. I didn't get to meet my wife until 1998, so I was single for a long time. And I lived on Siesta Key for most of that time. I met Patty in 1998. We got engaged in 1999. We got married in 2000. So we've been married a little bit over 23 years now.
And is she involved in business as well?
Yes, sir, she is. When I met her, she was helping her mom and dad run El Greco Cafe, which was a Greek restaurant down on Main Street in Orange in downtown Sarasota. And it's funny, I actually remember sitting at the intersection waiting for the light to change and saw the logo that said, where it was Greek cuisine, where Athens meets Sarasota. And I thought I wouldn't even know what to order if I ever walked in. Little did I know that I would end up marrying Patty just a couple years later. She now works with her sister and our nephew, and they have started a new chain of restaurants called the Breakfast Company.
There we go.
There's one in the Landings. There's one on State Road 70. And
business hours,
soft
maybe
grand opening was yesterday
Can
for
we
the new
admit the
site
menu?
across from UTC Mall.
So,
Can we admit the menu?
How did you, lack of a better term, get this gig? How did I find you to advise the jury on these issues?
So one of my longtime friends is Steve Heese. Steve is someone that I met during the Reagan administration when I was doing my residency in Philadelphia.
I just can't, guys.
Steve is a very smart businessman. He
I want to hear what he has to
ultimately
say.
went on to be one of the owners of Chris Craft Boats.
This is irrelevant. Approaching third parties who are not parties to this have nothing to do with it.
Sustainments.
I'll speed it up, Your Honor.
You knew Steve Heese and...
I knew Steve Heese. We had dinner. Our wives are friends, so the four of us were having dinner. Steve actually knew Greg as his chief counsel, I believe, for Chris Craft Boats.
Objection, Your Honor.
Sustained.
That's all I had on that, actually.
Before Dyer, the witness, Your Honor.
Ooh.
I'm not
Why
completed.
don't you let him finish? Thank you.
Before Dyer.
Exactly.
Finish the credentials.
Okay. All right.
Please.
So in terms of operating hospitals and in advising the jury on your opinions here today, tell the jury about your practical experience in evaluating the operations of hospitals and noting where there are issues that must be resolved.
So it started my involvement in assessing and helping hospitals run smarter actually began when I was in practice. I was on the medical executive committee of Doctors Hospital in Sarasota for 4 years. I was elected as the chief of staff, but my surgical complications did not allow me to fulfill that role. After graduation from business school, as I said, I was recruited to the advisory board, which was a think tank and a consultancy. So my roles involved going to health systems, hospitals, and large medical groups, giving them business insights about how to work in this new Affordable Care Act paradigm primarily. And then for HCA, as I said, I was a chief medical officer at Brandon, which was about a 375-bed hospital, which has subsequently grown, and then had responsibility for about 3,500 beds all total between California and Nevada in my role as division chief.
And can you explain how HR, if you will, played a role, whether you were either directly involved or over and making decisions in terms of the HR departments in these different hospitals?
So I didn't have any direct responsibility for the HR department, but I did have leadership responsibility or executive accountability for the medical staff office, and that was a responsibility that I shared with my CEO. I had direct responsibility for the quality department, and I had a vice president of quality who headed up that department and had maybe half a dozen to a dozen members on her team. I also oversaw a couple of other organizations, including computer physician order entry.
Were you involved in some of your roles in the development of hospital policy on various topics?
Yes, sir. So I didn't write the policy, but we met with the folks who did. That typically was somebody with a legal degree, so that we made sure that we wrote it the right way. But yes, I was involved in those conversations as they applied to clinical quality and patient safety primarily.
And some of the different policies and procedures that we will discuss here today, have you been directly involved or overseen the direct involvement in the development and management of those policies?
Well, not the policies that we'll look at today, but policies like that as they applied to
Obviously not
our
these,
hospitals. Yes, sir.
But in other hospitals.
Yes, sir.
And then in terms of your as Chief Medical Officer in Brandon Regional Hospital, then, can you explain your role in terms of overseeing or developing hospital policy and procedures of the type that we'll be discussing here today?
Yes, sir. So, for instance, one of the things that we did, aside from just writing policy, was actually working on performance improvement. So, for instance, shortly after I started at the hospital in the early part of 2013, we participated in an effort to improve how we were doing with sepsis, which is an overwhelming bacterial infection. When I joined the hospital, if you were diagnosed with septic shock, there was a 44% chance that you would die rather than be discharged home. That was unacceptable from a clinical perspective. Average nationally is about 30%. Before the end of the year, we actually worked as a team, and I had a part in leading that team. We worked as a team to put in new procedures based on what evidence and data showed us was the right path. We created guardrails for our clinical teams to stay between.
What's a guardrail?
That's my term for it. We said, look, the data and evidence says that this is acceptable and this is acceptable, and there's a range, right? So I think about it as guardrails, and we leave which lane to be in. We leave that up to the physician based on their knowledge, their skill, their education, their judgment. But we know that if you stay between the guardrails, the data and the evidence points us to the patient is more likely to get the favorable outcome that they want and we want for them. So we were able to lower our mortality rate from 44% to 24%. And we maintained that performance for several years in the mid to low 20s.
And can you explain your involvement with the standards that you'll be speaking about today? They're called CMC or CMA?
CMS?
CMS standards.
Yeah, so, lawyers frequently talk about standards of care, and that's a legal definition about what is expected a physician to do when treating whatever.
Sure.
Objection and approach. Okay, this has been bizarre. Chat, thank you for moving on. I'm gonna recap this just briefly, but we don't need comments on this. I've never seen a intro to understand the expertise of a witness, an expert witness that has delved so wildly into so many hot topic issues. Now, I'm not saying one is good and one is bad or whatever, but typically there are things you can talk about where I could bring up a topic that would alienate half of you. Okay, this guy had a list of all those topics, and he read off the list of everything. So he's basically triggering everybody in the room. Everybody in the room, for some reason, doesn't like something he brought up, and that's all they can think about right now. Okay, wow, what a strategy, or what a lack of strategy, I might say. And I would say that the plaintiff really needs to do a really good job of sort of steering this guy, because he likes to talk, he likes to name drop. Clearly he's been in, and I'm not faulting him for this, he's been in some upper levels of management of some very large companies. And yes, those people do tend to associate with or get to meet or get to hang out with or interact with big names in politics and the world in general. But dropping all the names is not the best way to start. You're dealing with a jury, okay? This jury is probably not impressed with your name dropping. or B, probably maybe on a different side, argument wise of the people you're dropping names for. So it seemed a strange way to start. He does. I mean, he's well spoken. He's educated. He's got a lot of experience. I think it's pertinent. It's wasting plaintiff time. We have not yet got to really the part that we need to hear. Some of it's been pertinent about his experience in building expertise and building the standards of care and the rules, the guidelines, the guardrails as he calls them. But it has been crazy. We will just start banning all the people who are dropping political stuff in the chat, just because people read that and even they won't read the rest of your message. Even if you say don't talk about and then you put the name, we're going to ban it. So just stay on topic. That's it. This guy has not been able to. That's what the defense is objecting to right now. Why is this relevant? It's not. We'll see what happens here. Don't talk about Bruno. We don't talk about Bruno. So, oh man, the funny thing. Here's my wife's business. These are the locations of the stores she's opened. They just had their grand opening. Here's their menu. They have a special today on. Wow.
And insofar as the CMA standards, based on the court's ruling, I want to ensure that we just stay involved with your knowledge of the development of them, any participation you had.
Sure, and it's CMS,
CMS.
Center for Medicare and Medicaid Services, which is the federal organization that oversees Medicare and Medicaid spending. So I had nothing to do with developing the CMS standards, but these really are there's a book referred to as, titled CMS Conditions of Participation. And these are the standards that every hospital is held to if they want to participate.
Yeah, I know.
Sustained.
Yeah. We can't go into the operation of them, just your background in terms of actually learning about them, using them, developing them.
Understood. Thank you. So the CMS standards were what I, as a practicing physician and a physician medical staff leader, was held accountable to. The standards were also what I was held accountable to as a chief medical officer, to make sure that my hospital was meeting those standards.
May we approach? Here we go. This guy is going to talk himself out of an opportunity to testify very quickly. He changed his answers to say, instead of saying this is what all hospitals are held to, this is what I was held to as a hospital administrator. Still too close to the line, I think. He's not supposed to talk about this. But we might be almost done with this witness, Dr. Joseph Cochran. Mr. Anderson's going to have to lay some foundation really quick, get whatever they want out of him very quickly, and then move on, because this is turning into a disaster.
Objection is sustained.
I'm sorry.
So, for the purposes of this testimony, let's stay away from the CMS standards and simply go with your background, training, and experience on this.
Yes, sir.
So, what did you review in connection with offering opinions here today?
I was provided with a variety of documents, which I've listed out in this.
If you could give the jury just an overview of everything that you'd received towards offering opinions.
And give the defense a copy.
Will do. It's quite lengthy, but it's multiple depositions from some of the treating physicians, from Catherine Beatty, some documents from Johns Hopkins variety of organizations, including All Children's Hospital, some policies and procedures from from All Children's Hospital, the medical staff rules and regulations dated February 2016, depositions of Dr. Napolitano and Perno, Patty Condon, Jackie Crane, organizational structure, org charts for Johns Hopkins All Children's Hospital, reports from various experts.
Okay. And what was your assignment here?
So you asked me to be a part of this this litigation, this case, to really help the judge and jury understand how hospitals work. They're very complex. They're very complicated. The hospitals that I worked in, Johns Hopkins actually has another layer on top of it because it is an academic medical center which has its own kind of fiefdom, right? So I was really brought on.
Bingo on fiefdom.
Object to relevance. Johns Hopkins is not part of the case.
Overruled. And if you can speak to any experiences you had where you were working with or developing things with Johns Hopkins, any one of them.
Yeah, so I'll be more precise about Johns Hopkins All Children's Hospital. I apologize. So I'm sorry, the question was, sir?
Well, that's a good point. I added on to it about any experiences you had actually working with Johns Hopkins in developing any policies, procedures, or other programs.
So I never worked directly with Johns Hopkins in Baltimore. When I was at Brandon Regional Hospital as the chief medical officer, as I said, we opened a pediatric hospital within the hospital. We actually worked with Jackie Crane, Dr. Napolitano, and other leaders from All Children's to help us build that hospital within the hospital.
For the pediatric aspect of it?
Yeah, yes, sir. It was a pediatric hospital within the hospital.
Okay. Now, so that the jury understands here, in terms of the hierarchies in hospitals, and can we bring up I guess it's now 2802 organizational chart, published, Judge, if we may.
Is it in evidence?
Yeah, it's the 2015 version we talked about.
I'm sorry, Judge, I want to hold our witness. It's going to
Are you finished with your credential background?
Yes.
Now we get a voir dire.
Mr. Hunter can voir dire.
Voir dire. There's going to be objection at the end of this voir dire as well. He's going to point out all the things he doesn't know, what he didn't do.
Good afternoon, sir.
Just a few questions at this point. As I understand it, your first billet, if you will, as a hospital executive was at Brandon Regional Hospital?
Yes, sir. My first hospital-based leadership position.
Okay.
Yes, sir.
And before that, and to the present day, you had not practiced in a children's hospital outside of medical school, correct?
As an obstetrician gynecologist, yes, I have not practiced medicine at a children's hospital, and I apologize for not being more clear before.
That's not a problem. And you haven't worked in a children's hospital since medical school?
That's not entirely true because, again, Brandon Regional had the children's hospital within the bigger hospital, and Sunrise Hospital has Sunrise Children's Hospital.
Okay, well, let's compare and contrast for a moment.
Okay,
Brandon Regional Hospital is a general hospital, correct?
that is correct.
Is it licensed as such by the state of Florida?
Sir, I'm not aware of the license.
You don't have any idea what the licensure classifications are?
That's outside my wheelhouse as a
Would
CMO.
you have any reason to doubt that it is licensed as a Class 1 general community hospital?
That's outside of my wheelhouse. I wouldn't even be able to comment on
Don't have
this.
any idea?
No idea.
Okay. We can agree that it takes adult patients.
It does.
That's primarily what it does, correct?
It does.
And it does adult surgery.
It does.
And the hospital within a hospital is just one floor of a general hospital, correct?
When I was there, it was limited to one floor. Yes, sir.
And that wasn't there when you started. It was something y'all developed.
That's correct.
Okay. It has nearly 400 beds.
Correct.
It's in a community as a community hospital, correct?
Yes, sir.
Doesn't have a reputation for referrals far outside as a tertiary care institution.
Actually, it does a lot of intake for some of the specialty work that it does, particularly in neurosurgery and other other services that aren't maintained at most community hospitals.
And they're adult services?
Yes, sir, but we also took in transfers from newborns.
Okay. So if you had problems with a newborn, you transferred it, correct?
Well, we kept most of them at the hospital.
But if you had a complicated newborn, you transferred it to a children's hospital, correct?
For the most part, yes, sir.
Okay. Now, do you have any idea what the number of beds that All Children's has?
I believe it's in the neighborhood of 240, 250.
What is their licensure, do you know?
I have no idea, sir.
Do you know what the acuity level of the beds at All Children's are?
I do not.
Do you know how many NICU beds they have?
I do not.
Do you have any idea how many PICU beds they've got?
I do not.
To talk about your hospital in Las Vegas, you never worked in that hospital, did you?
I was in the hospital on a weekly basis, but I never had an office in that hospital.
You didn't have day-to-day responsibilities for being the CMO of that hospital, correct?
That is correct. I was that CMO's boss.
Okay. And you were over the top of him and didn't have command of the executive team, did you?
Not command, no, sir.
Okay. So you were not directly responsible for operations in that hospital. You were supervising what your employee did in that hospital, correct?
I was accountable to the work that was done there, but not responsible for the day-to-day operations.
Okay, that's my point. Okay, so how many beds was that hospital?
The hospital writ large is, I believe, just over 800 beds, and I believe just over 200, I believe it's 206 of those are part of Sunrise Children's Hospital.
Is it separate?
The hospital is a multi-block complex. Sunrise Children's has an entrance on the south side of the complex. The adult hospital has its entrance on the northwest corner. The emergency room is, both the adult and children's emergency rooms are on the east side. So I don't know how to answer that. They are, when you're leaving one hospital and entering the other, but there are contiguous hallways.
Are they separately licensed?
To my knowledge, they are.
And how are the licenses classified, do you know?
Again, that's above my pay grade.
Okay. What is the acuity level of the beds at the Children's Hospital?
So the Children's Hospital actually has every conceivable level of service, every conceivable clinical service, including open heart. They have a very active open heart program. They have neurosurgical, pediatric open heart, pediatric neurosurgical. Sunrise Children's is the tertiary care hospital for the state of Nevada.
Okay. And your responsibility was overseeing the CMO of that hospital?
My responsibility, my accountability to my bosses in Nashville was to make sure that that hospital was running. I relied on my chief medical officer as my right hand for making sure that that happened. But at the end of the day, if something went afoul, I had to answer to it.
And when were you working with those folks?
Began in the fourth quarter of 2018, and I finished in the fourth quarter of 2021 for 3 years.
So those 3 years, but during the time that this incident took place, you were at Brandon Hospital, correct?
That's correct.
And at the time this incident took place, you had not worked in a pediatric hospital in 30 years.
The jury's here.
Again, that goes back to my clinical career.
Yes, sir.
Yes, sir.
But
might not be 30, but more than 15.
Going back to medical school?
And residency training, so up to 1991. It's pretty close. We're getting old, aren't we?
All right. That's all I have right now.
He's going to renew his motion to exclude in just a moment.
Okay, now, if we could bring up, I think what I was doing here is having, okay,
maybe
this isn't confusing at all, is it?
Maybe that's just preserved for the appeal.
Let me represent to you, and for the record, this is Johns Hopkins Children's Hospital. Well, actually, it's identified by exhibit. Where is it? I gotta get set up here again, Judge. All right, so this is exhibit Johns Hopkins, actually 2802, the Johns Hopkins organizational chart as of 2015, the year before what we're talking about here. Now,
I'm sorry, the date on mine says February of 2016. Are you
that'll still
looking
be
at the same?
fine, I think. It was 2015 issued and 2016 on it.
No, we said 2016.
It's revised 2022, 2616.
All right, so it's 2016.
Okay.
Okay, can you take the jury?
Your Honor, may we approach? I'm sorry. We have an issue with this exhibit.
We have an issue with this exhibit. Here comes another objection. They said they warned the judge. They said, just so you know, we're going to be objecting to everything. And as soon as they can think of an objection, they're going to make it all the way through this. And it's going to get a little frustrating. It's going to take a bunch of time. I believe these objections are counted against the defense on this. So it is burning their time, not the plaintiff's time. But did Brandy make that chart? I don't think so. I wasn't looking. I was reading chat because you guys told me to pay attention to chat. I was reading chat. The org chart. This is the chart that they just barely provided this morning, I think. Ooh, and Mr. Hunter is not happy. I mean, everyone looks red in this feed, but he looks very red. This guy doesn't have anything to do with Maya particularly. What his testimony is coming in, where it can really do damage against the defense, is that he can testify as to the running of a hospital and how it properly should be run. Okay, so he's talking about the guidelines, the standards, the internal workings, and how they should operate for risk management and everything else. And so he's going to testify that basically that Johns Hopkins Children's Hospital did not follow even their own guidelines, let alone the general guidelines that, on a more broader level that aren't specific to that hospital. And so it's going to look very bad on the hospital, and for that reason, they're objecting to everything they can to minimize the damage. Yes, we're going to push 825, I think, for sure, Ashley. We'll get there. The org chart and your evidence is different from the one the witness is testifying about. Ooh, I did not look at it. I need a closer look. The poor court reporter looks to be crying. It's like, I just have to write it down. He is expert, comes in after, gets to go back and look at all the other records and opine on them. He gets to speculate. He gets to bring his own 40 ounces of whatever beverage he brought in. Let's see what that is. He's still pouring. It's a big glass. Steady, steady. There, ooh, a little more. There we go. Perfect. Ooh, he's adding water. So he's, I believe we have a mixed drink here. We have a mixed drink, ladies and gentlemen. We have whatever he brought in his mug plus water. So, he's ready to go. And I still can't believe that an expert witness of his caliber was name-dropping his wife's business, even giving the addresses where the restaurants were at. And he's looking to the jury like, you should go there. They just had the grand opening. Great food. You're going to love it. That just blows me away. I mean, all the other stuff was out of line as well, but seriously. And then here's my buddy. He works for this boat company. You should go buy one of their boats. I swear, I'm surprised he didn't come in here wearing logos on his shirt from all his sponsors. It blows me away. New merch, huge mug with straw. Oh, man. I'm enjoying this. I'm really hopeful we get to the spicy part of his testimony, because I do think this witness has something that he offers to the plaintiff that will be very, very impactful in this case. Probably even something that only he can bring. So I'm hopeful we get there. Jury's been excused. We're about to have a proffer, I believe. That's my guess, because the witness has not been excused.
Okay. We're just trying to keep all our paper in a row here, so sorry about that. But I think we've figured it all out.
Where's the jury back?
I'll keep asking questions.
I think the jury's back now.
All right, so before we get to the organizational chart, can you tell the jury a little bit of the history of how All Children's Hospital became Johns Hopkins All Children's Hospital, to the best of your knowledge?
Judge Foundation, Your Honor.
Sustained.
Are you aware of the circumstances surrounding the acquisition, of the date and the general terms of how Johns Hopkins how All Children's Hospital became Johns Hopkins All Children's Hospital?
Judge Foundation, Judge, if we need to approach.
The judge's soul just left his body with that sigh. So jury is present still. He's looking. The witness is looking at the jury, so they're still there. I'm not sure why everyone stood before. That doesn't make sense. The witness is smiling because he's getting paid by the hour, and this is all billable hours for him. Oh my goodness! I don't think the jury left, but they have approached. Let me turn on the Zoom. Let's see what we got here. I've got to see if we can follow what's happening. Okay, here we go. Accept, watch trial, watch meeting, copy link. Paste, go, open. All right. Can't let you guys listen to this, unfortunately, because judge's rules, but. And of course, they've got the mic turned off anyway. So all that for nothing. Okay, so we're almost to 800 objections, and we haven't really got to the meat of the matter yet. So, okay, I like the guy, says Beach Gal. He's definitely been entertaining a little bit. Dr. Joseph Cochran. Have we decided that's what we're going to call him? Okay, they're still up there talking at the bench, so we've got to wait for a little bit. Fast forward your TV. Wish I could. I'm interested. I wonder why the defense has not made an issue of the fact that he does have a lot of notes that he seems to be reading, or maybe it's just some Reader's Digest that's keeping him entertained between questions. He's so polished. He's got some fancy cufflinks. The guy's a snazzy dresser. He looks quite sharp. He's got the blue suit going on, rocking it like Mr. Whitley. The tie is pretty impressive as well. Got some compliments on that already from people in our group. His fabulous hair, for sure. Can't believe he rolled his eyes at the jury. Yes, right after the objection, he's like, oh, yeah. Those guys, Okay. Hang on one second. I need a tie just like the witness. I have one similar to it. I'll have to look and see if I can find it. It's probably fallen on the floor. It's underneath about 1 million shoes in my closet. He's telling them the executive at Johns Hopkins All Children's Hospital should take responsibility. Hamilton meets his Liberace. This court reporter, he does not look happy The poor guy. I mean, has he been here all day, or did they switch? Usually they switch like halfway through the day. I wonder if this is like the defense's strategy, because if defense can just tie them up with objections for long enough, this guy's billable hours are just going to be through the roof. He's been there all day, so he's the one, Jackie. He's the one that got to hear the judge, blow his top. Just be, what is wrong with you? I can't tell if the court reporter is taking this down or not. He's got the headphones on, which would mean he's listening to the microphones, but I don't think they take bench conferences down. Judge has sat down. He's dismissing the lawyers. He's saying, go sit down. I'm not sure why you're all up here. Go, go, go. Shoo, shoo. He waves them off. Don't come up here again. You go over that way. I can read lips. I can tell what he's saying.
You may continue, Mr. Anderson.
Let me show you what's in my into evidence as 2200. And ask you if this was something you relied on in reviewing the background of Johns Hopkins Children's Hospital.
I'm sorry, can we have the zip number?
2300. 2300.
Yes, Mr. Anderson, it is.
Can you tell the jury approximately when All Children's Hospital became Johns Hopkins All Children's Hospital?
On April 1st, 2011.
And is Johns Hopkins All Children's Hospital part of the Johns Hopkins Hospital system? If you know.
I believe that Ms. Crane described it as the sole corporate member, JHHS.
Right.
And they did appear on the 2012 org chart. I've not seen the 2016 version.
So then let's bring up the 2016 org chart, if we have it now.
This is the chart we just got this morning, the updated version.
This is just so much less complicated. Now, can you, the first thing we'd like to know is your position at when you were working for Hospital Corporation of America. Where would you fit in this? Was there a similar position?
Well, I don't see a specific box that identifies chief medical officer on the on this All Children's Hospital chart 1.
Right. Okay. Are there any equivalent positions there? Just to orient the jury.
Right, I'm looking. At the time, I believe they had a vice president of medical affairs, Dr. Regina Chmiel, in 2016. I'm looking for her box on this org chart.
Let's go to the next page, please. And what I'm looking for here, and you can stop us when we. What I'm trying to look at here, at those, Dr. Mira. So this position right there.
I see it.
Okay. So let's then, if we can scroll through the next page. All right. What I'm trying to establish here is the chain of command from the president down to risk management. Okay. Now, if you can identify risk management, which I used to be able to on the old chart.
Right.
Are we going to hear from the
risk
president?
Management is on the upper right corner. Right. Thank you for the red box. Risk management is one of 5 organizations that report directly up to senior counsel, Jackie Crane. Jackie Crane then has direct reporting responsibilities, signified by a solid line. One goes directly to President Chief Executive Officer Jonathan Ellen, MD. One goes to the right to JHHS, which is the Baltimore-based organization. And then one goes further to the right to the internal auditor.
All right. So in terms of the level, I see that the risk management department is separated off to report directly up to the senior general counsel.
Objection, leading, Your Honor.
Overruled. You can answer.
Yes, that is correct. Risk management was responsible for reporting up to the senior counsel, Jackie Crane. I just want to point out, our expectation as leaders is that you not only expected your reports to direct...
Your Honor, it's not responsive to a question.
Sustained.
All right.
Thank you.
What, if anything, is different about this that you were about to explain?
I was just going to explain that there's a push of information up to your boss. Rule of thumb, never let your boss be surprised. But there's also a responsibility to pull information up because you are accountable as a leader to the organizations that you lead. You can delegate out tasks. You can delegate out...
Your Honor, it's unresponsive to a question being editorial comment and has no foundation.
Overruled the foundation, but let's have a question next time.
Well, why is the pull part of this so important?
So as a leader, you are responsible for what your teams are doing. So they should be reporting up to you, but it's your job, if needed, to pull information from them so that you have a clear understanding of how they are performing on tasks that you have delegated down to them.
So for the general counsel, senior counsel right here, and the senior counsel reports to the president?
That's correct.
The general counsel...
Senior counsel.
Senior counsel, for your background training experience, would he or she have a duty to pull information then on a timely basis from risk management?
Objection, lack of foundation in this organization. You speculate.
Let's just go with non-speaking objections, please.
Foundation, speculation.
Overruled.
You can respond.
Yes, sir. In an organization such as this, you would expect that there would be a push and pull accountability.
And would that be on a reasonably frequent basis? Or
Generally, I would meet with my direct reports on at least a weekly basis, if not more frequently.
All right. So if you could then tell us whether, as to this chart, then the risk management was directly reporting and the senior counsel directly pulling information up to the most senior levels of executives in this operation.
Objection, Your Honor. Relatives 403, lack of foundation.
Overruled.
You can answer.
Yes. So the senior counsel should have been getting information from risk management on a recurring basis and sharing the most relevant information up to the President, Chief Executive Officer, and JHHS, and as needed to internal audit.
Now, are you generally familiar with the facts of this case, the Kowalskis versus Johns Hopkins Children's Hospital?
I am.
And are you familiar with the facts leading to the time spent by Maya Kowalski at Johns Hopkins Children's Hospital from October of 2016 through January of 2017?
I am.
And what was significant to you in your review of the facts there that would make this case one that the senior counsel would or should have rather had continuous knowledge of?
So this case was...
Objection, Your Honor. Relatives foundation outside of pleading.
They already called Kathy Betty. She testified on Thursday.
Question again, please. Mr. Court reporter.
court reporter's like, oh, I don't get paid enough.
Okay, what was the significance to you and your view of the facts that there would make this case one that the most senior counsel would, or should have, rather, had continuous knowledge of?
What were those last few words? I'm sorry.
Have continuous knowledge of.
What is this beginning of his answer? He just said, so this case was, in the objection.
Let me, Mr. Anderson, why don't you ask the question again, because I didn't
Yes.
quite hear what the court reporter is saying.
It was what we call an inartful question. What I'm asking here is, based on your knowledge of the facts, can you explain to the jury why this case, situation, whatever you want to call it, about the Maya Kowalski situation, was one that should have, if it didn't, reach the level of senior management?
Objection, Your Honor.
Overruled. You can answer that one.
Thank you. So, in multiple depositions, including those that were aired this morning, it was clear that risk management was involved in helping to influence or make decisions regarding or supporting Maya Kowalski's care. The references in the depositions suggest that that was a fairly frequent conversation. On page 166 of Catherine Beatty's deposition, she describes conversations that she had with risk management that describes, quote, this case was different.
Your Honor, I object to this parroting testimony.
Sustained.
You can simply just, without reading it in, just reference
Sure.
the references.
I'm sorry.
That's all right. Have you ever testified before?
No,
As
sir.
an expert?
No, sir.
All right. All right,
Your
so...
Honor, court, please, the witness seems to have been reading from something
Here go the
a moment
notes.
ago.
He's got the deposition.
I'd like to know what else he's got.
What do you have there? Why don't you show it to Mr. Anderson, who can show it to Mr. Humphrey.
Sure.
It's his file.
Mr. Anderson, why don't you go get it and show Mr. Humphrey?
Here we go. We knew that was coming. I told you he was going to be, they were going to object about, well, that suit looks nice. I like the little checker pattern. Mr. Anderson's suit. It's very subtle. Yeah. I say we go out to that restaurant. That's what he was saying. He's got the restaurant menus. He's got the boat availabilities, the different, the hull sizes, the lengths, the engine options that are available, as well as the anchor packages that can come with them. Jamie, I just got a new suit. First one in about 5 or 6 years. They are taking their time on this.
Your Honor, if the court, please, it's a thick notebook that appears to have select.
Why don't you come talk up here?
Yeah. I'm going to count that as an objection. This guy's never testified before. He brought his notes. Hopefully, Mr. Anderson should have talked to him about this, and he only has stuff that he shouldn't have things that aren't up there. They're trying to slow it down. They're trying to break it up. They're trying to space it out. Even if they can just space out the time between the question and the answer, that could be a little partial win for the defense. Just because the question sometimes does, sort of point the finger of blame at the defense. But what this witness is doing is, in his answer, he's restating the question. And so that tactic is not working very well. But it's, oh my goodness, this is fun. We knew there were going to be objections. I think we've got another 100 in us here today before we wrap up, at least, maybe even 1,000. Okay. Sounds like they're going to say, quit reading out of that. Only use it if it refreshes your recollection, and let us know when you're reading. And can't testify out of it. Witnesses that have notes, the defense is entitled to see the notes the witness has.
Hold on a second. This is what we're going to do. We're going to put the notebook back there, but we're going to keep it closed.
Okay.
If you need to refresh your recollection, just let us know.
Okay.
We can open it up, and then the lawyers will come up and look at whatever you're looking at.
Understood.
Okay?
Yes, sir.
You may approach.
You may.
Thank you. Thank you. Yes, sir.
Now, where were we insofar as the reference or sources for your opinion in that regard?
I'm sorry. Can you reorient me?
Yeah, can we read back the last question?
He's allowed to have pretty much whatever he wants, but anything he has, defense has the right to have as well. That falls under the discovery. So if he brought up notes and in there he's got, if I say this, then I'm going, I'll get an extra bonus. And the defense gets to read that. Whatever he brings up, they get to see.
One question is, you can simply just without reading and just references.
I think the one before that.
It is slowing it down, and it is taking more time from the plaintiff. It is also using some of their time on the objections as well, I think.
Okay. What I'm asking here is, based on your knowledge of the facts, can you explain to the jury why this case, this situation, whatever you want to call it, about the Maya Kowalski situation was one that should have, if it didn't reach the level of senior management, and there was an objection?
Thank you. Thank you for that. So, as I said, risk management seemed to have pretty recurrent involvement in the case. That's the risk management department. The case was described by Kathy Beatty in a conversation that she cited in her testimony as being different, and discussing that with risk management and explaining multiple reasons why she felt it was different.
And so, armed with that information, what should have happened if it actually didn't?
So if this was a case that was constantly pinging in risk management, it seems reasonable that that would be shared with the executive who's in charge of risk management. That would be Senior Counsel Crane.
And so I believe we have an email here from...
This should be the redacted email. The one that the defense lady, what's her name, Corella? Like Corella DeVille, I guess. Corella said, I'm not sure.
This time, 2277, 628, and 629 alpha previously admitted evidence.
You may.
It's the redacted email where almost everything is gone.
Now, do you note here who this is from?
It's sent from Patricia Condon.
Are you aware of her position?
It indicates that she's a risk management analyst at Johns Hopkins Children's Hospital.
And do you recognize any of the recipients?
It is sent to Jackie Crane, who was senior counsel. It was sent to Louise Barnes-Kurth, who I believe was the head of risk management at that time, and Cindy Driscoll, which is a name that I do not recognize.
All right. Now, if you would review this as to the topic here, you see where they are continuing the allegations of, quote, self-inflicted
I do.
wounds, scratches, and then, and if we can keep scrolling down, and how they were asked about lesions from Mrs. Kowalski, either directly or through her counsel.
Waiting, Your Honor. Overruled.
That was a leading objection.
What I see is a quote from Ms. Condon. I did advise Dr. Majors to get pictures of the scratches. I need her to inquiry with Maya how she got them.
And just reading the exhibit once again speaks for itself.
That's not how witnesses read exhibits.
Does it appear to you that Dr. Majors, then, from this, was advising, or Patty Condon, rather, was advising Jackie Crane, among others, about the incident where Maya, what the jury has heard about, where Maya was stripped down, held down, and photographs taken from her?
Calls for conclusion. Objection calls for conclusion. Relevance. 403.
We're ruling the relevance, and now we're ruling the other objections. You can answer.
This does reference a direction, advice to get pictures of the scratches.
And assume for the purposes of this question that the photographs taken of Maya Kowalski were never analyzed as part of the medical records, and an after set were never taken, and that this just appeared to be an unpleasant, highly unpleasant situation for Maya Kowalski without any authorization from parents or anyone else. Is this the type of incident that should be reported up to the highest levels?
Objection, Your Honor. Assumes facts not in evidence. Can we approach on this entire matter just a moment?
Sure, you can approach.
The judge is like, sure. You've never approached before. Whoa, my ears. Let's kill that until they fix it. There we go. Okay, so as they have promised, we're getting objections on almost every single question, sometimes even multiple objections. That last one had 3, I think, objections. 403 is forbidden. 403, I think that has to do with, what is that? Probative versus prejudicial. I can't remember. Okay, I do apologize. I'm telling you, YouTube keeps telling me that it's going to be November when they fully roll out the new ads, where everyone gets ads pretty much all the time, and I don't know how often that's going to happen. But even though I've turned them off and have said not to show ads, they are starting to do it already. So. Relevant versus prejudicial. Let's see. 403 testimony is forbidden. Excluding relevant evidence. Thank you, AJ Red Sox. Excluding relevant evidence for prejudice, confusion, waste of time, or other reasons.
Do you have an opinion based upon your background, training, and experience into a reasonable medical... Sorry. Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the senior level executives at Johns Hopkins All Children's Hospital were made aware of the situation involving obtaining pictures of Maya Kowalski?
Objection, foundation, and proper hypothetical.
Overruled. You can answer.
From this email, it's apparent that Jackie Crane received this email, and the information was there for her to receive.
And based upon your background and training and your knowledge, what would be the appropriate thing to do if a senior level person, management level person, received reports that could be construed as a battery upon a child? What should they do?
In my experience as a chief medical officer, if I saw information like this from one of my direct reports, I would investigate. I would get involved. I would make sure that I understood what was going on.
Would you get personally involved, is what you're saying?
Absolutely.
Form and objective relevance.
So now, from your review of the facts of this case, can you tell the jury, and strike it, and have you had the opportunity to review various emails and other documents involving the exchange of information between Ms. Condon and Ms. Crane and others between the Risk Management Committee and the senior level to determine whether there was an appropriate response back down from senior management to investigate this further?
I have seen emails where information was shared with Ms. Crane. I've not seen any emails that there was a response directing other actions to be taken.
And assuming that these photographs were taken several days later, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether this failure to investigate caused or contributed to the injury done to Maya Kowalski from the photo session?
Objection, speculation, no foundation.
Yes, sir, I do have an opinion.
And what is that opinion?
I believe that it did contribute to the injury. And I think that I was here on Monday and I heard that loud and clear from Maya Kowalski herself.
And in this instance, strike that. I'll move on.
Scratch all that.
I'd like to bring up Exhibit 1082, and for the record, that's the Johns Hopkins patient family rights there. And if we could go to the next page that sets forth the actual, and then if we could go down or look at the first two under expect privacy and always receive polite and now based on your knowledge of what happened to Maya Kowalski just in this incident, do you have an opinion based upon your background, training, and experience as to whether Johns Hopkins All Children's Hospital violated its own internal statement of rights to patients?
Objection to relevance outside the pleading.
Overruled.
Yes, I do have an opinion.
And what is that opinion?
I do believe that there were episodes that have been reported in testimony that were outside of these directives as rights that patients should have and expect.
Same question as before. Based on your background, training, and experience, if a senior member of management learns that patients' stated rights are being violated on a consistent basis, what should they do?
Objection, Your Honor. Relevance foundation outside the pleading.
Again, as a leader, if I saw this kind of information coming up from one of my direct reports, yes, I would get personally involved and I would find a way to get us back on track.
And would that involve, what if any training would that involve as to the participants?
I would certainly make sure that they understood what the patient rights were that we were advertising as affording every single patient in the hospital. I would make sure that they understood what was in bounds and what was out of bounds.
And what if anything would you do to ensure that if a particular employee, in this case, let's say Kathy Beatty, rejected that training, what is your opinion based upon your background, training, and experience into a reasonable medical management probability should be the action taken with an employee in this situation who either fails or refuses to accept this training?
Objection, relevance foundation outside the pleadings, no foundation.
I don't understand the question. So I'm going to sustain it on my own. I don't understand what you just asked.
All right. Maybe I'll ask another. All right. So what is appropriate in this circumstance for the retraining of Kathy Beatty if there was a circumstance such as you have learned repeated behavior violating the patient's internal rights? What type of training should be undertaken in addition to just educating them on this?
objection. I don't understand that one, the same objection as before.
Sustained.
As to the training?
I don't understand your question, Mr. Anderson. I'm sorry.
I'll move on, Judge. All right. I would like to direct you over to the farthest column right before the black column right there, and at the top it's got an arrow next to it, and it involves the ability to talk to another physician outside of this. I want you to assume, for the purposes of this question, that one or more of Maya's treating physicians, in particular Dr. Ashras Hanna, attempted to visit Maya in order to gain an understanding of her physical condition, how she was doing, and that he was rejected not from trying to go and treat, but simply as a visitor who was a doctor. Do you have an opinion based upon your background, training, and experience and to a reasonable medical management probability as to whether Johns Hopkins Hospital violated this right that Maya Kowalski had?
Objection to relevance, assumes facts, not an evidence, improper hypothetical.
Sustained.
There's been evidence of Dr. Hanna already.
Sustained.
All right, now, has it come to your attention through your investigation that the Kowalskis were attempting to exit Johns Hopkins All Children's Hospital during the first 7 days of Maya post-admission?
Yes.
And has it come to your attention that over that period of time there was no court order that authorized keeping her there?
Yes.
I'd like to show, published now, Trial Exhibit 2237-005, and this is from the Johns Hopkins Discharge of Patient Against Medical Advice. First, what is AMA?
Against medical advice.
Does it have the power of law?
No.
All right, so if we look at this chart down here and we continue down, from your review of it and further down, is this describing what the Johns Hopkins personnel should be doing in the event that a parent disagrees with their proposed treatment and wants to just get their child out of there?
Objection, Your Honor. Relevance, foundation, lack of foundation, lack of credit.
This is the foundation.
Can you all approach, please?
The judge is going to be frustrated here a little bit with two things. First of all, Mr. Anderson has got to do a better job with the shorter questions. This is really key at this point. Very pointed, short questions would help, and help this witness be able to bring in the testimony they really want to elicit from him. Also, the judge might be a little frustrated at the fact that they're just throwing like 5 different objections at the wall every time something happens. And it's like they're drawing objections out of the hat and reading off the ones they found for each question. Especially when it's like relevance and things like that, when we're clearly talking about items that are pled in the case. Okay, this is the main tenet of this whole case. Aura ring alert. Does he have an aura ring? What is the aura ring? I've heard about this. Is that like a smart ring or something? Someone had asked earlier, can the judge just tell the defense, just save it for cross? And no, because the defense does have a right to stop evidence that should not be allowed into court from being shared with the jury. So if the question elicits evidence that should not be allowed in court, whether it was hearsay or some other, if it's a ruling that the judge said we're not going to allow that, then as the question's being asked, as soon as the question is asked, they can object. And so that's the rightful thing. The judge can't say you can't object anymore. You've got to sit there and wait your turn. So the judge can't do that. So we'll just continue to have objections all day long with this witness. Okay, I think they're done here.
Overrule the objection. The witness can answer.
All right. If we go to the bottom of Exhibit 2237-005.
Witness didn't
Now,
answer.
leaving out the comment on the lower right,
I'm looking for the document. It's not up.
Okay. Let's put up 2237-005.
I've got it. Thanks.
Previously. And if you look at this flow chart here,
I think he does. Every time the judge stands up, he
down
stands
below,
up.
in all cases, does it appear to you, and based on your knowledge of the power or lack thereof of AMA, that Johns Hopkins breached its own internal rules regarding the ability of the Kowalskis to leave simply on the basis of AMA?
Objection, Your Honor, it's leading improper predicate and relevance and foundation.
We just discussed that.
You can answer.
Thank you. So I wasn't a party to the conversations, but there is nothing in this policy or this flow chart that should keep Maya's parents from walking out the door. It may be against medical advice, but there's nothing here.
And to the extent that they prevented, in some form or fashion, either through security or through representation of some kind, the Kowalskis from leaving with Maya, and I'm talking about this period, the first week, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether they violated this internal rule regarding AMA?
Objection, Your Honor, relevance foundation assumes facts not in evidence and fails to take into account Chapter 39 and object on the basis of the latter.
He limited it to the first week, so I'm going to overrule the objection. He limited the question to the first week.
I understood, Your Honor, this is the 24-hour rule as well.
You can continue, Mr. Anderson.
24-hour rule as well. What's the 24-hour
Yes, I do
rule?
have an opinion.
And what is that opinion?
My opinion is that they did not follow their own internal procedure.
And confining it then to just this week, we're talking about before there was any court intervention, do you have an opinion based upon your background, training, and experience and your review of the depositions of the Kowalskis and the facts of this case as to whether that action in violating the rules caused or contributed to harm to Maya Kowalski?
Same objection, Your Honor.
Overruled. You can answer.
Yes, I do have an opinion, and I do believe that it contributed to the injury.
I'd like to ask you, and I want to focus now, go back to 1082, if we could. I mean, I published, Judge, the same patient's rights.
You may.
All right. Now, if we look on the center column, the third from the bottom, where it discusses cultural values and spiritual beliefs, let me ask you to assume for the purposes of this question that Maya Kowalski was prevented on one or more occasions from practicing her religion, either by not being able to pray with or see her own parish priest, or by having certain materials taken from her or not provided to her, I should say, or by having this religion criticized. Do you have an opinion based upon your background, training, experience as to whether Johns Hopkins All Children's Hospital violated their internal statement of rights that they be allowed to practice their cultural values and spiritual beliefs.
Objection, Your Honor. Relevance, like a foundation, the failure to take into account the interplay of DCF in Chapter 39 and outside the pleadings.
Overall, you answer.
You may answer.
Yes, I do have an opinion, and I do believe that they did not respect the patient rights that you've highlighted here.
Did you see anywhere, inspect that, did you have the opportunity to go through, if not all, the majority of the medical file during the time that Maya Kowalski was in Johns Hopkins from October of 2016 through January of 2017?
Did I have the opportunity?
Yes. Did you review it?
I did not review much of the medical record because I'm being asked not as a medical expert, but as an expert in how hospitals are meant to run.
Then I'm not going to ask the next question.
You didn't know he didn't review the medical record?
I want you to assume for the purposes of this question that the Kowalskis informed the physicians during this first week that they had a different type of medical treatment and they did not want to move forward with the hospital's recommendations. Do you have an opinion based upon your background, training, experience, and to a reasonable medical management probability as to whether the hospital violated the second from the bottom on the first column to right to refuse treatment?
Objection, like a foundation of relevance, Your Honor. This rolls outside the pleadings.
Overruled.
Yes, I do have an opinion, and this right clearly states that you have a right to refuse treatment except that written by law.
And have you seen anything in these records or been told in any of your investigation that the Kowalski's decision to be treated, have their daughter treated outside of Johns Hopkins violated any law?
Same rule.
I've seen nothing to the sort.
Have you become aware that there was an incident where Maya Kowalski was placed into a, quote, surveillance room and told that it was some form of EKG when in fact she was being surveyed by the hospital?
Objection, foundation, misrepresentation of the record.
Overruled.
I understand that it was an EEG,
That's right.
Electroencephalogram, not an electrocardiogram. And those rooms in pediatric hospitals, it's normal for EEGs to be videotaped. That's not a practice in an adult setting.
In this instance, did it come to your attention that no actual EEG was ever performed?
There was certainly no evidence of that on the videos, that they were performing an EEG. That would involve a lot of wires, and it would be very easy to see.
All right. And assume further, for the purposes of this question, that there are no results, analysis, or barely mention of this procedure in the medical records surrounding it. Do you have an opinion based upon your background, training, experience, and to a reasonable medical probability as to whether, again, this violated Maya Kowalski's patient's rights to be able to move freely around?
Objection, Your Honor. Relevance, foundation 403. It's outside the pleadings.
Overruled.
Okay.
She was placed in an EEG room and surveilled, but that apparently never made it to the medical records.
Correct.
Which would indicate to me that it was not part of the care and treatment of Maya And
so then, do you have any opinions as to why they were doing this?
Objection, cause for speculation. No foundation. Overruled.
Leave it this way.
It certainly wasn't to treat her and help her feel better, because it was never documented. Rule of thumb is if it's not documented, it wasn't done. As to whether they were trying to just observe her activities, her actions surreptitiously, that's as likely as any reason for it.
Would you expect in that circumstance for there to have been some documentation in the medical records, some discussion of results or observations?
Objection, lack of foundation. He's indicated he didn't review the record.
Sustained. Okay, I'll move on.
And Mr. Anderson, the next 7 minutes, let's bring us in for a good point for a break.
In for a landing. That's what the judge wanted to say. Please land the plane.
I'd like to bring up Exhibit 3002-0002. And for the record, this is the quote consent for medical routine diagnostic procedures and treatment. May I publish, Your Honor? It's in evidence 3002-0002. It's a defensive exhibit.
That's right.
It is.
I believe it is, Your Honor. This was a carve-out at his request, I believe.
Was that just another objection? Are we at 826? I think it is.
It's not in evidence. It either needs to get in evidence or you can't show it to the jury.
We don't object to it, Judge. It's just not evidence right now. If you're going to lose it, go ahead.
Well, then what's this number?
3002-0002.
Okay, I'll receive that exhibit in evidence. Now you can put it up to Reyes.
Thank you, Judge. Now, if we could look at the second page of this, and you've got it up. All right. So in this, first, tell me, if you can, have you had involvement in either the development or the evaluation of these types of consents placed in the admissions packages of the patients before?
I've never developed a consent to treat. I'm certainly familiar with them as both in my professional life and as a patient.
All right, and so in this particular one, then there's a consent to treatment that involves understanding that imaging technology, videotapes, photographs, closed-circuit TV monitoring patient care may be used. You see that in the course of treatment?
During the course of treatment.
And why is that phrase, during the course of treatment, significant to any consent that the Kowalskis gave or did not give?
Objection to relevance, Your Honor.
Overruled.
So in the deposition this morning that that was shown of Dr. Perno, he said that the consent to treat...
Objective. The comment about one
sustained.
You can just, you don't have to reference it. Just your opinion.
Okay, I apologize.
Go ahead. No, sorry.
It's been testified that the consent to treat gave the legal...
Objection, Your Honor.
Does this...
I'm sorry.
I'll rephrase. In your practical and clinical experience, is there a requirement that any such video or photographs have to be part of actual treatment in order for these consents to apply?
Objective form, calls for conclusion, relevance.
Overruled.
Yes, it's clearly stated that videotapes, photographs, and closed-circuit television monitoring of patient care may be used during the course of treatment.
And so if the jury were to want to determine whether this consent had any validity, what would they want to look for in the medical records around the time of any such photos or video?
Objection, foundation, speculation.
Since the objection started, he seems very uncomfortable now.
Those two objections.
At a very minimum, I would expect that the videos, photographs, etc., would be part of the medical record if, in fact, it was part of a course of treatment.
And would you expect there to be discussion or analysis of them as to the why, how, and result?
Same objection, Your Honor.
Overruled, you can answer.
Yes, I would expect that it would be referenced in a progress note. I would expect that there would be results or interpretations, just like any other test.
And so then let me bring up Trial Exhibit 2277-06. Oh, it's not. I'd like to move in Trial Exhibit 2277-068, part of the risk management file. It's actually just that first page. I think the two of them are complete.
If I may inquire, was this one of the ones that we discussed?
It looks like one of the ones we discussed, but could we approach that?
Well, I tell you what. Why don't we take a break?
Judge
Members
is
of the jury,
so
do not discuss this case amongst yourselves. Do not do the investigation and receive no information. Let's try to keep it to a 15-minute break, please. All rise.
Okay, I think we're going to hear from the judge in just a minute. And he's going to be like, look, guys, get this together. You're wasting all the time. Let's see. Blackbird speaks or Blackbird squeaks. It looks like your son's getting his tooth pulled. That's a huge day for any kid.
Everyone can be seated. What exhibit is this?
I'm sorry, I missed the question.
I need someone can put the exhibit.
Oh, yes, 2277-068.
And sir,
Yes.
I need you to step outside, please.
Happy to, sir.
Transcript should reflect the witnesses leaving at the court's request.
Your Honor, if I go to the bathroom, I won't.
You're fine.
Thank you.
Your Honor, I've been holding it for the last 3 hours. Can I run? I can't read this note very well. Do you guys... October 7th, admitted, PICU, October 15th, transfer something.
So, what is this and how are we going to use it?
Your Honor, this is a risk management note from the hospital, and it is describing circumstances in the videotaping. It's unfortunately one of the exhibits we would have used our lunch break for, but we had other issues. So, pertinent to this discussion is that it relates to the October 18th to 20th videotaping in the EEG room, which was just discussed at some length. And at the bottom, you can see the various approvers, for lack of a better term. You have Dr. Sally Smith, Dr. Deese, and then pertinent to this witness's testimony, you have an authorization from risk. It says okay from risk. It describes, in particular, the videotaping, and then it says no order relevant to this witness's testimony that there would need to be a progress note, a result, an order of some type for this not to be a failure by the hospital. And then it explains the circumstances of the videotaping and the rationale relevant to the consent to treatment, which is the diagonal right in there at the bottom right says able to do when no one was there. So it's reference to, well, that's it.
Notice.
Judge, we don't know who wrote this. We don't know for what purpose it was written. We don't know what these random cryptic notes mean. And this witness has testified that he's never reviewed the medical record to comment on what should be in the medical record or what is or isn't in the medical record. So I don't know what this is being offered for right now, but there's no foundation for it. There's no demonstration of who created it, for what purpose, under what circumstances, or for what intended result.
Well, let me ask you more fundamentally, because I know we've been discussing this particular issue for 2 years now. Is the hospital's position that this was a medical procedure?
Yes, sir. This was part of a diagnostic procedure. We said that from the outset.
Okay, so then what's it doing in a risk management file? I mean, this is from the risk management file, right?
This is from the risk management file. I can't tell you what this is doing in the risk management file, Judge. I suspect that they were asking if it was okay to proceed with that based on the consent that was in there, but I don't know that, and I don't know what this means. And there is evidence of physicians indicating that they wanted to do the EEG video monitoring.
And after 5 years, no one has claimed ownership to this note that happens to be in the risk management file?
We think we know. I believe it was the first lady. No, Condon. It was. I thought it was Condon. I thought it was Condon.
It would either be, well, it could be Patty Condon, it could be Louise Burns-Kirk, but
who cares? From our point of view, it's a risk management. It's from the risk management file. It states there's an okay from risk management. It identifies people involved in it. And we're putting it in for the purposes of demonstrating exactly what the court just brought up, which is if this is supposed to be a medical procedure, why is risk management bringing in Sally Smith? Why is risk management bringing in Dr. Dees? Why is risk management involved at all if this is a fairly routine treatment or procedure?
Let me just make it more fundamental. Obviously, this is a hearsay document, but it is a statement by the hospital.
Correct.
So there is an exception to it. So there is a basis for it. It clearly is relevant, extremely relevant. So I don't see how I can keep this out, Mr. Hunter. I mean, what other basis are you suggesting that I exclude this document?
There's no indication of what the document means, of who created it, or what the intention behind the so-called document is. I would venture the comment that saying that this page of random notations is a document is stretching the word document a bit far. It came from the risk management file, I'll grant that, but the idea that it simply reflects someone having called risk management and been asked, is this okay, and been told, yeah, that's not, number one, it's not relevant to particularly anything other than the fact that it occurred, and number two, it doesn't give this, with these random jottings, any kind of probative value or relevance.
Well, here's where I'm just not following your argument, because this has been one of the most hotly contested issues in this case, and you're telling me that a document from the risk management file, and this is one of the punitive damage claims, talks about the video, no audio, no order, to see if she can walk on her own, suspected Munchausen syndrome by proxy. That this is not relevant? I mean, how is that possible, Mr. Hunter?
Judge, the doctors were attempting to gather clinical information. There is a notation in the chart, patient transferred to room 709 yesterday for monitoring, continues to have pain all over, but reports she was able to get more sleep last night. Her PO intake appears to be slowly improving. The demonstration is from that note that it is part of the medical record, and exactly the narrative that's being promoted is just not correct. We don't have a date on this beyond what 1, 2, 3, 4, at least a range of 6 dates, so we don't know what it was for.
Well, the jury's going to get to see it. It's highly relevant. I don't understand why we continue to talk about it. We've been talking about it for years. This is highly relevant. And
yeah.
I guess yours and my definition of relevance isn't calibrated the same. So I just,
Assuming its relevance, it doesn't speak for itself. So to give it to an expert to opine on before the person who actually put it in the record and can explain its contents, when, where, and how, and why it was done, I mean, this is just the wrong time to use this document.
now that I am more akin to that type of argument, Mr. Oltenburn, but it seems like this document is pretty clear as to what it means. So I'm going to go ahead and admit 2277-068. Can we take a break?
Yeah.
Okay, we'll be back in 10 minutes.
Your Honor, at least when this witness is concluded, I want a special instruction on the fact that violations of internal rules and policies and things like rights and responsibilities is not a violation of the law or actionable, but it can only be used as evidence. We need a limiting instruction on what's going on here.
Absolutely. Well, I suggest on the break, get Mr. Elliott on the phone, you and he start talking about this. Okay. Thank you.
All rise. Let's go on recess.
Okay. This is getting really, really good, you guys. Lots and lots of objections, tons of objections. Mr. Anderson, the questions have gotten a little shorter. The answers have been a little better. We've heard several instances of Maya's care, that the hot topic instances, whether it's the photographs, whether it's the cameras, whether it's the priest not being allowed in. We've heard the witness address each one of those and say, yes, that violates the hospital's own standards or patients' rights, their own rules. Okay, they haven't followed their own processes. We've got all this conflicting testimony about risk management, where Beatty says risk management was ordering all this stuff. I was just doing what they said I was supposed to do. And then on the other side, you've got hospital people in risk management, like upper risk management, say we have no idea. There's no notes or anything. We never talked about Maya. So there's a disconnect somewhere. And it's pointing it out that there's just a problem here of some sort. The defense has lost a lot of their objections, and they have said they'd be objecting a ton to this witness. As you can see, because it is so detrimental to their case, they're trying to stop anything they can. The last objection that the judge is partial to is the fact that this document doesn't stand on its own, and with this witness, he shouldn't be able to possibly handle it or comment on it. So, but the document's coming in. It's going to be in evidence, and once it's in evidence, they can use it however they want. So, documents in. Risk management, looking out for risk management, says Greeners. Yes, the last Mr. Altenberg just came up with one more request at the very end and saying, okay, we need a limiting instruction. Okay, this is an instruction to the jury. If you can imagine, we're going to have like 2 days of instructions to the jury before they go and deliberate. These instructions are going to be massive. But a limited instruction telling them that just because the hospital broke their rules does not mean they broke the law, right? So this isn't, we're not saying they're criminal because they didn't allow, because they, for whatever rule they broke. So there's that's going to be coming in, and the judge saying, "I suggest you talk to the other lawyer." They want them to draft an entry, to draft that instruction to give to him. The judge doesn't want to write all this up himself. All right, let's see. Blackbeard Squeaks, are you? Is your son's tooth out yet? Do we have good news? See, Cheryl Bybee says, could one of our in-chat attorneys tell us if they could bring new charges against Kathy Beatty after testimony in this case? Yes or no? I think that might be one for, maybe for Nicole. KK, welcome to the gallery. As a new member, you even have a dog profile picture. That's awesome. Thank you so much. Appreciate you joining us. Thank you for being here, and thanks for your support. See, no, I don't need the break, Mandy. They were saying they need a break. I'm good. I'm good for another day, maybe two. Sounds like someone in risk management tried to clean up the medical record. I don't think we've seen any indication of a cleanup, like a shred the documents, hide the evidence type situation. And this note would be evidence of that they just dumped everything in the record into the scanner and provided all of it. So this is in the record. This is part of it. It's a note that was in the risk management file. Okay, and the fact that it's in risk management, that's very telling. They're trying to say that they put her in this room for a medical procedure for the EEG, but there's no EEG medical records. They just have the video, which they do have. So it's, yeah. Kathy Beatty, if she settled, is she the one that settled for, I don't know, there was like $2.5 million. Let's see. Keep in mind the judge advised the family they can seek criminal charges on the SA. They can pursue that. I'm not sure if it will work. Yes, they can bring criminal charges. Maya is still a minor. No statute of limitations there. Texas. RA has bionic kidneys, man, Mandy. Correct? You'll find out more the more you hang with us. I don't know. I'm some things I'm really good at, and waiting is one of them. It is a hospital record. It's fun to hear them argue against it. And they're like, we don't even know what this is, Judge. Yeah, it's out of risk management file, and it says risk management okays this and everything. It's got the doctor's name, so we don't even know. This document doesn't speak for itself. Judge is like, apparently it does, and it's coming in. All right, let's see. Where else are we?
What more do you need to see?
The Aura ring tracks health, including alerts you when you have sat too long. It would blow up on me. My watch already tells me that I need to stand up periodically. So maybe I should stand up every time there's an objection in this case. That way my legs would be like ripped by the end of this case. Okay. I want the receipts of an EEG. Apparently there aren't any, other than the fact they put her in that room and filmed her. Let's see. Every objection, says Joe. I know, that's a lot of objections, right? We've had close to 100, I think, today, right? Over 60. I think we'll get over 100 today. Bite Me says, Buttercup is busy today. She's getting the snip. She'll be home this evening and will want to go straight to bed. She misses y'all. All right, Rebecca, thanks for the update. Hope Buttercup gets rested up and back to full activity soon. Well, not full activity, but you know what I mean. Take a shot, do a squat, says Nikki. That's my daily workout. Should we all stand every time there's an objection? I think we're at 761. Does that sound right? Do we start at 761? Looks like on Zoom the judge is back, so we should have him back here in just a minute. There's his door. Let's turn on the mics. Mics are still off. Oh, we're waiting for the attorneys to come back. That's why. There's the sound guy in the blue shirt coming up there. We're waiting for him to sit down so we can get the sound back.
There's a lawsuit.
AJ Red Sox says we were at 764 this morning when we started for objections. Yeah, I don't think there's anything about an EEG in the records at all. Okay. Judge is calling the attorneys up to the bench. So let's see if I can give you a play-by-play of that if the audio's on. And I'm not getting any audio. Do get a really good close-up of defense.
Bring the jury.
Defense is nodding. Judge is telling them something. Everyone's leaning in closer suddenly. Still nodding from the defense. Mr. Hunter's responding. Judge is talking with his hands. It was Sally Smith who settled, not Kathy Beatty. Okay, thank you. Still Mr. Hunter talking. Judge is listening now. I think a plaintiff is talking now. We have a close-up of Mr. Altenberg's lips, like this much of his face. That's the only thing on the camera right now. Judge is still standing. Everyone's still up at the front. Mr. Altenberg is nodding vigorously. And now he's speaking. Can only see his chin now. Mr. Shapiro just pulled out his phone. Appears to be, is that Tinder? No, email. Sorry, my bad. Sorry, that was supposed to be funny. But he did pull out his phone. Swiping with his thumb. Looks like he's swiping left. Mr. Altenberg's still talking. Judge is standing with his hands behind his back now. Listening to Mr. Altenberg. Judge is swaying side to side. Now I can only see Mr. Altenberg's neck. And it appears he is still talking. Periodically, the chin comes into the picture. So, man, this is good stuff. I wish I could show you this. Mr. Altenberg's going on and on. Very verbose in this portion. Judge now holding still, hands back behind the back, still standing. Mr. Shapiro's put his phone away. Mr. Whitley is standing sideways because the bench is very crowded. So his shoulders to the judge. Judge now talking with his hands again, using this motion. Judge just nodded, saw his chin. Attorneys are listening. Mr. Shapiro swaying side to side. I don't know who's going to win this one. We don't know what it is. The judge called this sidebar. Appears the plaintiffs are speaking now. Looks like Mr. Anderson. And both Mr. Anderson and Mr. Whitley are shifting. Mr. Altenberg's now speaking again. It's a beautiful dance, Petrified. They might be speaking about this, the need for a limiting instruction for the jury and how that might be crafted. I get a side shot now of the tie of Mr. Shapiro, and from the side the knot is protruding quite a bit, like it's the most protruding part of the tie. Didn't notice that when it's straight on. Mr. Whitley has a tie bar holding his tie in place. It's the only one I've noticed with the tie bar. Mr. Altenberg is using his hands now to speak. He's using this motion. Judge has clasped his hands together in front of him in this fashion. Mr. Altenberg, left hand, you can see the ring on his hand quite clearly. He's now doing numeral gestures. It looks like number 3. He keeps emphasizing 3. Keeps bouncing the hand in this motion. He appears to be counting something, now using his thumb. Mr. Shapiro has brought his legal pad up to his chest and is clutching it protectively. Judge now is back to the dividing motion with his hand, and with periodic jabs from the other hand. Judge now brings his hands together, has interlocked his fingers a little bit. Made a fist now. He seems angry. Nope, he's not angry. Oh, fist is open again. Hands clasped together one more time. General motion and swaying from all attorneys, which might indicate there might be wrapping up here shortly, or or close to a conclusion, as they've all shifted in anticipation of returning to their seats. Mr. Altenberg has leaned in so close to the camera that I can only see portions of his cheek. The full screen is covered by his cheek. I can't even see his ear. He apparently is listening intently to the judge, who is now scratching the back of his knuckles with his other hand. Mr. Whitley is looking down at the ground. His lower lip is protruding slightly. Mr. Altenberg is rubbing his face. I can see through his glasses from the angle we're sitting right now. Still concerned, caressing his face, pushes the glasses back on his nose, continues to massage his face and look down at the ground. And then head pops up, and Mr. Altenberg is speaking. It was with a lot of energy there. Mr. Shapiro still now waves his hand dismissively, but still clutches now his legal pad with both hands tight to the chest. Mr. Shapiro leans in now. Mr. Whitley still protruding lip, looking down. Mr. Shapiro takes a step forward, now leans in, listens to Mr. Altenberg, shakes his head. Pursed lips from Mr. Altenberg. Judge's hands clasped behind his back, still standing. Mr. Whitley leans in to whisper something to Mr. Anderson. Now they're starting to turn and shift. Mr. Altenberg has now stepped away. It's back to the judge. Mr. Whitley talking with Mr. Shapiro amongst themselves. Does not seem to be a lot of agreement there. Mr. Altenberg goes back to his cheek position right in front of the camera, while Mr. Shapiro reaches up and almost reaches over towards the judge over the desk. Now leans forward. Mr. Shapiro leans far forward just so I got a good shot of his neck. The female defense attorney, we're calling her Cruella, is the only one who's off camera here. The witness chair is empty at this time. Nobody's there. Discussion continues. Judge still standing, hands behind the back. Mr. Shapiro talking now, moves center stage. His legal pad is down at his side. He seems confident, chest out, tie protruding. Mr. Anderson now shifts. His shoulder is now pushing the camera, possibly turning the camera. The suit looks as good as ever on Mr. Anderson with that little cross-hatch pattern. Lots of hand gestures now. Judge still standing, listening. The attorneys have moved out of the way. We can see past the defense table to the back corner of the room. The camera barely cuts out the jury box from this view. Mr. Shapiro leans forward. Judge speaking now. Judge swaying back and forth. Mr. Whitley leans forward, whispers something to Mr. Anderson. Mr. Shapiro prepares to speak and steps up to do so. Mr. Altenberg has his head down again, can see through his glasses and see, oddly, a strange reflection of Mr. Shapiro through Mr. Altenberg's glasses. The judge is standing in a way that I can see the top of his tie and the top of his collar, but not his neck. Mr. Shapiro now is rubbing his face in the same manner that Mr. Altenberg was previously. Now he's caressing the bridge of his nose. No indication now that they are any closer to being done than they were when they started. Mr. Anderson's almost completely blocked the other camera. Mr. Shapiro waves his legal pad in front of him. It's now made a fist and is speaking emphatically, bouncing his fist in the air. Leans forward. The judge has leaned forward as well. You can almost barely see part of his tie with just the whole camera obscured by his robe. They must be just inches from each other. The cameras are almost fully obscured because everyone's so close to them at this point. Although I'm almost able to read the writing on Mr. Shapiro's legal pad, which I will not do. But he's holding it in such a manner that it's not closely guarded to the chest. The pages folded over the top appear to have some sort of writing on them. Mr. Whitley now has strayed into the other camera view as Mr. Anderson has taken up the one that plaintiffs typically are seen in. Mr. Hunter now, who appears to be hunched over the desk, has stepped back a little bit, is now encroaching on Mr. Shapiro's space. Mr. Hunter appears to be directly in front of the judge. Video is great, but sound is amazing. We could do so much better if we could hear this. Right, Mr. Whitley now has his arms crossed in front of his chest. Very defiant. He's stepped back a little bit. I don't think he's happy with this ruling. You can see him in two cameras now. Mr. Anderson now blocks the camera again. Mr. Shapiro is now speaking with his hands again, using his left hand to do various shapes. Well, his right hand still clutches his legal pad protectively. Judge now has his hands out, doing all sorts of strange things like this with his hands. Mr. Shapiro still emphatically gesturing. Conversation continues. Mr. Shapiro is not done speaking. Mr. Anderson now has made a major shift. To almost saw the chest pattern of his suit, so he must have turned to look to Mr. Whitley, who still stepped back with his arms folded. Mr. Altenberg inadvertently hits the camera lens with his right hand, has now stepped back out of the way, realizing he's crowding the space. Mr. Shapiro's front and center. He leans over to talk to Mr. Whitley, shakes his head, turns back towards the defense table. The judge now speaking with his hands again, explaining possible ruling, possible implications. Judge's fingers still caressing the other hand. He's scratching one hand with his other hand. All the other camera angles are just filled with suits and ties. There's almost nothing else visible. Judge drops his hands to his side. Mr. Altenberg has leaned forward and is standing directly in front of Mr. Shapiro, who's also leaning forward. Mr. Whitley has now stepped forward again. Mr. Whitley has his pen in his mouth and is holding it with one hand, other arm still folded across his chest. Mr. Shapiro still speaking. Judge has his hands behind his back one more time. The pinstripe suit of Mr. Altenberg is now filling one frame of the camera. I can barely see in the corner space from Mr. Shapiro's tie. The judge making strange gestures. Mr. Shapiro leans into the camera to whisper, just seeing his lips move while shaking his head while whispering. Mr. Whitley still has his head down, still frowning. His arms now clasped behind his back, like the judge. Mr. Shapiro gesturing again, emphatically, head nodding as he speaks.
4 gang signs.
What was that? Who said what?
Please read books to us ad law.
Oh my goodness. Ella, thank you very much. Also, it's Chilo? Cielo? I don't know how to say your name. Thank you very much. Judge is back to drawing on his hand with his other hand. He's doing repeatedly slapping the back of his hand on the palm of his other hand. He's now made gestures that seems to be dismissive in nature. He's swaying back and forth, turning back towards his chair. We have the back of the suit available. We can see Mr. Altenberg has now stepped away. The camera is clear. The female defense attorney is turning his way as well, walking back to her side. Mr. Hunter is still up at the desk, as is Mr. Anderson, although they switch sides. Mr. Whitley's back at his chair. Judge returns to his seat. Mr. Hunter's returning to his seat, and just like that, all the action, as fast as it started, is now over as the sides prepare to continue with court. So who says sidebars are boring, right? The bad part about that is all we're going to hear is your witness or something like that. So we have no idea what just happened there. Maybe Jules can tell us. Maybe Jules has heard what happened. And we're back. Jury's coming in.
All right, jury's entering.
Next time I'll do golf narration. Very dry, very quiet.
Okay, please be seated, everybody. Okay, members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation, and you did and you received no information. Is that all correct?
We received
and has
no
anyone
information.
approached you about this case? And have you seen any media coverage about this case?
No.
Their loss.
And the doctor's taking the stand again. You can. And you understand you're still under oath, sir?
Yes, sir.
Okay. Mr. Anderson, you may continue.
I'd like to pull up trial exhibit 2277-068. Is that in? Yeah, that's in. That's the one we just got in. 2277-068. All right.
This witness has taken all the available water.
I'd like to orient you to a few phrases here. In the center bottom of the page here, there is an inscription that says "Okay from risk," and then and we can highlight that. Now, based on your experience and knowledge, and I'll represent to you, this came from the risk management file. Does this appear to be a form of authorization from a risk management department, given the circumstances?
Judge, conclusion, lack of foundation, relevance.
Overruled, you can answer.
Amazing play-by-play are aided with editing.
I don't have enough information to make that conclusion, sir.
Assume for the purposes of this question that in fact, is a risk is referring to a risk management department. All right, so if you then look up in the top right hand, it says to see if she can walk on her own. Do you see that?
I do.
And then above that, it points and says something to the effect of no video.
Apparently in the PICU?
Right.
Right.
And then below that, it says video only, no audio.
Correct.
Right. And then if you go down here, in this box on the lower right,
able
highlight the
to
dates.
do when no one was there, I believe. And then
That was the
finally,
bottom right-hand
on
corner.
the
Able to do when no one was
bottom
there.
left, it says, no order, dash, and above it, videotaping. And I'll represent to you that this is from the Risk Management Department. Now,
The whole thing's
based
highlighted.
upon your background, training, and experience, does this appear to be an analysis of a medical need or an analysis of another need to prove something, a diagnosis or whatever?
Objection, leading relevance foundation.
This does not look like a traditional order, which would be electronically submitted in an electronic medical record. This looks like notes taken. You said it's from the Risk Management Department, so I would say that these are notes taken of a briefing or a meeting where it's decided based on this history, based on this need, we have the okay from Risk to do videotaping without an order.
And then in the center of it, it says suspected Munchausen syndrome by proxy. I know you're not a psychiatrist or psychologist, but are you aware of whether suspect Munchausen syndrome by proxy is a diagnosis of a parent or a child?
Objection, Your Honor. Foundation, competence, relevance.
Sustained.
What, if anything, do you know about Munchausen syndrome by proxy?
Same objection, it's beyond scope.
They want to get in that that's a diagnosis of an adult, and nobody at the hospital is authorized.
And finally, I'll point out here in the center above, it says Dr. Smith, Sally Smith. Do you see that?
I do.
And Dr. Dees and Dr. Smith, Sally. You see that?
I see that.
And have you seen in the records where these two doctors were participating in the ordering of this video?
Objection, foundation.
I ask you if you have.
Overruled. You can answer.
I have not seen that specific order, but I have seen both doctors referenced throughout the stay.
Okay. And have you had an opportunity to investigate, as part of your the assignment here, the role of Dr. Sally Smith in all of this?
I have.
And did it come to your attention that Dr. Smith was the director of child abuse education at Johns Hopkins All Children's Hospital during the relevant period of time?
Objection to relevance foundation.
Overruled. You can answer.
I believe that she was head of that program from 2015 to 2018, if memory serves.
And let's pull up Exhibit 2116. And that's in evidence, Your Honor. That's a committee, I believe. Messages. Now, if you take a look there with Dr. Smith, does it appear Dr. Smith and Dr. Paola Dees were messaging back and forth?
It does.
And so it says, FYI, we were able to move her to a video room last night. Staff has been making notes while watching her remotely. Apparently she's currently sitting in bed with legs crossed and has a laptop or something propped up on her lap.
Objection to leading.
You see that where it's written there?
I do see that.
And I'll ask you to assume, for the purposes of the question, that the videotaping in question occurred October 18th and 19th, 2016. And then below it says, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I see that.
Objection, Your Honor. Reading the document speaks for itself.
It's a predicate. So, if this type of communication was brought to your attention in your roles as director of, again,
Chief Medical Officer,
where two doctors were conversing in this manner about a patient and a patient's mother, what, if anything, would be your concern?
Objection, Your Honor. Speculation, foundation, relevance.
Overruled.
at a minimum, I would address their method for discussing the case and the tone and characterization of their discussion.
Does this tone and characterization, based upon your knowledge and position, both as a physician and as a medical director, does this appear to be a compassionate concern for a little girl?
Objection, foundation, relevance, leading, speculation.
Overruled.
In a word, no.
And should doctors be trying to set up their patients to see if their symptoms are correct or not? Or
I'm
real
sorry?
Or not? Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Objection to relevance, 403.
Can you, Mr. Court Reporter, can you re-ask that one for me?
This court reporter is not very loud, so we have to listen carefully here.
Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Sustained on that one.
I'm going to leave that be for now. I'd like to pull up 2277-630 and 631A. And this is, for the record, an email between Patty Condon, who I'll ask you to assume for the purposes of this question was one of the risk management personnel.
So the transcript's clear. We're looking at 2277-630A, not
A.
Yeah.
Did I say 8?
I think you missed the A.
Yes, sir. Thank you, Judge. Now, I'll also ask you to assume for the purposes of this question that Louise Burns-Kurth was the chief, I guess, of the risk management department. And I'll ask you further to assume that this involved a transfer or a discussion of a transfer out of the hospital. And finally, I'll ask you to assume that the Kowalskis would like to get the child out of the hospital, but refuse to do it to a inpatient program, any type of psychological or psychiatric program. Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of a antagonistic relationship?
Objection, relevance, leading, 403, assumes facts not in evidence, improper hypothetical.
Can I have that one again, Mr. Court Reporter, please?
Just a second.
Seemed bleeding.
Also beyond the scope of the pleadings, Jeff.
Let's throw one more thing at the wall.
Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of an antagonistic relationship?
I'm going to sustain the objection.
What, if anything, does this email tell you about the risk management position on Maya Kowalski being transferred out?
Same objection, Your Honor. In addition, vague.
You asked about a relationship between the patient and the family. I believe you meant the caregiver and the family?
Yes, sir.
This looks more antagonistic than collaborative.
And are you familiar with the problem of a medical narrative starting in a hospital about a patient or situation?
Objection, Your Honor. Relevance 403, beyond the scope of the pleadings, and I think it's assuming facts, not an evidence.
Sustained.
Mr. Hunter is
What, if
taken to
anything,
just
have
staying
you experienced in terms of a narrative, that is a story based on a selection of facts and ignoring other facts to prove a point or make a point through the course of your experience in hospitals?
Same objection, Your Honor. In addition, he's used the prior question to suggest an improper question to the witness.
There's a new one.
Can we scroll down?
Use the prior question to suggest an improper question to the witness.
So,
Mr. Whitley's walking around handing
all
things
was
to
the last answer.
Mr. Anderson.
Let's proceed. Now, can we...
It's 2142.
2142, you want to publish?
Yeah, it's in evidence.
It is.
Here comes an objection.
If you could review this and see if whether Dr. Sally Smith appears on here.
She's listed on the Standards and Credentials Committee, four names down.
All right. And did you have the opportunity to speak to this objection?
I agree with that.
With what?
I agree with it. We don't need him to basically read the document.
I understand, sir. I just wanted to identify that she was on that. Now, did you have the opportunity through your investigation to try to determine the role of Sally Smith in the care and treatment of Maya Kowalski?
I did.
And what did your investigation reveal?
Objection of predicate lack of foundation, Your Honor.
You can answer.
So Dr. Smith was head of an outside agency, but had an internal.
I'm going to sustain the objection.
Okay. What, if anything, did it appear to you in reading through this as to Dr. Sally Smith's role at the hospital?
Excuse me, Your Honor. Object. I don't know what he's reading through. I don't know what he's being asked.
I don't know what.
I assume you're talking about the committee list?
Yes, her overall role at the hospital based on what we've already...
For a second.
Okay, we're back on approach. Here we go. Everyone's back in their usual positions. Witness is still on the stand, though. The chair is not empty. Judge is standing. Mr. Shapiro has taken Mr. Altenberg's position. Mr. Hunter is standing directly in front of the judge, objecting. MJ Lynn, welcome to the gallery. Good to have you here. Thank you very much for supporting the channel. Make sure you take your seat and help yourself to the emojis. You guys can see on the stand what's happening, so I don't have to cut away and describe everything. They're done. This is a quick one, so give them a minute. On Zoom, they're already back to asking questions, so just give them a second here as the feed catches up. Objections everywhere. Quite a few objections. Sorry.
I'd like to publish then 2045-005. This is a statement. Actually, is this in evidence?
Yes, it's in
All right. May we publish, Judge?
It's in evidence, yes.
All right, I'd like you to review that statement to yourself, please, Doctor.
Beautiful picture. Looks like one of those lenses that your real estate agent uses to take pictures of your home to make it look better than it actually is. Slogan that stands out is the all we do, all for kids. It's more than just a slogan. It says in our blood as caregivers. Patient safety and quality of care are the prime directive for our
Do you have an
hospital.
opinion based upon your background,
Driving
training, and
everything
experience
we do.
into a reasonable medical management probability as to whether, based on your review of the facts of this case, Johns Hopkins All Children's Hospital lived up to or complied with the statement by Dr. Mueller?
Objection, Your Honor. Relevance, foundation, lack of predicate in 403.
Sustained.
What, if anything, did you see in this organization to indicate that there was a defined chain of, that there was a defined leadership or lack thereof?
Same objection, Your Honor.
You're going to overrule that objection. You can answer that.
So the indications have been consistent that quality assurance and performance improvement was to be organized at a division level. And the divisions report up to departments. There appeared to be no system-wide approach to quality assurance and performance improvement.
What's the problem with that?
Well, for starters,
Objection, Your Honor. It's vague. It's calling for a narrative answer. It's calling for a lecture. It's outside the pleadings. It's 403 violations as well.
Overruled. You can answer.
so first, it's an expectation that I was held to every time that I was at the facility or division and participating in a regulatory survey, that we could demonstrate a system-wide approach.
Why is that better?
Well,
You can answer.
it sounds great to have everyone responsible for quality and patient safety. But we've all experienced it that when everybody is responsible, nobody ultimately is responsible. So without oversight by a leader like a VP of quality, a VP of medical affairs, a chief medical officer, somebody to make sure that there was a consistency, you had wide standards from one division to the next, and that creates gaps where patients can fall through the net. And this, my experience in reviewing the system that the leaders have addressed and touted, is that this was really a system-wide failure that allowed Maya and potentially others to fall through the gaps.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the system that was set up by Johns Hopkins All Children's Hospital in operation provided sufficient safeguards to protect children in Maya Kowalski's position?
Objection, Your Honor. Foundation, relevance, 403, improper hypothetical.
Sustained.
What, if any, opinions have you formed about the ability of the system you just testified to protect children who are in a situation such as Maya Kowalski was during October of 2016 to January of 2017?
Same objection, Your Honor. We're saying the same question.
I agree, it's the same.
What changes, strike that. How would this system have to be changed, in your opinion, in order to ensure that situations such as a child being allowed to, or being photographed without authorization on 2 occasions, a child having what we discussed before with the not being allowed to see her priest, having things taken from her, these type of events from happening?
Objection, Your Honor. Relevant to 403, leading, it also fails to take into account DCF and Chapter 39 involvement, and it's outside the plea.
That's
Overall, you can answer that one.
So the quality assurance and performance improvement function would need to be overhauled so that it was system-wide. And that's actually something that Hopkins is recognized as a leader in. So the expertise should be readily available to the team at Johns Hopkins Children's Hospital. But that would provide a consistency from division to division, and create a safety for patients as they're being handed off from one caregiver to the next.
Do you have an opinion based upon your background, training, experience into a reasonable medical management probability as to whether the system in place provided sufficient safeguards for children at Johns Hopkins Children's Hospital during the relevant period?
I do have an opinion.
And what is that opinion?
Objection, Your Honor. Relevance outside the pleadings, improper foundation.
But I don't think you tied it to Maya Kowalski, so I'm going to sustain the objection.
Same question as to the care and treatment of Maya Kowalski.
Same objection, Judge. The question's compound as well.
I'm going to overrule that. You can answer it.
I do have an opinion.
What is that opinion?
I do believe that the system failed Maya Kowalski and her family during her stay, primarily because the architecture was so siloed that there was no, there were gaps in the safety net that let her care fall short.
Your witness.
Your witness, here we go. Here comes Mr. Hunter. This one might be spicy. He's going to be attacking him personally. Just calling it now. His abilities, his experience.
Good afternoon.
Good afternoon.
Once again.
Yes, sir.
Your Honor, if the court please, could I first approach the witness and ask to look at the materials he's reviewed?
Sure.
Sure.
Now he gets a moment. Here we go. We think there's something in there. They're going to quiz him on something.
No worries.
Honest.
I think they're going to quiz him on something and see if they can catch him in a mistake. If they can prove that he missed something, wasn't aware of a pertinent fact, shouldn't that have been relevant in your evaluation? Something to that effect. Thal, good to see you here, my friend. It's been a while. Hope you're doing okay. We do try to keep more likes than objections, so as we get closer to the end of the day, I'm going to need a few more likes on the stream, just so we're in the safe zone.
Okay.
They have to discredit this witness in the eyes of the jury. That's the only way they can sort of reclaim some of the testimony that they've just had against them. I haven't seen all the medical bills, so I'm not sure. This doctor is a hospital management
If I
expert.
understand correctly what you just showed me, and what I will ask the clerk to mark when we get through here was a complete list of everything you've reviewed about this case. Is that right?
It is a list of everything that was provided to me. Yes, sir.
Okay. And it was provided to you grouped by issue. Is that correct?
By date and by issue.
Yes. So in other words, if they wanted you to look at issues relating to the surveillance video, they sent you documents regarding that, correct?
That is correct.
And if they wanted you to look at corporate documents, they sent you a group of documents related to that, right?
That's how they're grouped, yes, sir.
Okay. And if they wanted you to look at examples of Dr. Smith directing care, they sent you a group of documents relating to that, right?
Yes, sir.
I'm not sure, Mandy.
And
I don't
then
remember.
if they wanted to have you look at particular documents regarding the surveillance video, they sent you documents related to that, correct?
Yes, sir. That's one grouping.
Okay. So do you have any idea how many pages of policies and procedures and documents have been produced in this case?
Have been produced to me?
No, sir. To the
in
parties.
Jail.
That the hospital has produced.
I understand
the
that
plaintiffs have produced. Got any idea?
I understand the number is in the tens of thousands.
Okay. We can agree, can't we, that you didn't get tens of thousands of documents?
No, sir.
You didn't come anywhere close.
And for the scope that I was evaluating, I didn't need the entire.
Well, so that we're clear, we covered this a little bit earlier, and I'm not going to go back into what I asked you before, except perhaps by accident. But you're board certified in osteopathic medicine, but you've never held yourself out as a pediatrician, correct?
I am board certified in obstetrics and gynecology. I have a
I'm sorry. I beg your pardon.
No worries, sir.
You're an osteopathic physician.
I am an osteopathic physician.
And you're board certified in obstetrics and gynecology.
Yes, sir. That's correct.
And you've never been trained as a pediatrician.
That is correct.
And you've never held yourself out as such.
That is correct.
And as far as your opinion in this case, it presupposes that the diagnosis of CRPS for this young lady was correct, doesn't it?
No, as I explained to you during my deposition, it presupposes that the proper approach should include an evaluation for CRPS.
I see. Okay. Did you ever look at any records of this young lady's care from Lurie Children's Hospital?
Not from the hospital, no.
Did you ever look at any from Tampa General Hospital?
No, I did not.
Did you ever review any complete medical record in this case?
Medical record? No.
Okay. And the depositions that you seem to have reviewed in this case, looking at your list, seem to be somewhat limited. Is that right?
Yes, sir. I think that's fair.
Okay. Well, you reviewed Sally Smith's and Ms. Beatty's and Dr. Elliott, Ms. Condon, Ms. Crane. That's about it, wasn't it?
No, sir. Dr. Perno.
Okay, Dr. Perno.
Dr. Napolitano. There were others.
There were others. Did you ever review Dr. Michelle Smith's deposition?
I don't recall that name.
Okay, well, that's a good thing because she wasn't deposed. Here's what I meant to ask you. Did you ever review her progress notes from the PICU?
I did not.
So you have no idea what efforts were made to transfer this patient during the first week that she was at All Children's?
I didn't review the medical record references to transferring the patient.
Okay, so you don't have any idea what they contain?
I never reviewed the medical record, so I have no insight into what was in the medical record regarding the transfers.
Okay. Now, let's go back to what you haven't looked at. Did you ever look at Dr. Hanna's records? Ever see his records at all?
Not his records, no, sir.
You never saw Dr. Kirkpatrick's records?
Not their treatment records.
Okay. And you've never seen any order in the chart regarding the EEG video or seizure monitoring, have you?
Again, I have not reviewed the medical record because that's not the area of expertise that I've been brought to assess.
Well, you've expressed some opinions regarding the EEG video. What I'm trying to find out is, have you looked at the chart to see what's in the chart about that video?
I don't think that reviewing the charts are necessary to inform the opinion that I shared a half hour ago.
Okay. But you did indicate in that opinion what you thought the chart should contain, right?
I was asked to review a memo. I shared my opinion or insight about that memo.
Were you ever provided any of the court orders regarding this patient?
Oh, if they open this door.
I don't specifically recall seeing the court orders. I may have, but I don't recall it right now.
Going back to Ms. Beatty, did you ever see her personnel file?
No, sir.
Did you ever see any of the evaluations that she had, or annual evaluations?
Annual evaluations? No, sir.
Okay, so you have no knowledge of any of that?
Of her annual evaluations? No, sir.
Okay. And with Dr. Mueller, the VPMA, you know who she is?
I do.
Did you ever see her job description?
No, sir.
You did notice on all the charts here that there was no title called Chief Medical Officer in their lexicon.
And I pointed that out.
Okay. So you're kind of assuming where the Vice President of Medical Affairs fits in? You don't really know what her
I don't agree with that characterization at all.
Well, you don't know what her job description is, do you?
The job description wouldn't be on the organizational chart anyway, but you are correct.
The organization.
I've never seen her job description.
Okay. So you know where the line is. That's about all.
It wasn't represented, so I don't know where that line is, and that was my point.
You don't know where the line is, and you don't know where she fits in.
On that chart, you are correct.
Okay. Well, you looked at several charts, didn't you?
Well, I looked at organizational charts that were provided that apparently were from 2012, which had the position listed.
Wow. He's doing a good job on
You
cross.
talked about the consent. Council put up 3002-002. Had you ever seen that before?
Not before getting involved in this case, no.
Okay. Well, there was a question about the use of images, video in this case, in the course of treatment, correct?
Correct.
Well, diagnosis is part of treatment, isn't it?
I would think so.
Okay. You'd agree with me about that, right?
Sure.
Okay. With reference to transferring this patient, were you ever aware of Ms. Kowalski denying that she wanted to take Maya out AMA? Were you ever made aware of that?
My understanding is that the objection that she had was based on the diagnosis of a psychiatric disorder.
I understand. So your understanding was that she didn't want the child transferred because the child would carry a psychiatric diagnosis upon discharge. Is that right?
I think we heard that they didn't want to accept that as a transferring diagnosis.
Did you ever see any indication that the hospital was asked to reconsider that part of the medical record?
Again, sir, I've not reviewed the medical record.
Okay. No, well, my question wasn't really restricted to that. My question was, did you ever see any indication that this family heard, gee, you're going to discharge our daughter with this diagnosis. We want you to change the diagnosis. Did you ever see any documentation of that?
Where would that documentation be?
Could be any one of 1,000 places. I'm asking you whether you ever saw that suggested.
Only in testimony.
Okay. You heard it in testimony somewhere?
I believe we heard that Monday morning.
We heard that someone asked to change the diagnosis?
No, we heard that the diagnosis was rejected.
I understand that.
Okay.
Listen to my question very carefully, please. Because it's probably confusing, even to me. And I confuse very easily. But here's my question. My question is, did you ever see any indication, any documentation, any indication that this family asked that diagnosis for Maya's discharge that they didn't like, that it be changed?
Documentation? No.
Okay. And under the client's rights you talked about, they had the right to do that, didn't they?
I don't have the document in front of me, but if it's in your hand, I have no reason to question you, Mr. Hunter.
Okay. I appreciate you having a chat with my wife.
Only if you'll do the same, sir.
Okay, deal. Were you aware of any policy at All Children's regarding images and recordings of patients in child abuse cases, child abuse situations?
Can you cite the policy for me?
I can. It's Defense Exhibit 3019-005. Did you ever see that?
Visible? Off the top of my head, I can't tell you.
Okay. Well, I'm not sure it's in evidence, so I'm going to pass along with it right now. But that brings me to another set of questions. In your experience as a CMO in Florida, have you ever worked with DCF?
That never came across my desk.
Objection.
Sustained.
Very well. Did you you told us that you had no role in preparing any consent of the type we talked about earlier. Is that right?
I never wrote the consent. We left that to the lawyers.
Didn't I understand your testimony to be that the medical staff is independent of the hospital?
The American Medical Association was granted autonomy around the time of the adoption of Medicare. So, yes, the medical staff is meant to be self-governing.
Okay. So the mere fact that someone holds a position in the medical staff doesn't necessarily reflect any position with the hospital per se. Is that right?
I disagree with that.
So you don't agree that the medical staff is independent of the hospital?
I don't agree that anyone with a position of authority, regardless of who they're aligned with can't hold a position of influence with a hospital. A board member, a politician, a community leader.
Like yourself?
I'm neither. None of the above, sir.
Well, you were elected president of your medical staff.
I was and unable to serve, but
Okay.
that was when I was in practice. That was a
when
long
you were in
time ago.
practice. But if you had served,
Yes, sir.
that would not make you an employee of the hospital, now would it?
That's correct.
Let me ask you about a couple of depositions just to be on the safe side here. You've never reviewed any of the Kowalski's depositions, have you?
I have not.
And you've never reviewed the depositions of Dr. Kreisman or Dr. Kilgore?
Kilgore, I have not.
Dr. Posey, Dr. Sanchez?
I don't believe it. Off the top of my head, I can't comment about those.
Okay. Well, let me ask you about Dr. Tepa Sanchez while I've got you on the subject here.
Okay.
You talked about, you referred to the text exchange between Dr. Vose and Dr. Tepa Sanchez?
I believe that was brought up.
Okay. Do you know who Dr. Tepa Sanchez is?
From the PICU?
Yes.
Yes, sir.
You know what date she saw this patient?
Not off the top of my head, sir.
Were you aware that she hadn't seen the patient for nearly 3 months at the time that Mrs. Kowalski committed suicide?
Well, she was a PICU physician, and Maya was in the PICU in the early days of October, and that unfortunate message was exchanged, yes, 3 months later in January of the following year.
I think maybe she was referring to what she did 3 months before, not what the hospital did during the ensuing 3 months.
Can you read the text for me so I can
Well,
put it into context?
I've been objecting to that, so I'll tell you what, we'll let the jury hear that from her.
Okay.
But the point is, you never heard from her what her explanation was for what she meant in that text message, have you?
I've never spoken with her, no, sir.
Okay. That's all I have. Thank you, sir.
Thank you, Mr. Hunter.
Mr. Anderson, do you have any follow-ups?
Wow. Did very good on cross. Held his own. This is his first time testifying as an expert
Counsel
witness.
here show you a single document, deposition entry, or any other evidence that changed your opinions in any respect?
No, sir.
Nothing further.
Boom.
Anything further?
Jury.
Members of the jury?
Jury, here we go.
Do you need me to step out, Your Honor?
Look at pens. See how many questions I get.
Yes, sir.
This is for tearing sounds.
I'm learning.
There's a page.
John.
Couple pages.
I'm sorry, what before?
Well, Doctor, why don't you go ahead and step out? Looks like it's,
Doctor's going to step out.
Remark his list while he's at the counter.
that's
The jury, I think, is about to step out. Okay, it just got quiet.
stepping out. Thank you. Members of the jury.
There they go.
Well, no, this goes to Mr. Hunter. I need to. Members of the jury, why don't you step into your room back there? Do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
Go to your room, he says.
All right, let's go right back to highest.
Okay, so red one. Here's the first question. I'm not sure if you're going to hear this or not. The judge says, "What's the name of the witness?" Dr. Cochran. Okay, the first question is Dr. Gies and Dr. Smith still at Johns Hopkins Hospital? If not, why?
Go through these questions.
Oh, here we go. We get to
red
these.
one.
Possibly.
No. Let's just get through this. And what's the name of the witness again? Dr. Cochran. Okay, the first question is, Is Dr. Dees and Dr. Smith still at Johns Hopkins Children's Hospital? If not, why?
There's our first question. Got some more questions coming after a little pause here. The judge is reviewing everything. Sort of pre-reading the messages. No objection from the defense?
Any objection, plaintiffs? No.
No objection. That one's going to be asked.
I'll ask that one. Next one has a couple of questions. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concern? The next question, were the Kowalskis told, I think it's they, could contact senior executives to voice their concern via email, Dr. somebody. Next question is, and I'll put an underline so you can tell me the name of that doctor. Next question, if medical staff works independently of the hospital, then who I don't know that word. I think it might be told them, or who holds them accountable. Who holds them accountable?
Who holds them accountable? Looks like to me.
Yes, hold.
Yeah. But I don't know about the name of the doctor in that second question.
Well, but it's via email or otherwise.
Or otherwise?
Yeah, I think it's a doctor's name, but it's or otherwise.
Or otherwise, okay.
Yeah, penmanship is not their the jury's strong point, but they do ask good questions.
Yeah, we're objecting number 2 is on the basis of foundation. Yeah,
Objections to one of them because of foundation.
Mr. Anderson?
No objection, and if he knows, is number 2, which I think he might, Mr. Kowalski's testimony. He can testify.
Okay, I'm going to overrule the objection to number 2 on red number 2. So I will ask it. Okay, red number 3, there's several questions. Do court orders have an effect on a patient's family rights? If a child is in custody of DCF, do the parents have the rights to consent or deny treatments during the DCF custody?
Ooh.
Have you assisted in a case with a Munchausen by proxy diagnosis in your career? I'm assuming the first 2 are ones that ultimately I'm going to give legal instructions on and are not appropriate for the witness.
Agreed.
First 2 are out.
So that leaves us the question about, have you assisted a case with a Munchausen by proxy diagnosis in your career?
Well, he's not being tendered as any kind of medical expert, so I don't know what matters whether he answers or not.
It doesn't matter to me, Judge.
So either there's an objection or there's no objection.
There's no objection.
Objection.
Okay, I'm going to overrule the objection and ask. And I think the last page. What is, quote, the acuity of the bed, end quote? Please elaborate. What does this mean?
Someone in chat had this
During
question.
this review, the question was regarding the, is it acuity of the beds? Not sure what that word means in this question. I'm sorry?
Yeah, I was talking to myself, Judge. I'm sorry. Bemoaning the fact I didn't define that.
He's
Did you
kicking
answer
himself.
yourself if you're asking yourself the question?
The jury doesn't know what he's brought up.
So no objection? Is that, Mr. Anderson, no objection? No. Okay. Before we bring the jury back, I'm assuming this is our last witness today.
I could probably get.
Mr. Anderson says, I could probably bring in another witness. Mr. Whitley says, no, she left for the day.
Okay. So it sounds like this is our last witness. And I'm going to tell the jury 9 o'clock tomorrow. Is that what we all decided?
Yes, and then we'll start with the video depots, and then.
The Georgia.
Why don't you get the guardian ad litem up and down and then do videos? Well, it's up to you, Mr. Anderson.
If she wants to get back, if she wants to get home, she's gonna want to go first.
Yeah, I was just trying to take off tomorrow morning to get those exhibits together. Yeah, we can call her first, and then.
Well, we can talk about it.
Yeah. Let's bring back the jury.
Bring the jury. There we go. Charlie says the jurors are asking questions like they know the answers. Acuity is the kind of workload or demand level of care required for each patient, says Lizzie. Thanks. We're going to hear that from the witness, hopefully, if he knows that as well. I think they are scheduled to take some time off, but not aware of any between now and when the plaintiffs are going to rest their case, which is Monday.
All right. Jurors in. Answer it.
Brooklyn, thank you. Thank you, all of you. I appreciate the likes. That definitely does help the channel. I appreciate that. Kim, a gift is a membership.
Everybody.
A membership.
Members of the jury, just want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And I want to confirm that you've not been approached by anyone about this case since you were last with us. And you did not see any media accounts. Is that correct? Okay, Dr. Cochran, the jury has several questions. First question, if you know, is Dr. Dees and Dr. Sally Smith still at Johns Hopkins All Children's Hospital?
I don't know for certain. I understand that Dr. Sally Smith has...
If you know or not?
I don't know.
Thank you. Okay. Next question. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concerns?
That's a very reasonable expectation, and I believe that that's the way it should work. I can't say that the system in place in 2016 provided for that.
Not sure how that got messed up.
Were the Kowalskis told
Welcome, Beth. Or welcome, Kim.
they could contact senior executives to voice their concerns via email or otherwise?
I don't know the answer to that.
If medical staff works independently of the hospital, then who holds them accountable?
That's a great question. And the Medical Executive Committee, which I was a member of for 4 years when I was in practice, is responsible for oversight of the physicians for quality assurance, performance improvement. And the Medical Executive Committee has a relationship with the board of the hospital so that everyone's on the same page. I hope that answers the question.
The next question, and for the author of this one, I'm only able to ask one. Have you assisted in a case with a Munchausen by proxy diagnosis in your career?
I have not. I practiced obstetrics and gynecology, and I'm happy to say that that was not part of my experience.
Next question.
what is the acute, quote, the acuity of the bed, end quote? What does this mean?
That would be a better question for Mr. Hunter, but I believe that he was referring to how sick of a patient can you care for? Some hospitals, like Venice Hospital when it was around, was a lower acuity. Sarasota Memorial Hospital takes care of sicker patients, so it has a higher acuity.
Mr. Anderson, that completes the jurors' questions. Do you have any follow-up questions?
No, sir.
Mr. Hunter, do you have any follow-up?
No.
And may this witness be excused.
Please.
Please.
Although he's still under subpoena.
Okay, so.
Please, although he's still
you're
under
free to
subpoena.
go today, but you still might be called back.
So.
Okay. Have a good day.
If you have not received a gift and in a while and you've interacted a lot, you might want to go back and just make sure that gift setting is still turned on. That means this button
Members of the
slid to the
jury,
right.
I think this is a good point for us to stop the witnesses for today. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. 9 o'clock the same time. We will see you tomorrow.
9 o'clock for the jury tomorrow. Let's see what time we come in. I think we're going to do a little bit of work here with the jury gone. Maybe some evidence stuff. Talk about, obviously, we have to do the shot clock to see where everyone stands on the timer. We also have to maybe discuss who's going to be on our witness list tomorrow. We got a preface to that. They say Jessica. It says Jessica Blackjack, but I'm not sure if it's Blackjack. Jessica somebody. Deborah Salisbury, Brian Gillis, Eli Newberger, Dr. Sally Smith, and the Kalowskis, if we have time.
Do the shot clock while I'm thinking about it.
So we should expect the family back in court tomorrow if they're
The
potential witnesses.
Plaintiffs consumed 3 hours and 20 minutes today. Their running total is 36 hours, 10 minutes. The defense consumed 40 minutes today. Their running total is 12 hours, 50 minutes. Are there any issues we need to address before we?
Well, just to be helpful, Judge, there were a couple of objections on the Dr. Newberger's that you had some question marks, and if we could look at those so we could get rulings on those.
Sure, and I think
have a
part of
copy
it.
for you.
Okay, that's great, but I think maybe it was a miss site or.
Well, I think it's just the way they designated it, Judge, so,
Discussions on
Nick,
this
do you
chat are
mind?
always so
Can you mind
interesting
looking
and
with me?
fun.
Sure. Which
Okay.
one?
Virginia, thank you very much. Appreciate that. And
So,
Samantha, thanks for
on
the
page
gift of the
3,
membership as well.
you had a question mark of your order, I'm sorry, of your,
So this is the
it's
September
actually-
22nd, 2020 deposition. And you bring up page 145?
yes, yes. So I have a copy of that page of the DEP, Judge. I meant to object 145-15, the word indeed, through line 21. So,
This isn't the right one.
so if I could,
Add one more objection there. She forgot to object, but she wants to object now. Not quite timely, but
and the objection
as soon
was
as
breaching
possible.
standard of care regarding Dr. Smith's role as investigator.
Very British. You want the party sound because we hit 100 objections.
So you're suggesting that the lines 13 through 15 before indeed are okay by you?
Well, can I see it again, Judge? I don't think I objected to it. It was all blurred.
So she just said, hey, I objected to something, this part.
Well,
And he says, so you want the rest is okay?
Yeah, I will sustain starting at the word indeed at line 15 on page 145 through line 21.
okay.
Okay.
And then the other one has to do with plaintiff's designation. You questioned on page 4. It's the September 30th, 2020 deposition. I went back and checked. They did designate page 183, line 1 to 12, which doesn't have a question. That's what they designated, Judge.
Okay, so what I put on here is I would overrule if the correct page site, so.
Well, I have the deposition for you on if you want to look at the page. But the line 1 is hanging there. There's the page before it's not designated.
Which is why I added a question mark.
Oh, it looks like we failed to designate. We would designate the last word of the question, but we failed to designate the question beginning at page 1.
I'm okay with the question because I remember last night going back and looking at it. And,
Okay. Can I look at it real quick, Judge?
Sure.
So you want to start on page 182, line 23? Is that what you're saying?
Yes.
Okay.
They're dotting the I's and crossing the T's right now.
And then did you want line, can I ask counsel? Did you want line 12? You designated
No,
line
that
12.
just looks to be
Okay.
sloppy highlighting.
Okay. No, that was your designation. I went and checked.
Sloppy highlighting translated to a designation.
Okay.
Welsh law student, good to have you here.
Understood.
Love the name
I think those were
too.
your only 2 question marks, Judge. Just check real quick.
Much respect for anybody who's studying law. I thought it was
Maybe I should
50
just put
hours.
an S or an O.
No, we can read sustained. But it might help your time.
The attorneys on the defense side, they have a lot of them, and they divide up a lot of the work. So you'll see certain types of objections from certain lawyers at the end of the day.
Yes. All right, thank you, Judge. That was the only question marks I saw.
Any more designations coming anytime soon, or?
I don't think so.
I don't think so.
I don't think so.
So just to confirm, counsel, tomorrow, Dr. Newberger by deposition, Dr. Smith by deposition, the guardian ad litem. Anybody else?
Are we doing a half day or a full day tomorrow? I didn't know the outcome of that discussion.
Whatever you decide, but we just need to know on the defense side. Please don't surprise us.
I am looking to both sides. I will do whatever you all want to do, so long as you can agree.
It's like, by the way, in the morning, you can work in the afternoon.
I just want you guys to get along.
Richards, and you'd have Debbie.
Yeah, we can take tomorrow afternoon off.
Tomorrow afternoon off, get a half day.
Be able to get her in the morning, considering how long are those depots? I wouldn't mind taking the afternoon off, and we'll get absolutely as much in as we can in the morning. Maybe take a late lunch.
Okay, so
Keep through.
Oh goodness. I'm not going to be able to have you in tomorrow until 8:45.
8:45 start tomorrow.
Won't have the ability to have any lengthy discussion. But I guess if you're playing a whole bunch of depths, it doesn't really matter. So we'll start tomorrow at 8:45.
Yes, sir.
So we'll start at
We're
8:30.
starting at 8:45.
And to be clear, Judge, my understanding is the first 2 Newberger deps are being read in. There's only the video for the last dep.
I think
Acting
someone
class.
said that there was no video for depths 1 and 2. So
That's what I'm saying, Judge. Those are being read in.
That's true. We'll have to read the first couple.
well,
That could
I'm sure
be
you'll have readers.
incredibly.
Sounds like that's the plan, just those 2 depositions
Boring.
and the guardian ad litem, and then
So did you want to? Because for a while you were talking about putting Maya and Jack Kowalski back on.
I think Thursday.
Tomorrow is Thursday.
You know,
It's like I think that's Thursday. Tomorrow is Thursday.
I can't take it off. We've got to put them on because we've got the damages people the next morning, Friday morning.
Okay, so
Half day just
so
disappeared.
Tomorrow will
No
be a full
vacation.
day, and then is it Jack Kowalski and Maya Kowalski coming back, or just Jack, or
It's all 3.
Jack, Kyle, and Maya.
They're
coming back for the damage testimony.
as well?
Yes, Your Honor. But it's simply limited to the general damages, although I would like a stipulation of some kind about the liens, so I don't have to get into that with him. I will if there's no stipulation. I'll try to work out an instruction.
Your Honor, the difficulty on the liens is, that they want an instruction that basically tells the jury that they will owe the liens, if a verdict is entered. And one of the liens, which is about $10,000, appears to me to be a straight Medicare or Medicaid lien. Medicaid. And I know that they always maintain, well, we get it no matter what. The judges normally say we get it only if there's an award of medical damages on the verdict.
But wouldn't I have to do, is it an all-born hearing on that?
That's why we normally put this off to the end to let the judge decide, because mostly it's legal resolutions based on things. The second one is an insurance policy claim. I've not seen the policy, and it's not like it's a hospital lien or a statutory lien. It's something out of a contract. And even then, normally these things get negotiated or resolved afterwards to lesser amounts. So
Is it an ERISA plan? Because that even further complicates it.
I don't know the answer to that.
Judge, we don't know whether it's an ERISA plan, whether it's a lien, or whether it's a right of reimbursement or a right of subrogation. And all that makes a difference. And
There's an LOP and there's two liens, as far as I know, and I believe, don't quote me on it, but I thought Jack Kowalski said he paid, either by mistake or just paid down part of one of them. The only thing I'm interested in, Judge, is that I don't get a DV on damages as to that, because a contingent liability like that is still a damage. And so if counsel is willing to go with that, then we can save all that till the end.
I'm willing to resolve the liens at the end of the case like we do in every other case.
What I'm hearing him say is that you would not move for directed verdict on that they failed to present
that
the
special medicals,
the damages.
And on the claim for fraudulent misrepresentation of the bills, is what we're talking about, right? That claim?
Right, yeah, that's what it is.
Yeah, I might move for DV on a bunch of other issues, but not on that.
So it sounds like we have the beginning of an agreement here.
Whoa.
Yeah, I won't
New
move for
territory.
directed verdict on that count because you don't prove that stuff up. I absolutely will not.
All right, so I don't have to put in the liens for damages for proof of the fraudulent.
Right, and
Right.
for the record further, I don't think you need to put that evidence in for proof of any of your other claims. But maybe we may still need it.
Mr. Hunter seems to have a
maybe not
dissenting opinion.
I have an issue.
While they're talking, Mr. Anderson, I would imagine the cross will be relatively short if it's truly damages and we're not rehashing causation and liability, so we should be able to get through that schedule. Anyway.
I have nothing planned in terms of anything other than how did this affect?
I assume that, and assuming that's true, the cross will be short.
And what is it cost?
If ultimately we decide not to call somebody tomorrow, can we just send a note to the other side?
Yes, please.
Midnight.
Even if it's at 10 at night.
Okay, so going back to our possible agreement here, you've conferred with Mr. Hunter.
Yeah, I'm not going to move for DV because they don't have proof that they paid that. And right now, I don't think they have proof that they paid anything else, but I won't move for DV on that either for purposes of that count.
Okay. So are we both sides agreeing? We have a court reporter here. We're in open court. So is that an agreement?
Yes, as I
We have a
understand
stipulation.
the defense's agreement, they will not move for a directed verdict based on the element of damages, since the majority of our damages has to do with liens, which should be resolved, should not be put before the jury, and should be resolved afterwards. based on that stipulation, I will agree not to approach the issue with my client as to the 2 liens and LOP, I believe it is. Are we in agreement?
And I concur in the agreement.
Thank you. So let's move on to the next issue.
Concern here?
No, I was just going, I thought we were done. I was going to.
We're finished with that issue.
I was just going to rebroach. I didn't get who's coming tomorrow, I suppose.
Let's talk about the following week. So the following week, it's Wednesday. Is it Wednesday that we're not here?
Yes.
Okay. Are we going to be in a position, and Mr. Altenburn, to have a meaningful discussion about jury instructions maybe Wednesday afternoon? I've already kind of given the morning away for other things. I'm just wondering, I
was thinking about going back to Tampa, but yes, we can do that.
Well, I'm just trying to figure out when we're going to have time to talk about it.
I understand. Right. I sent a draft to Mr. Elegant on Sunday saying, please redline these and send it back. And that hasn't yet. And I bet that's because he needs to talk to them, and they've been busy. By the way, I've also sent him a draft of what I discussed a couple hours ago with him, and I know he needs to still talk with them, but I would really hope I could give that tomorrow morning. That's all.
Mr. Altenberg always wants
of that,
to address his issues, and it never
it
happens.
also helps mean if we get by the DV, then we know exactly what the package looks like.
Well, I'm certainly hopeful that we will have rested the plaintiff's case by then, and even if we have to do DVs over lunch or go late or something.
And I think by this weekend I'm going to know what all the evidence is, so I can try to put together my thoughts on that. So I'm ready to go whenever on Monday.
Yeah. So I just wonder if Wednesday afternoon is an appropriate time to start talking about the jury instructions, given that, I know that not all of you have to be here. Maybe it's just Mr. Elegant and Mr. Altenburn to have this discussion.
Because I don't think I'm going to need to be in the courtrooms so much when we're putting on our case. So especially if we were doing our case on Tuesday, I could work with Mr. Elegant a whole lot before that meeting.
And I could probably even handle you all on Zoom.
Okay.
If you wanted to,
if you wanted to go
that way we
to Tampa.
Yeah. We could even be in the same room together, probably, if you wanted to.
Well, you and Mr. Elliott?
Yeah.
Yeah, it's just so long as I actually physically had whatever you were looking at.
We work well together, work with friends. So.
You think
Zoom's
that's
an issue.
doable?
That's an issue
Wednesday
for us.
afternoon.
I do, but I'll send an email to Tom to see how far along he is on this as well.
Can you let me know like tomorrow so that if the answer is no, it's not doable, then I'll probably give the time away to others. But
Gotcha.
Before y'all get first dibs on my time, so I just.
Yeah, I was hoping to have this done by the 20th of August, so I'd be happy to have them done on Wednesday.
Anything else?
No.
Judge, on Williams' rule on this has to do with Sally Smith, has to do with the parent agency, and I've got 2 witnesses, and they're going to say that Sally Smith walked in and did the same thing to them. She did the Kowalski's. Their testimony should take about 15 minutes each.
What is the specific issue? Because it's got to be. I don't have the list right in front of me.
Plan, motive, opportunity on 9404, substantially similar incident. So each one of these cases, in fact, one of them ended up almost identical to this, the Kushner case. And this is situations where Sally Smith walked in, either announced as a doctor or unannounced, wearing a lab coat and the badge, and then comes in, quote, examines them, asks a bunch of questions, walks out, and they never find out until much later that this was actually a doctor who was interviewing them towards a prosecution. And in both cases, of course, they did end up prosecuting, but that's not part of the question. That's just simply, the only question is, did you have this happen to you, so that we can show a plan, motive, or intent in terms of why they do it. And
under 9404 and the substantially similar incident stuff, which I grant you is usually railroad tracks or things, but it would appear to be fall within that.
These are two people?
Two people.
And when do these events and where do these events occur?
When do they occur?
Yeah.
Well, actually, the Kushners happened within a year of the Kowalskis, and the other one about a year and a half or 2 years before. But I couldn't give you an exact date for the other one. I don't know it. I know the Kushner case because they're on the other side of it, and there's litigation in it.
I don't know the details of that, Your Honor, but the language in 404.2 on this is that you can get in symbol or fact evidence of crimes, wrongs, or acts that are admissible when relevant to prove a material fact in issue, including but not limited to proof of motive. I don't see motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. But it's inadmissible when the evidence is solely to prove bad character or propensity. And this smells like propensity evidence that we've done this before so we can do it again.
Well, my question, because I had to pull up the statute to Mr. Anderson,
I see Mountain Dew.
It has to be an element in the case.
Right. It's got to be not just a side issue, but a big issue in the case.
Yeah, and so I'm struggling. I mean, it doesn't fit your medical malpractice.
Apparent agency. It all goes to the agency argument, Judge, which is a key issue in the
But
case.
here's, I was thinking about this the other day because I had a chance to read this yesterday. How is it that, let's say this is true that it's been doing lots of other families, but how does that impact what the Kowalskis understood?
Right.
Dr. Sally Smith's role was? Because it doesn't go to what the Kowalskis understood. It's really what the Kowalskis understood.
Right.
So I don't think it goes there.
I think that's two different points. As the Kowalskis understood, it goes on the detrimental reliance and how much they told Sally Smith and what actions they took based on their belief that she worked for Johns Hopkins Hospital. So I don't think the fact of identification and the plan that we argue was in place, which the defendant acceded to, was that Sally Smith would come in unannounced, and it didn't really matter, Judge, after that, what the circumstances were. It was simply that this was an ongoing pattern and plan of conduct in order to extract
But if you're talking about a parent agency, it's got to be focused on the Kowalskis and their understanding, and what experiences other people had is absolutely not relevant to what the Kowalskis understood, which is why it doesn't come in under medical malpractice. And I'm not sure it comes in, what happens to other people under any of your other counts. So that's why I'm struggling to see how this comes in.
I think under the intentional infliction of emotional distress count, obviously Sally Smith is part of that. But I'm not going to I didn't plan to ask them, were you traumatized by Sally Smith misrepresenting? They were, but I hadn't planned to ask them about that. I guess I could ask them about whether discovering the misrepresentation, the subsequent prosecution, was harmful to them, and that would place it as a similar incident.
Unless you can come up with something really strong, I'm going to end up denying your motion because I don't think it fits under 90.404 paren 2 paren A.
Because we're traveling under a parent agency is the thing, and that's...
And it does not go what experiences other families, and I'm not saying it didn't happen, it's just what happened to other families isn't within the knowledge base of the Kowalskis, and it's really the knowledge base of the Kowalskis that matters for purposes of your parent agency.
I thought... I'll have to check that. I thought we were in on other... Let me check the plea.
So, unless something massive changes, expect that motion to be denied.
And just to buttress the record on that, there is a case called Trees By and Through Trees versus Kmart Corporation at 467 Southern 2nd,
Bingo,
401. It's a 4th District case from 1985. And it was reversing a civil case because something in this nature was done. And explaining this was a propensity and pattern of conduct were the same thing, and that's just a pattern of conduct, which is what I think they were just trying to explain. Thank you.
Thank you very much. Anything else?
No, but I just to quadruple check because I'm here. I'm so sorry. I was up very late last night and very early preparing for Dr. Hanna again because I'm hearing whispers of different people coming. The only people the Kowalskis are bringing tomorrow again are the DCF coordinator, the 3 Kowalskis on damages only, and the 2 depot designations. Correct?
Ahead of time, we have sent over the list, including Deborah Salisbury.
And we're evaluating whether her testimony is necessary at this point or she would be a rebuttal witness. But we will let you know one way or the other after I have a chance to speak with her after we get out of here.
I guess the frustration with this, and I know it's very late in the day, is unless the plaintiff wants us to be doing this to them, in our case, throwing 7, 8, 9 witnesses that they know they have no chance of us getting through, it's very frustrating to hear that we now have a lineup of 7 to 8 witnesses that are going to span 9 to 10 hours that we know we're not getting through.
It's been a constant pattern throughout the career.
Well,
but anyway.
It sounds like Miss Salisbury is probably going to ultimately require some sort of proffer before,
Right.
And so I wonder if, from a timing perspective, is that something that is even doable tomorrow, given everyone else?
I think what I'm trying to evaluate is the scope of what she can say and not get into the wrong area. And I can't assure the court of the breadth, or counsel the breadth of that until I talk to her one more time.
Well, what it sounds like is she should not be a witness tomorrow, perhaps on Friday, but not tomorrow. Is what I'm hearing, just from a timing perspective.
That's fine with us.
Because that means someone gets to go to bed at midnight as opposed to 2 a.m.
Mr. Shapiro's halfway to the door.
We'll move her till Friday if we do decide to use her.
All right, thank you.
That's all you're
Thank you. Have a good night.
There we go. Okay. All right. So we're Mr. Shapiro's drinking Diet Mountain Dew, I believe. That's he had 2 bottles, both empty. So he's been up late trying to stay awake. All right. That was a little spicy end to this. We did manage to get up to 100. That's 1 with 2 zeros. 100 objections today. We're 865 now is our total right here on the desk. My finger is okay. I'm probably going to ice it tonight in anticipation for tomorrow, which is probably going to be spicy as well. Let's see. Anything we need to go over before we finish? Let's see. The all we had here was with Dr. Joseph Cochran. Once he got through his intro, once he got done with all his background and experience and his wife's restaurant chains and their addresses and what meals they sold and when their grand openings were and plugging his friend's boat company, once he got through all that bit, and all the political name dropping, it was actually pretty good. He did really well. He did excellent on cross for someone who's never testified before as an expert witness. I think he did excellent. It was some pretty good testimony. Very good for the plaintiff. Even though Mr. Hunter was quite agitated and tried to, I think, trick him. Literally, I think it was not accidental that he said, "Hey, did you review this doctor's depot?" When that doctor didn't exist, he got the name wrong. He's like, "Oh, it's good because they didn't exist." What I meant to ask was, no, I think he meant to ask that question. Tried to trap the doctor. Anyway, what we got, let's see, the end of the day, the time clock, if you want to go over that again, 3 hours and 20 minutes charged to the plaintiff today for a total of 36 hours and 10 minutes out of their 50-hour total allotment. That's direct and on cross. Defense had another 40 minutes charged to them today, so altogether 4 hours of time was charged to one side or another, even though we've been here for 8-9 hours. And their total is now 12 hours and 50 minutes. So we're expecting that with Thursday, Friday, and then a little bit on Monday, then the plaintiff is going to rest at that point. Then we'll switch to the defense case. So that'll be a lot of fun. Wednesday, up in the air a little bit. They said Wednesday no jury, and there was a little bit of a discussion about having the lawyers, particularly Mr. Delegate and Mr. Altenburn, on Zoom. The bad part about that is if they're not in the courtroom, The judge ruling is that we cannot broadcast the Zoom feed. We can view it as members of the media, but we can't broadcast it. So unless you want me to do play-by-play voice only of that little argument, I'm not sure how we can do that. So we'll wait and we'll play that by ear to see how that goes. Let's see. So tomorrow they've got a DFC coordinator. The Kalowski's are going to be on for damages only, talking about the damages they've sustained. And then some other people. We don't know. They'll probably pull a little stunt like they did this morning to some degree. Anything else that we need to talk about before we wrap up here today? A lot of things happened. Yes, we're all going to be in Rob's chat tonight. Can't wait to hear, because it starts off with a bang this morning with the judge being angry and everything else. It's wonderful. Make some sock puppets and you can narrate for us, says People for Real. I'll need like 3 hands because I need a defense, I need the judge, and I need I guess I could like wear like a balaclava or something. A balaclava, so I would be the judge and then these guys would be I'd have to like, yeah. I'm thinking out how to do this in my head. I could like throw my voice for these ones, like not move my mouth, the whole ventriloquism thing with the sock puppets, and then the balaclava would be the judge. I'm not sure I've got that many skills in that area, you guys. Great idea, People for Real, but I think I would fail in that one. Who is Rob, says Amanda H. Rob is on Law and Lumber. Rob is Law and Lumber. He's a full-time lawyer and part-time woodworker, and he has a YouTube channel as well where he's following this case, and every evening, I think it's like 7 or 8. Is it 7 tonight, Maisla? He reviews this case. He reviews it. He plays it a little high speed, and he takes excerpts, so he's not listening to the whole thing. But 8 p.m. Eastern. Thank you, Valerie, for that. 8 p.m. Eastern for Rob. Does a great job. His analysis is spot on this case. I've only disagreed with a couple things, and one of them being the timing. I think that time is going to be a major factor on this case, and I think it's becoming more so. But very, very smart guy. Very smart guy. And a lot of fun to listen to. It's very entertaining. And a wonderful community as well. If you go in over there, his community is fantastic. Let's see. Fell asleep to him last night. It's pretty good, says Nicole. We need Brandy to make a timeline chart for this case. Several of the charts we've seen could use a Churchwell makeover for sure. Ooh, Vicky White, update from Brandy's channel. Boeing box has been handed to the jury. Deliberations begin at 8:30 tomorrow morning. So she's on verdict watch tomorrow. That's going to be exciting. Total time, Christina Bell, they get 50 hours is our understanding. 50. Angie Carter says, this is my trial is my first trial. I'm joining the RA family. I just love it here all the way around. Angie, thank you so much. Appreciate that. Good to have you here. All right. I think, yes, let's go. We don't need sleep. Yeah. We do need a little bit of sleep. I need some. It's a long day. We didn't really get a break today. Just had a quick lunch, and that was it. 80s Music Man, I see you there. Can't hide from me. Welcome. Good to have you here. All right, so now we're going to play the music. Yeah, and don't plug RA on his channel when he's there. Thanks, Parrot Court. I appreciate it. I think it's just polite when I'm visiting other channels, which I love to do because there's LawTube in general is amazing. Whether you're in it just for the humor and you're on Law Talk with Mike, or you're watching The Lawyer You Know, or you're watching Law and Lumber, or any of the many great lawyers that are out on YouTube that provide analysis for us. I feel I don't want you to like advertise my channel on their channels. We're a little bit different, but them being lawyers, and I'm just a nut when it comes to true crime. I love that sort of stuff. So that's all. I'm just self-conscious is all. So thanks, I appreciate it. But I can't wait to see you tonight. It'll be a lot of fun. Tonight, speaking of that, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. It will be, let's see, check the clock. Let's see, court starts at 8:45, so we'll go live at 8:30. We'll sing happy birthday to all the applicable people who need it sung tomorrow. If you need your birthday song sung, make sure you're there early. Click the subscribe button, ring the bell. If you want to be first in chat, you could win the internet. That's also an option. That would be a lot of fun, so go ahead and do that. And other than that, we'll just call it a night, shall we? Yeah, we'll see everybody over in Law and Lumber. It should be a great night. Thanks, guys. Be good to each other. We'll see you tomorrow. Bye.
scratch all that. Oh, that was terrible. I apologize.